ಅವಂಗೆ ಹೇಳಿ ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ರವಿ ಫೋನ್ ಮಾಡ್ತೀರಲ್ಲ ಉಮಾಶಂಕರ್ ಹೋಗಿ ಆಚೆ ಹೇಳ್ಬಿಟ್ಟು ಬನ್ನಿ ನಮೋಸು 150 ಮೇಲೆ ಈಗ ಬಂದು ಅದೇನೆ ಇವಾಗ ಉಮಾಶಂಕರ್ ಬಂದಿರ್ಬೇಕು ಹೇಳ್ಬಿಡಿ ಅಷ್ಟೇ ಯಾರನ್ನೂ ತೋರಿಸಿಲ್ಲ ನೀವು ನಮ್ಮ ಕೋರ್ಟ್ಗೆ ಇಲ್ಲ ಕಾಂಟೆಸ್ಟ್ ಜಾಸ್ತಿ ಲಿಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಇವತ್ತು
Yes, I know, sir. They told me, sir.
ಯಾವಾಗ ಆಗಿತ್ತು ಲಾಸ್ಟ್
ಇಲ್ಲ ಸರ್
ಮುಂದೆ ಆಗಿದೆಯಾ
ಅಲ್ಲೇ ಕೋರ್ಟಲ್ಲೇ ನೀವು ಇದು ಮಾಡಿ ಅಪ್ಲೈ ಮಾಡ್ಕೊಂಡು ನಾನು ಹೈಕೋರ್ಟಲ್ಲಿ ಒಂದು ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಿಕೊಂಡು ಐ ಗೋ ಓವರ್ ದಿಸ್
10-7 ಲಿಸ್ಟ್ ಆಗಿದೆಯಂತಲ್ಲ
ತಗೊಂಡಿದ್ದೀನಿ ನಾನು ಹಾಕ್ಕೊಡ್ತೀನಿ ಐ ವಿಲ್ ಅಪ್ಲೈ 2 ಸೆಟ್ಸ್
ಮೇಡಮ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಸ್ ಕೋಡ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್
ಅದು ಅರ್ಜೆಂಟ್ ಆದ್ರೆ ಒಂದ್ಸರಿ ಹಂಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ ಹೇಳಿ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ ಹೇಳಿ KLR ನಮಗ್ ಬರಲ್ಲ ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ KEB ನೀವ್ ಹೇಳ್ತೀರಾ ಅಷ್ಟೇ
ಮಂಡೇ ಇತ್ತು ಮೇಡಮ್ ಸಿಟಿಗೆ ಮಂಡೇಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಮತ್ತೆ ಮಂಡೇಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಈ ಮಂಡೇಗೆ ಲಾಸ್ಟ್ ಮಂಡೇಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ ಅಲ್ಲ ಇದೇ ಕೋರ್ಟಲ್ಲೇ 2015 ಮ್ಯಾಟ್ರ್ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅದು ಲಿಸ್ಟ್ ಆದ್ರೆ ರಿಪೋರ್ಟ್ ಮಾಡಿ ವಿತ್ಡ್ರಾ ಮಾಡ್ತೀವಿ ಮ್ಯಾಟ್ರ್ ಅದು ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅದೆಲ್ಲ
ಸೆಟಲ್ಡ್ ಫಾರ್ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಬರೀರಿ ಕೆಳಗಡೆ ಏನಾಗಿದೆ ಸರ್ ಪೇಜ್ ಮೇಲೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೊಟ್ಟಾಗ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಕಳಿಸಿದೀವಿ ಮೆಮೊ ಹೋಗಿ ಹೇಳಿದ್ರಿ ಅಲ್ಲಿ ಫೈಲ್ ಸ್ಟೇಟಸ್ ಏನಿದೆ ಅಂತ ನೋಡ್ಬೇಕಲ್ವಾ ನೀವು ಬ್ರಾಂಚ್ ಅಪ್ರೋಚ್ ಮಾಡಿದ್ದೀರಾ ಮತ್ತೆ ಅಲ್ಲ ಇವ್ರೆ ನೀವು ಮೆಮೊ ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಕೂತ್ಕೊಂಡ್ರೆ ನಮ್ಮ ಸ್ಟೇಜ್ ಆಫ್ ಯುವರ್ ಕೇಸ್ you have to check there what happens to your memo ಅಂತ ನೀವು ಚೆಕ್ ಮಾಡಬೇಕು ಇನ್ನೊಂದು ಯಾಕೆ ಮೂವ್ ಮಾಡ್ತೀರಾ ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿರೋವಾಗ ನೀವು ಹೋಗಿ ಅಲ್ಲಿ ಸ್ಟೇಜ್ ಚೆಕ್ ಮಾಡಿ ವಾಟ್ ಈಸ್ ದಿ ಸ್ಟೇಜ್ ಆಫ್ ಯುವರ್ ಕೇಸ್ ಅಂತ ಅದು ಡಿಗ್ರಿಗೆ ಹೋಗಿರುತ್ತೆ ಎಲ್ಲೋ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಅನ್ಸುತ್ತೆ ಮೋಸ್ಟ್ಲಿ 24th ಅಂದ್ರೆ ಹೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ ನೋಡಿ ನಮ್ಮಲ್ಲಿ ಔಟ್ ಆಫ್ ನಮ್ಮಂತ ಸ್ಕ್ಯಾನ್ ಆಗಿದೆಯಾ ಅದು ಕಾಪಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಸ್ಕ್ಯಾನ್ ಆಗಿ ಬಂದಿದ್ಯಾ ಎಂಟ್ರಿ ಮಾಡಿದ್ರು
ಕೆಳಗಡೆ ಬಿತ್ತು ನೋಡಿ
ಸಬ್ಸ್ಟೆನ್ಷನ್ ನೀವೇ ಮಾಡಿದ್ರಾ ಕೋರ್ಟಲ್ಲಿ ಮೇಡಮ್ ಮಾಡಿದ್ರಾ ಹೌದಾ ಅದೇ ಹೇಳಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಲಾಜಿಕ್ ಆಸ್ ಮೆನ್ಷನ್ ರಾಂಗ್ಲಿ ಡೇಟ್ ಗಿವನ್ ಮಾಡಿದ್ರು ಯಾವ ಡೇಟ್ ಯಾವಾಗ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಅದೇ ಸರ್ ಮೆಮೋನಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಕೋರ್ಟ್ ಡೇಟ್ ಅಂದ್ರೆ ಏನ್ ನಂಬರು ಧಾರವಾಡ ಜಿಲ್ಲೆ ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ ಆಯ್ತು ಒಂದು ಆಗಿತ್ತೇನೋ ಗೊತ್ತಿಲ್ಲ ಸರ್, ಅವಾಗ ನಾವೇನು ಮಾಡಕ್ಕಲ್ಲ. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತ ಹೋಗಿರುತ್ತೆ, ಅದಕ್ಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರಲ್ಲ. ಹೇಳಿ 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 ಹೇಳಿ, ಅದು ಏನೇನ್ ಹೇಳ್ಬೇಕೆಲ್ಲ ಹೇಳಿ. ಹೇಳಿ ಸರ್. Court of Small Causes Courts Act.
Mine is also not listed today. Okay.
All of them have collided.
ಜಾಸ್ತಿ ಏನಪ್ಪ
अभी भेजता हूँ, ठीक है, जरा वो not increase आपका. Lord one submission.
On Saturday, connect for the auction sale.
Huh?
On Saturday, connected for the auction sale. This matter was listed on last Thursday, and the other side appeared and they requested this court that their senior counsel is not in station. They took the time and my lords gave the date on Monday.
Tomorrow.
My lord,
No, 2:30. Tomorrow I'll take.
my lord, 20 days delay, my lord, with regard to filing up WS, my lord. Due to that cause only, my lord, the honorable
All that I don't want. What is that you're mentioning now?
tomorrow, my lord. Finally, an argument is posted on day after tomorrow, my
You
lord.
filed the writ petition.
File, my lord.
When was the writ petition filed?
Two days before, my lord. 2 days
If it is
before.
numbered, it will come tomorrow.
No, my
If
lord.
office objections are complied, it will come.
My lord, tomorrow, my lord.
That's what I'm saying. If office objections are complied, it will come. Don't give the fresh matters. I have given standard instructions. Yes.
Kindly. On 4/6/2006, this honorable court stayed an ex parte injunction order passed by the trial court, basing on a Supreme Court judgment, and a detailed order was passed. Then the matter was listed on 16/6/2026. Other side informed me they are going to take a short adjournment in the matter. Instead of that, they have sought for adjournment till August 2026.
They have not sought. If anybody asks for adjournment, and
It
other
is
side-
written in the order. They have sought for till August. Anta.
No, they have sought adjournment. But I am granting adjournment.
What has
till
happened is
August
in that preemptory order is passed against me. My lords are noted the Supreme Court judgment is filed regarding maintainability. That was the only office objection raised. That was clarified in the court. Now your lordship has said 2 days to comply with the office objection by the petitioner. Now after 4 days the order is uploaded. My lords, I had no occasion. There is a lapse on my part to grant that other side's request for adjournment. I should not have done that. I understand.
All the advocates have to be present when the matter is.
I understand.
When they are mentioning it, because I will not be adjourning the matter as per their request.
I
When
understand.
it is adjournment, it will go beyond that.
Preemptive order. Now there is an interim order in my favor. Detailed order your lordships have passed and said that the trial court has not considered the matter in the right manner and state in the ex parte interim order. That will not be extended now. Kindly have it tomorrow, my lords. I'll explain.
Tomorrow it's not possible.
Monday.
We'll see. Take it as per the court's.
Please.
Yes.
Read.
Amendment application, my lord.
When is the writ petition? When is the writ petition filed?
Filed on 2020. Next date is
2026. We are in the 7th month. When in 2026? Huh?
22nd is the next date on trial court.
Then
8/26.
22nd of next month is
This month, my lord. 22/7, my lord. Has been posted.
You have time. Why are you mentioning now?
8/26.
We will consider it a day before, not now. Yes.
There's an eviction suit of
Mention it. If your matter is coming on 22nd, mention on 20th.
an eviction suit of 23, my lords. The respondent in this matter is a senior citizen. She is now residing abroad. She has filed the suit in hopes of coming back and staying in her own house in Bangalore. The matter was posted for judgment, my lords. In that time, in January, a stay was granted. A stay was granted with the exception that liberty was granted to seek modification of the order or to seek
No, that
vacation of stay, my lords.
whether a liberty is granted to you or not, you are entitled
Because
for
she is a senior
modification and
citizen.
vacation of the order.
She is a senior citizen. She has to come back for
We will
treatment.
see.
At
We will
January
see.
in
Please understand the court's difficulty also. All matters
my
I
lords,
can't
the stay has
vacate.
been there since January, my lords. That is the only reason. And next
There
the
are so many
matter is posted
matters,
for
the stays are pending from years together. That can't be a.
my lords, next the matter is posted for September, my lords. Until then, again, it will be a delay, my lords. Yakanda judgment stage ali, it has been.
If the matter is coming up in the month of September, before the matter is coming up
My
before
lords,
the trial court, you make a
my
mention.
lords, I may be allowed to show this court the delay that has been taken place, even in the suit, the trial court.
Give you an opportunity, I have to hear it. For hearing it, I have to give some time.
My lords, Monday
Yes,
it may
next.
be taken up, my lords.
No.
Monday.
Yes.
My lords, at the fag end of the trial, my lord, when the matter was posted for final arguments, my lord, plaintiff files an application seeking amendment.
The writ petition filed.
27/6, my lord, the writ petition is filed. The order, my lord, is on 26/6. My lord, the matter is posted today, my lord, for final arguments, my lord, of the plaintiff. My
Improved order is on 27/6.
26/6, my lord. The petition is filed on 27/6. Or the matter is posted day to day, my lord. My right to file, my lord, the additional written statement is forfeited. My right to lead.
And the
27/6, my lord, the petition is filed.
it has not come up.
No, my lords.
Why?
Yesterday also we have mentioned, my lord. I have complied with the office objections as well, my
Find
lords.
out. When the
My
office
lords had
objections
directed
are-
it to be listed today, my lord.
Why the matters are not listed? If there is any reason, call the, inform the registrar judicial. We can't take up every day this kind of, yes.
My lord, the matter is set for argument before the trial court on 7th, my lord.
When did you file the writ petition?
My lord, the CRP was filed in the year 2025, my lord's notice was issued. My lord,
And you are happy from 2025 till 2026?
my lords, what has happened was some of the respondents died. We had to bring their LRs on record. Now, my lords,
To wait for some more time, no issue.
lords, on 7th of matter is listed for final
Let it be,
argument.
let
My
it
lords,
be
on Monday, my lords, may
Let it be
request.
listed. Yes.
My lords, this matter as mentioned yesterday also for correction, my lords, were gracious enough to take it today at
Why?
top of the list for to be spoken.
Give it.
I request for 2:30, please, my lords.
No urgency for 2:30.
My lords, because the petitioner undertook not to sell flats, that also is not forthcoming in the order. I've informed the petitioner.
What will happen if the order, if it comes tomorrow, what will happen?
Please, my lords,
Yes,
tomorrow.
at least tomorrow.
In list one,
And
please, my lords.
it's there are live videos of this, so nobody can deny that.
Please,
So
ma'am.
don't be worried about it. Yes,
May I please request for list one, please, ma'am.
yes.
On 24th June, this court has granted a stay of further proceedings in an injunction order against interstate matters. I have placed that order before the trial court. Trial court has still extended that temporary injunction. It can be taken up today.
Take up that one.
List number 2.
2:30.
2:30.
List number 2, my
serial number
lord.
45, my lords.
List number 2, serial number 38.
Page wise mentioning, court officer will call. Only out of the list mentions, please make a mention.
Your lordship.
Out of that.
Almost submission ಇಲ್ಲ.
Thank you.
I am telling everyone, I do not want to hear on the merits of the matter. I am asking a simple question. When is the writ petition filed? It will come. It will come. If you have complied with the office objections, it will come. I have instructed the court officer and the registry also. Yes, don't give the memos for that. Yes.
My lord, in a partition suit, the data filed a partition suit,
Writ petition which year?
2026.
When was it filed?
25. 25.
20?
25/6. This one? 25/6.
25/6. Was it listed?
Not yet.
Have you complied with the office objections?
One day this one. I will carry.
If it is not, it will not come. Yes.
My lords, this is a 2026 writ petition, my lords.
Which month? When did you file?
Today, my lords. My lords, the urgency is, last week an order on IA was passed in this case, my lords. The Honorable Trial Court has passed a perverse order forcing me to purchase the shoot schedule property, or it will evict me and sell my shoot schedule property to the respondents.
When was the order passed?
Last week, my lords.
And the court
Tomorrow it is going to execute this order is what it said, my lords. We have taken an undertaking before trial in Mysore that we are filing a writ before the Honorable High Court. The learned
The
trial
court
judge
mentioned
has-
that tomorrow it's going to
My lords, I
give
produced
effect to the order.
I produced the order. In this, it is showcased that I have undertaken to file a writ petition before the High Court, but the learned trial has said that is of no consequence. He will still go ahead with passing orders on enforcing INO.
When was the improved order passed?
Last week, my lords.
And when was the order copy ready?
Order copy, we got it 5 days ago, my lords.
And the court will execute it tomorrow.
Yes, my lords. That is what this order sheet reflects, my lords.
2:30. Yes.
Your lordship, a humble submission.
This matter was listed day before yesterday on 30th. Both the parties, petitioner as well as the respondents, are willing to settle the matter. If Lordship may be pleased to refer the matter to the Lok Adalat, I've got the consent from the as well as from the petitioner
Tomorrow.
council. Please, Your Lordship.
Yes, call the list.
My lords, in list number two.
List
List number 245, my lord, there is
Page-wise
urgency.
adjournment,
My lord,
page-wise adjournment, page list number.
Memo for posting, my lords, fresh matter. Suit for father.
Why should the fresh matter memo for posting?
My lords.
Please tell all the advocates that I will not accept any memos for fresh matters. There are instructions to the registry, and let's none of them waste the court's time. Call the list.
Page list number 1, page-wise adjournment, page 1, serial number 1 and 2, serial number, page number 2, serial number 3 to 5.
Serial number 4, my lords. Seek for a short adjournment in this matter.
No. If you want a short is in this court only in September.
Serial number 4, my lord.
Yes, September. This is matter in the month of September at the request of learned counsel for the petitioner. Yes.
Page 3, serial number 16 to 29, page 4, 30 to 36, page 5, 37 to 44, page 8, number 45 to 48, page number 7, 49 to 52, page 10. Page number.
Who are you?
49. Yes. ಆವಾಗ ಹೇಳಿದ್ರಲ್ಲ 49. ಕನ್ನಡ ಮೇಡಮ್ ಅದು ನಮ್ಗೆ ಇಂಗ್ಲಿಷ್ ಬರಲ್ಲ ಅದು. ಹೈಕೋರ್ಟ್ ಅದ ಮೋಸ ಮಾಡ್ಬಿಟ್ಟವ್ರೆ. ಹೈಕೋರ್ಟ್ ಅದ.
Next.
Page number 8, cell number 53 to 58.
55, my lordship. Next week, my lordship. 55. Next week.
This matter. Notice to R3 returned as refused. Amounts redeemed service of notice at the request of learned counsel for the petitioner. List this matter in the month of September.
Page number 9, cell number 59 to 62.
My lord, serial number 60, my lords.
Serial number?
60, my lords. Adjournment.
Why are you seeking adjournment like this?
My lord, senior is not available, but it's for orders for respondent number 1 to come on service, my lords. And we are awaiting the service of respondent number 1, my lords.
List after service and respondent 1.
Page number 10,
Grateful, my lords.
cell number 63 to 69.
Take that. Memo is filed stating that the writ petition may be dismissed as withdrawn. Dismissed as not pressed. Accordingly, memo is taken on record. Dismissed as not pressed. Yes.
Page number 11, cell number 70 to 75.
My lord, serial number 70, there's an urgency, so it may be taken up.
What is urgency?
The urgency is that there's an interim order. I filed a section 9 petition against, and I was granted an order. They have filed a writ petition and they have got an ex parte interim order. I have already filed an application for vacation of stay. On the last date, it did not reach, and it was being given date-wise. So if there's an urgency, I was told to mention in the morning so that it could be.
Because all vacate petitions, there are so many pending that can't be the urgency. Whenever now today it is 70, tomorrow it will come little further. Whenever it comes, you please wait. Yes.
Serial number 66. The serial number 66, the urgency is, my lords, the petitioners for High Court employees, their salaries have been attached.
It will reach, 66 will reach, yes.
Page number 12, cell number 76 to 81.
Malad may I mention 80, Malad. 80, the matter ought to have been listed either in the orders or, Malad, at best here vacating of the interim order. It's been listed for B group. An ex parte interim order, Malad, of an arbitration award. Malad, we had filed execution petition and.
That's in list 1.
No,
is in list 1. Wait.
There's grave urgency in this matter, Malad.
We will see, it will reach. Yes.
Page number 13, cell number 82 to 85. List number 2, Page 1, serial number 1 to 5.
My lord, listed to serial number 5, my lord. I seek short accommodation, my lord. Kindly have it on Monday, my lord. I appear for petitioner in this matter, my lord. Kindly have it on Monday, my lord.
Monday, the
Much
request on petitioner. Yes.
Page number
My lord,
2.
serial number 3, my lords. List to serial number 3, my lords. It's been posted for judgments today, my lords. Yesterday it had come in list 2, serial number 1, my lords. My lords had actually instructed to put it in list 1. It may be taken up today in the first.
And the matter is coming up?
Today it's posted for judgments, my lords.
Yes. 233.
Page number 2, serial number 6 to 8. Page number 6.
Yeah, Your Worship, I am appearing for the petition in that case, my lord. Serial number 6.
Let her say what she wants. Yes. Yes.
Already 1 month is over, my lord, copy served. Three times listed before this court. Still the matter is in fresh matters only. And the matter is posted in second list. We have some urgency. The file code is.
Yes, next.
Serial number 7, my lord. Serial number 8, my lord. Serial number 8, my lord. It is for steps, my lord. Take 1 week time may be granted, my lord. Serial number 8, my lord. 1 week time may be granted, my lord, for steps.
You have an interim order?
Yes, my lord.
No.
My
We
lord,
will,
serial number
wherever
7.
interim order is there, we will wait.
My lord, serial number 7, my lord.
Yes.
My lord, my lords has directed us to serve the copy to the trial court advocate and give the date today, my
Why
lord.
the parties are coming to the court? No, that's not the problem. Tell somebody. No.
Madam, handicraft, madam.
Call the police. Call the police. Yes, next.
My lord,
Page number,
serial
page
number 7,
3.
my lord.
Yes.
My lord, serial number 7. My lords are directed us to serve the copy to the trial court advocate and put the, my lord, call today, my lord. There is an urgency for consideration of interim prayer, my lord. Consideration of interim prayer, my lords.
CRP of 2025, no urgency for interim order.
Last date of hearing, my lords was heard at great length, my lord. And
We will
thereafter,
see,
my
we
lord.
will see. I will not take up this matter out of turn, yes.
Serial number 9 to 11. Page number 4, serial number 12 to 14.
My lord, serial number 12, my lords. There's an urgency in this matter, my lords. The matter be heard today itself, my lords.
What is urgency?
My lords, tomorrow there's a date matter in trial court, my lords. They'll dismiss the case for evaluation of the appeal, my lords. Just because on valuation of appeal,
You file this writ petition.
my lords, my humble submission. There are 3-4 connected matters, my lords, which has been filed on
You have
7.
to answer to what the court's query is. When did you file the writ petition?
On 12/6, my lord.
Huh?
16/2, my lord, sorry.
Why you are not?
16/2/26, my lord.
Notice is ordered. You don't even furnish the PF for the first time.
1 second, my lords. There is contesting parties only for 4 members, my lords. 4 members are only contesting parties, my lords.
Then
For
who
that
will tell
time, filed. 1 second.
Sorry, call the
My
next.
lords, my humble submission
Yes,
is.
next.
Page number 5, serial number 15 to 18.
My lord, serial number 16, my lord. Urgency, my lord, because since many dates it is been listed, but it is not been reached, my lord.
That is not the urgency.
Together with that, my lord, the issue is related to the bore, my lord, one of the bore in Tumkur district, my lord. There, what has happened is, my lord,
Please understand, this is nothing but
No.
all of you will be at loss by making all these mentions. Because I will
Please,
not be
my lord,
considering
the
it.
urgency is,
I
my
made
lord.
it very clear that vacate petition is not the urgency. Only urgency before this court is the matter coming up before the trial court. Other than that, I will not take up any urgent matters because all matters are urgent for every party because there are stays.
The issue is, my lord, because Lok Adalat is going to happen, my lord. The judicial officer is in dilemma to whom to call that to conduct all these things, my lord. The president, for the reason, my lord, because 11th it is going to happen.
That is not such a big issue.
No, my lord.
Heavens are not going to fall. If the bar association,
lord,
who has
they
to
are
call the
conduct-
president, nothing will happen.
No,
They are
my lord,
not so
for
important.
and together with that, my lord, the urgency is that other all activities are doing all these
No
things.
urgency for that.
That also, since many dates it is listed, my lord, but it is
It will
not
be
been.
listed because
Kindly, my
what
lord.
can the court do? Court can only do what the court to the
My lord,
capacity of the
kindly
court.
may taken up tomorrow top of the list, my lord.
Oh,
That
I
also.
will not take.
Page
Yes,
6,
next.
serial number 19, 20, page 7, 21 to 24.
The serial number 21, please, my lords. The matter is coming up before the executing court today.
My lords, I appear for the respondent.
It's a
in this matter.
2025 matter, even if it is coming up before the executing court today, I will not take up
My lords, my
next.
difficulty is that, my lords, the petitioner obtained the interim order
Let
before
it,
this
let
honorable
him,
court
let
and they
him.
have sold the schedule
2025
property.
matter, there is no urgency.
My lords, they have sold the schedule property, please, my lords.
Let them to sell.
My lord, serial number 36, lordship.
22, my lords.
Yes.
Serial number 30.
For 22, my lords, the Honorable Supreme Court has granted the injunction order. Despite that, my lord, this pending writ petition, my lord, they are just coming and dispossessing me, my lord. There is certain urgency. Though there is a Supreme Court order, my lord, which confirms the order of this.
Come in the
Honorable
first list tomorrow. Yes.
My lord, serial number 36,
Take
lordship. Sir. 36, 36.
We'll call the page number.
Yes, I'm sorry.
Page number 8.
Serial number 22 may be taken up.
Huh?
Serial number 22, the matter just may be taken up.
Why?
Tomorrow.
There is some internal sparking council tomorrow.
Yes, madam.
Where is she?
Madam.
There. List.
They want it on Monday.
Serial number 22.
They are asking for.
My lord, there is urgency, my lord. They bring all the cars and everything into
Yes,
the
tomorrow.
property, my lord.
Page number 8. Cell number 25 to 30.
27, Swami. The trial court case is set for Monday, Swami. 27. That's it.
Tomorrow in the first list.
In first list.
Yes.
Page number 9. Cell number 31 to 34.
My lord, 34, my lord. Kindly short accommodation, my lord. Next week. 34, my lord. Serial number. Next week, any date, my lord.
Have you informed the other side?
Yes, my lord.
Does this matter in the month of August?
Please.
Page number.
At the request of Land Counsel for the petitioner, yes.
Page number 10. Cell number 35 to 40.
Serial number 36, lordship.
Kindly, my lord, serial number 30. May I request for early hearing, my lord? Matter is pending since 1999, my lord.
Which case? 30?
38. 30. Serial number 38, my lord.
My
lord may take it at least at the end of list.
Why?
The urgency is that, my lord, he is not the respondents who are the tenants. They are not even paid 1 rupee rent. Despite, my lords, there are directions from the trial court, my
Oh,
lord.
I'm sorry, I can't.
And I have been thrown out, my lord.
I can't take up like that. Yes, next.
Serial number 36.
Take chance at least.
Let it be there in the list, no chance. Yes.
Serial number 36, lordship. My lord, last date of hearing, lordship. Interim order not extended, lordship. Because 19th of this month, lordship. So before that, 18th listed, that time appeared and
End of the list you mentioned, then the court officer will look into that.
Please,
At this point of time, we can't
please,
do
madam.
anything.
Please, madam.
Let's see. Yes.
Page number 11. Cell number 41 to 47, 46.
My lords, 45, still number 45, my lords. My lords, there's urgency in this matter, my lords. Respondent authorities are erecting electric tower, my lords, and they even dig a pit. The matter has been listed 2 times, my lord, before the court, but it didn't reach. And they didn't even follow the due process of law, my lord. It will be heard to them. They didn't even.
Anyhow, you cannot stop them from erecting the towers. What you can seek is, you can seek compensation.
My lord, it may be considered an obstruction application, my lord. Obstruction application. They didn't even following the due process of law, my lord. It may be heard today, my lord, by 2:30.
This matter in the first list tomorrow.
My lord, serial number 46, my lord. Your lordship could recollect last week, my lord, this matter was listed. Your lordship had directed me to take out notice on the council appearing before. Now, my lord, they have filed wakalat, my lord. The urgency is, my lord, they have filed an application seeking police protection, my lord, to dispossess me, my lord, in the guise of interim temporary injunction.
So all are of that nature only. All the
No,
restrictions are of that nature.
there is a temporary injunction operating against me. Now they have filed a application seeking police protection.
You have not questioned that order.
Which no,
The
no,
temporary
that is set down for argument.
Temporary injunction is against.
No,
you.
that is before your lordship. That is the writ petition.
Then where is that order? That police protection.
No, that is set down for argument.
So you are anticipating that court will pass an order.
My lord, I have challenged.
If the court passes an order, no, 230.
My lord, humble request, my lord. There, my lord, the court, my lord, is not granting, is not accommodating, my lord.
Let us know. Let the court pass orders. The moment
My-
order is passed, they will not want it.
Then, my lord,
Then I will hear.
no, again I have to challenge that order, my lord.
That you any challenge this or
My lord,
once this order goes.
humble request, my lord. Your lordship had specifically granted date, my lord, and I was also permitted to take out notice to the council, my lord.
Please look at the.
2:30, my lord. Humble request.
There are already enough matters.
Humble request, my lord.
No. Yes,
My lord.
call the
Lordships, may I make one mention? Sorry for interruption.
My lord.
Serial number 28 in list number 2. Your Lordships had posted it yesterday on 30th for in list number 1. As your Lordships was not sitting today, it is come in list number 2. Matter is set down before the trial court today. May I request in list number 1 tomorrow? I am requesting your Lordships. It could be posted in list number 1. Your Lordships, sir. Serial number 28, CRP, your Lordships. Your Lordships heard it and posted it on 36, and it was requested to be listed in list number 1. Tomorrow in list number 1, your
My lord, at least Monday, my lord, for in the first list, my lord. My lord, Monday, my lord, 46, my lord.
We'll see.
46, my lord.
We will see. Yes, call the list.
My lords, one small submission, my lords. My lords, in list 2 serial
Once
number
I've
12.
rejected, please don't
My lords,
waste
my
the
humble
court's time.
submission is I have filed a
You are not
dispensation that has
answering the
not been
court's-
considered,
When
my
you are
lords.
not answering the court's query, court
My lords,
has no
that I'll make
obligation
my
to-
submission, my lords. That the only thing is I have filed for dispensation for notice, my lords. That has not been considered, my lords. My humble request is at least notice will be issued for respondents, my lords.
The matter will reach, then we will see. Yes, call the
Please, my
list.
lords.
Serial number 42, your lordship, may be taken up next week. I filed Vakalat last week, your lordship.
Attached to Dharwad bench, serial number 1, Deepak Kulkarni.
My lady, I appear for the petitioner. There is a small typographical error in mentioning of the place of arbitration in para 12 of the judgment.
Para?
12 of the judgment.
Yes.
The seat of arbitration in line number 3 and 4 of para 12, my lady. That is page number 10 of the judgment.
Court officer, what is happening? I said, ask them to go out of the court. If not, call the police. Which paragraph?
Para number 12, page number 10.
Yes, in the light of the respective contentions.
Of both the parties and the fact that both the parties, as per the arbitration clause, want to engage an arbitrator, and the seat of arbitration at Dharwad. It is actually Belgaum city. The arbitration clause is reproduced by the Honorable Court in the para prior. That is what is quoted there in para 3.
It is supposed to be Belgaum.
Belgaum. That is the only correction.
Yes. Where is the other side?
Yes, Millers. I represent the respondent. Even we have filed the memo.
So it's Belgaum.
Yes, Millers. It's Belgaum.
Please come. This court has disposed of the writ petition on 25th February 2026, wherein at paragraph number 12 of the order, this court has recorded that as per the agreement, the seat of arbitration is at Belgaum, at Dharwad. This petition is moved to the court stating that instead of mentioning Belgaum, it is mentioned at Dharwad, and have come before the court seeking clarification of the same. Land counsel for the respondent also does not deny submits that instead of Belgaum, it is mentioned as Dharwad accordingly. At paragraph number 12 at line number 4, that shall be corrected as Belgaum instead of Dharwad, and the corrected copy shall be uploaded. Yes.
Much obliged.
Much obliged.
Serial number 2, HN Sarigaud.
Yes.
Appear for the petitioner, Milord.
Yes.
Milord, the application does not serve for consideration, Milord.
What is this IA?
Milord, I have filed for extension of time for Milord paying the amount. After disposal of the writ petition, Milord, filed application. And subsequently, one more order passed by the authority, Milord, that is challenged before this Honorable Court. Writ petition also dismissed, that is confirmed by the division bench. In view of the subsequent development, application does not serve for consideration.
An IA is filed. IA is filed seeking extension of time. Modification of the order dated 25/2/2026, the matter came up before the court. Then counsel appearing for the petitioner submits the said application no more survives for consideration for the reason in view of the subsequent developments. Hence, the same may be dismissed as not pressed. Accordingly, I number so and so is dismissed as not pressed. Yes, next.
Serial number 3.
Please.
Yes, Shri B. Serial number 3.
Yes. No representation. This is matter after 4 weeks. Yes, next.
Serial number 4. Serial number 4. Soumya
Milord.
Hegde.
Milord, I represent petitioner, Milord.
Yes.
Last time, Milord, the memo was not put up.
No, we
I
will
mean,
see some other day. Today I have a heavy board today. Yes, this is matter on in the month of August. On
Milord, may I seek specific date, Milord, please?
19th of August. Yes,
Great.
call the list.
List number 1. For orders matter. For preliminary hearing, serial number 1. Niraja Karan.
Here for the petitioner.
Yes.
In this matter, because last week we not.
Yes, you appear for them.
But I'll appear. Got the wakalat, I'll file it to the afternoon.
And now, if as per what the last time argument is that
May make one submission. They cannot squat over the property, not pay rent. I have filed an application that there is a 2 crore due.
let the court, wherever this matter will be transferred, let the court decide that in priority.
Even if it is transferred, that benefit which they are getting it on a commercial, and my lords are giving them an agreement saying that it's a commercial property and therefore you must go to the commercial court. If that order is to be passed, let them deposit the amount.
Is it a condition precedent that the court should do?
That Atmaram Properties case, wherever orders are passed, and they cannot have the benefit.
Will the court go into something else which is irrelevant for consideration in the writ petition? What is the writ petition? What is the scope of this order? Order is an order passed by the trial court, whether the civil court has jurisdiction or the commercial court. Now, when this court says commercial court has got jurisdiction, there is no necessity for the court to pass an order that it should be done.
May I make a submission?
Yes.
An humble submission that could be made. They have filed the other suit saying that cancel this agreement, saying that it's a fraud document and they have not acted upon the document. If that be the intent, there are 2 suits pending. The other suit is for that purpose. Lord, I draw the attention of the court insofar as that suit is concerned. You can't have both. On one breath, you say that the document is a fraudulent document. On the other hand, you say that it's a commercial intent. What is the choice insofar as the petitioners are concerned? Whether they have a choice of a fraudulent document or whether they have a choice.
No, let me look at what are the impugned orders, whatever are the impugned or what is the scope of adjudication, that I will be doing it.
Scope of the adjudication.
Other issues I will not be touching upon.
But in that event, one suit will remain in the civil court, one suit will be remaining in the commercial court.
And when it is a commercial suit, commercial.
Who should suffer, madam? The owner must suffer.
That is not the problem of the court.
That's the problem of the court.
Whether the matter
That's the problem of the court. That's the problem of the court. The court should know somebody else who could snatch away the property without any money and he takes the benefit from the court. Could they do that?
Where is the impugned order?
Page number 18 is the impugned order in Lord's Annexure A.
Passed in both the suits.
Same order.
Common order.
Same order.
Yes.
Yes.
Can they have the benefit? It's something fraud on somebody's property.
I'll hear you. Yes.
They have filed, this is a 15-2 application, not seeking transfer of the suit Millards to the commercial court Millards. The reasons are in page number 24 Millards.
Yes.
And page number 25, paragraph number 9 Millards. The court holds that it is a residential property Millards. However, on what grounds Millards the court has come to this conclusion that it is a residential property has not been discussed. There is obviously no discussion in the entire paragraph, Millards.
And you are referring to certain documents. Where are they?
Please, Millards. I am referring to the lease deed, Millards.
Page number.
My lords may first look at what's the suits that are filed.
You can argue once she completes.
Lords,
Yes.
page number 106, Millards. Annexure H, Millards, is the lease deed.
It's an agreement to lease.
And Millards, page number 112.
1 minute.
This is a lease deed of the year 2017, Millards, 15/5/2017. Page number 112, Millards, is the purpose of the lease, Millards.
112.
112, Millards. May I read, Millards?
Yes.
Second paragraph. Whereas the lessee approached and requested the lessor to grant lease of scheduled premises to him for manufacturing and sale of food, bakery, ice cream, sweets, hotel catering business on rent and security purpose for 10 years, Millards. And the lessor offered to lease the scheduled premises on refundable interest-free deposits of so and so, Millards. Is this lessor's intention also, Millards? For the same purpose, the property has been leased out. And Millards, the next covenant I am relying on, Millards, is page number 124, clause number 5, Millards. Here, Millards, the 124, clause number 5, Millards, property taxes. Millards, the lessor himself, the landlord himself, has valued the property as commercial, Millards, for all taxation purpose. And he has, this covenant says I have to reimburse whatever he pays, Millards, as tax, which is valued as commercial, Millards.
Next.
Also produce the tax paid.
Page number?
Millards. That is at page number 131, Millards, annexure J.
131.
131, Millards. Last annexure, Millards.
Yes.
Exhibit P4, it has been marked as, Millards, by them, wherein the property has been.
Now, this suit,
valued as-
this OS number 1017 of 2019 is filed.
Filed by us, Millards, the
For?
lessees, Millards, seeking cancellation of the lease date, Millards, on the ground that it was executed on fraud and false inducement to the petitioner that the property is a commercial property. And also we are seeking the recovery of money of the sum we have spent on renovation of the property, Millards. We have renovated.
What is this 2713 is for?
2713 is their petition, Millards, seeking the arrears of rent and also
Eviction.
of lease, Millards.
Yes. Yes.
But kindly see 1017, that is the suit filed in OS 1017.
Page number.
Page
54.
54. That's the plaint.
Yes.
And kindly look at what the allegations that are made. The allegations are in the said suit, they specifically contend in paragraph 12 and 13. Para 12 and 13. 12 is what is required. Defendant 1 and 2 have further agreed orally and supervised, made the plaintiff to spend erecting borewell in the scheduled property, availing of temporary additional electricity load, and to carry out agreed minor development alterations as stated above. Second defendant, in the meantime, though the first defendant had sent a mail objecting the development works, he himself approached the plaintiff personally, supervised the same, got the works done. Defendants 1 and 2 further promised and assured plaintiff that they would hand over Khata extract, no objection certificate, BBMP tax, up-to-date land conversion certificate issued with the BBMP, building plan, BESCOM authorities and additional power, commercial water connection and other details. That the plaintiff honestly approached the competent authority of the BBMP for necessary trade license to run his business in the scheduled premises. But shockingly, they have noticed that defendants 1 and 2 have mala fide intention, objected the authority to issue the license in favor without a valid reason. Plaintiff has realized that notice the defendants are fraudulently misrepresented and subject to commercial converted site building. Defendants have set up and made alleged residents to file objections and issue of commercial license to the scheduled site against the plaintiffs herein. Certified copies of the complaint, etc. are produced. Defendants have managed to execute evil design against the plaintiff that plaintiff would not start their business in the subject property and they would otherwise enrich instantaneously. Now, this was the statements that were made. Kindly turn to the prayer minute at internal page 9. Declaring the registered lease agreement 15/5/2017 executed before the sub-registrar's office is a result of inducement, misrepresentation, fraud which is illegal, fraudulent. One, hence is illegal, null and void, not binding on the plaintiff in any manner. That's his relief. Then consequently, direct first defendant to execute necessary cancellation revocation deed in favor of the plaintiff against the registered agreement 15/5/2017. Direct first defendant to return original checks collected during the illegal transactions which are more fully described in B schedule, directing defendants 1 and 2 to pay jointly and severally 64,12,600 so and so along with interest the date of the suit till the date of realization towards the damages cost, etc. According to them, there is no lease agreement at all. If it is sought to be cancelled, it is cancelled. They should have delivered possession of the property. They don't deliver possession of the property. On the other hand, this writ petition is filed. If they hand over the keys, I'm prepared to take the keys. They don't want to give the keys also. This is the situation. But on one hand, they say it's cancelled. On the other hand, no actions are taken. Apart from that, both the suits have been sought to be clubbed. They don't vacate the premises. Premises has gone wasted. It is into a dilapidated condition. No human being can reside. No human being can occupy it. But we are suffering in the litigation, which is a frivolous and a false litigations that are being pending before the court. He dragged on the case from 2019. At the end of the stage, when the case was posted for arguments, this application is brought. On one hand, they don't pay the rents. On the other hand, they want this litigation to be pursued at the hands of this court also. I don't have the money. I don't have money to pay tax. Is this not a fraud on court at any stage? And all that, I am not responsible. He is a businessman. He knows that this premises cannot be taken on lease. He makes all arrangements to see that he enters into a lease. It's his headache to get a commercial permission. He makes a counter allegation against me that I have made a complaint. I have evidence to show that in his own evidence he has stated that all documents which has gone to the corporation are forged documents. The signatures of the owner of the property are forged for the purposes of getting licenses, which was not granted. Neighbors have objected. Am I responsible for all these actions? And 2 crores 19 lakhs is due insofar as rents are concerned till date. Should I suffer, my lord, with this
You have to
litigation?
ask yourself. I cannot tell you that. Please come.
That if both the suits are going to be transferred, or your honors may set aside the order, let the trial court, I'll make an application under 7 Rule 10 for transferring these cases.
We'll transfer both.
Yes.
We'll transfer both the suits.
Yes, madam.
The
order be set aside and send it back, my lord. I'll make arrangements to see that an application is filed.
you will file an application to transfer your suit also.
Yes.
Now, when both the suits are, they're now clubbed together and both arising out of the same agreement, so let both be transferred. We will pass an order and so let both be transferred.
Two things that may arise. May I make a submission? But there is some technicalities
Something.
insofar as it is concerned. I make my submission. Now, if this court transfers these matters, the trial court, 12A would come into effect. And if 12A is to be come into effect, pre-institution mediation, I must exhaust. Can court dispense pre-institution mediation? Of course, I may have to make an application. They will once again get 6 months benefit insofar as pre-institution mediation is concerned. This litigation would be on the face of the owner of the property to suffer this litigation.
So what is to be done? I'm not able
I
to
will
understand
suffer.
your submissions.
Not I will suffer. I told my client, you suffer and you die, I said.
Yes. No, what is that you want? You want this court to transfer both or not?
Not
Or
my-
only I'll allow this application and leave it there?
May I make a submission, Manoj?
Yes.
Set aside this order, ask the trial court to pass a fresh order. I make a submission before the court. I will make an application in my case for transfer it to the commercial court.
No, what will happen if this court transfers?
But if this court transfers, that pre-institution
And
mediation,
if that court transfers, your 12A is dispensed with.
I have a reason for that. The Supreme Court has said, once if it is transferred, I can make an application under 12A, keep the case pending so that the pre-institution can be completed. Then again, that suit can be revived. This is a
Anyhow,
judgment
then
of the Supreme
I'll
Court.
allow this petition whatever you want to do, you do with that. The present writ petition is filed.
My lords I have to make an application in that court.
Make it there. Whatever is this writ petition, I will allow it.
But if it is allowed, that order would remain. The order, if it is allowed, that order would be set aside. What should happen to the litigation? Consequences.
The present writ petition is filed. Agreed with the orders passed on. I number 22 in OS number 1017 of 20.
My 3 applications are pending here for arrears of rent.
Clubbed
Last
with-
time my lords had said, make an application, I'll consider. Those applications are also before the
Clubbed with OS number 2713 of 2018. There are 2 suits. One is OS number 10117 of 2019 filed seeking cancellation of the lease deed along with other reliefs. And OS number 2713 of 2018 is filed by the owner of the premises seeking arrears of rent, and both the suits are clubbed by the court.
No, it's not for arrears of rent, it's for damages.
It is for damages. In that I number 22 is filed in OS number 1017 of 2019 under section 15(2) of the Commercial Codes Act. Read with section 151 CPC.
In both the suits that we have,
Huh?
it is connected. These 2 suits are connected, and in both the suits we have filed.
Both the suits is filed.
Yes, it is filed.
In respect of both the suits. An IA number, the IA is filed under section 115(2) of the Commercial Codes Act with a prayer to transfer the suits to the commercial court at Bangalore that came to be dismissed by order impure. The court has, while dismissing the application, the court has observed that on going through the documents relating to the suit scheduled property, it is not a commercial property, but it is a residential property. Plaintiff is number 1017 of 2019, who have filed the present IA, have entered into lease agreement with defendants to take the suit scheduled property on monthly rent, and they attempted to get commercial license. The authority competent refused to grant license to run business activities in the suit scheduled property. On careful perusal of the pleadings and the material available on record, transaction between the parties does not fall within the ambit of commercial transactions as envisaged in the Commercial Codes Act of 2015. The court has further observed that plaintiff in OS number 1017 of 2019, who have filed the present application, have not stated as to why they present the plaint before this court if the transaction is of commercial in nature, instead of presenting the same before the commercial court. Other side has read evidence on the witness, that is PW1 is cross-examined by the plaintiffs during the said stage. This objection is not raised in the cross-examination of PW1. Thus, looking from any angle, the court does not find any grounds to hold that the transaction between the parties is commercial in nature, and accordingly dismissed the IA. Agreed by the orders in both the IAs. Two writ petitions are filed. That is WP 10643 of 2026 and WP 9816 of 2026. As two, as these arise out of suits clubbed by the court and out of an order in the IAs. This court petition is disposed of by way of a common order. Then counsel appearing for the petitioner submits that petitioner tenant submits that the court has failed to consider the application that is filed by the petitioner, and the findings of the court are contrary to facts on record. It is court went on a premise that it is a residential property. Then counsel has drawn the attention of this court to the agreement to lease, and particularly to the covenants where it says that the lessee approached and requested the lessor to grant lease of scheduled premises to him for manufacturing and sale of food, bakery, ice cream, sweets, hotel, catering business on rent, and security deposit for 10 years duration. Further, it states that whereas a lessor offered to lease a scheduled premises on a refundable interest-free security deposit of rupees 12 lakh plus rupees 6 lakhs and monthly rent of rupees 1,20,000 plus service tax GST as applicable on dates subject to change, plus increase in rent at 8% every year thereon, and rentals by way of 120 numbers post-dated checks for a term of 10-year duration. Then counsel also has drawn the attention of the court to the clause number 5 of the said lease agreement, where it says property tax shall be paid by the lessor, but lessee is liable and shall pay to lessor from the year 2017-18 onwards till lessee vacates BBMP SAS taxes within brackets all the total taxes payable in excess to than paid by lessor for commercial for 2016-17 inverted comma the bracket close for any and for additions covered or added by lessees, alterations, modifications in the scheduled premises portions, or it will be deducted out of a security deposit. And counsel submits that in support of her case, she has also placed the tax receipt, which clearly mentions about the what is that at page 131?
It's a tax paid receipt where the property has been valued as commercial.
Where it shown as non-residential zone, commercial, declared by the taxpayer. Basing on this, then counsel for the petitioner submits that it is a commercial property. It's a commercial transaction between the parties, which very well come within the purview of the Commercial Courts Act, and the Commercial Court alone has got the jurisdiction, and the trial court has failed to consider all these aspects. Next paragraph, then counsel appearing for the respondent landlord submits that they have filed submits that till the matter came up for arguments. And even in the course of after the cross-examination, at this stage, the present application is filed. All the while, they have been contesting the matter, and the first time they have come up with such an application. It is a case that they have not paid the rents.
From the beginning, they have not paid.
Arrears of rents running into crores of rupees.
No, 2 crores. I have stated correctly, madam. 2 crores, 59 lakhs is the arrears in rent.
Running into crores of rupees, and crores of rupees, and
2 crores, 2 lakhs 28,280.
Then they have not managed the property, and the property is in a very they're not managing the property. Is not in a livable condition, and by virtue of that, the landlord is put to a lot of inconvenience. Neither the premises is used, nor the rents are paid, and nor the premises is maintained. in these circumstances, only with an intention to delay the proceedings, the present petition, the proceedings, the present application is filed. It is submitted that the court has rightly dismissed the application. Next paragraph, and counsel further submits that this order may be set aside and the matter may be remanded to the court. There he will file an application seeking transfer of his suit.
I'll
It is
invoke 7 Rule 10A for transferring.
Order 7 Rule 10A. It is submitted that if now the petitioner has to go through the process of Section 12A of the Commercial Courts Act. And again, the petitioner will have the advantage of protracting the matter by another 6 months. 6 months. It submitted that if the court is inclined to set aside inclined to pass any orders, then the may be set aside and remanded back to the court. Next one. Having heard the counsels on either side, that is the material on record. There is no dispute about the fact that 2 suits, 2 IAs are filed seeking transfer of the same, as the transaction between the parties is commercial in nature. In that regard, land counsel for the petitioner has drawn the attention of the court to the agreement, the lease agreement, the covenants of the said agreement. This court has perused the same. A perusal of the order passed by the trial court shows that trial court has failed to consider the agreement between the parties and on what basis the court went on a premise that it is a residential property is not known to the court and it is not borne out of the record. Considering the agreement of lease, the covenants, and also the property tax receipt that is placed before the court clearly shows that it is a commercial property. And then as there is a commercial transaction between the parties, the commercial court alone has got the jurisdiction to decide the dispute between the parties. Hence, in the opinion of the court, the order passed by the court and is liable to be set aside. Then coming to the submission of the land counsel for the petitioner, that this order is set aside, he will file an application before the court seeking transfer to commercial court. This court do not find any force in the said document, as in the considered opinion of the court. This is a transaction between the parties is a commercial transaction, and the order before the court needs to be set aside, and applications have to be allowed. Consequently, the application filed by the petitioner herein have to be allowed. Hence, the question of remanding the matter does not arise. In that view of the matter, this court is passing the following order. The order passed by the court in IA number. This is IA number.
IA number 22.
That is 23. In the other matter.
No. Only IA is filed because both the suits are connected.
So IA number 22 is allowed. Consequently, IA number 22 is allowed, and OS number so and so are transferred to the commercial court.
Transferred from the stage in which it is posted.
Then it shall be
continued from the stage in which it is.
The court shall proceed from the stage where it is pending before the earlier court. Yes, next.
Serial number 2, preliminary group, Gautam and Raghunath.
The matter was posted yesterday and they had sought time till tomorrow. Your Lordship has stated that the petition would be dismissed if they are not turned up.
Yesterday, when the matter came up, a mention was made seeking adjournment, and counsel for the respondent has opposed the same. And hence this court has directed the matter to be listed on the top of the list. And it is made clear that no further time will be granted on that day. And if any adjournment is sought, the writ petition will be dismissed on the ground. Today also, though the matter is listed as item number 2, there is no representation on behalf of the petitioner. the interim order granted earlier is vacated. This is matter in the month of October. Yes, next.
Cell number 3. Vinay N for petitioner.
As per number 1 and 3.
I filed a memo for withdrawal. There's been a compromise and the suit has been withdrawn by me. Maybe dismissed as withdrawn.
Where is the tie? Memo is filed stating that the parties have entered into compromise in OS number 752 of 2008 on the file of the principal senior judge and JMLC Devanahalli. And they have withdrawn, they have filed a memo for withdrawal, and the court by a wide order dated 28/11/2025 dismissed the suit as withdrawn. In the light of the same, nothing survives for consultation in this writ petition, and they filed the memo seeking to withdraw the petition. Accordingly, memo is taken on record, dismissed as withdrawn. Yes,
Cell
next.
number 4 urgent 5. Chandranath Arida. Cell number 5.
Petition.
Yes.
Is only a mandamus is sought.
Uh,
But suit is of the year 93, suit for possession.
Suit is of the year
1993. Suit was decreed in 2009. Execution petition is filed in the year 2009. It has not reached this stage. Court is not proceeding.
Which court is this?
This court. At Kundapura, annexure. Yep.
It comes within which district?
It comes within the district of Udupi.
Udupi.
Yes.
The present writ petition is filed. Present writ petition is filed seeking a mandamus directing the civil judge and JMFC by Indore to dispose of execution case number. It says 63 of 2023.
It was transferred.
63 of 2023 in a time-bound manner. Next parallel, counsel appearing for the petitioner submits that the suit is of the year 1993, and the same came to be decreed in the year 2009. And in the 2009 itself, it is execution petition is filed, and later it was transferred to the present court and renumbered as execution case number 63 of 2023. It is submitted that from the last how many years? 16 years.
17 years.
From the last 17 years, the execution petition is pending, and the same is not considered. Considering the fact that this is a suit of the year 1993, and which is decreed, then the suit and the execution is filed in the year 2009, which is pending with the court. It required and in the considered opinion of the court, the same has to be disposed of expeditiously. Accordingly, this court is passing the following order. The civil judge and JMSC by Indore is directed to dispose of execution case number 63 of 2023. How much time? What is the stage now?
My lord, the stage is the issue of delivery warrant.
Generally, how much time it takes?
My lord,
Even if they, we have to know. Even if they start doing it, we have to. The High Court has to tell them to do in a reasonable time. We can't.
Within an outer limit of 6 months.
Within an outer limit of 6 months, the court shall dispose of the execution petition. No notice is issued to the respondents. A disposal of the case is in the interest of both the parties. Yes, next.
Cell number 6.
Appearing for a petitioner.
Yes.
My lord.
Yes.
Appearing for petitioner. My lord.
Yes.
My lord, I'm for petitioner. Srimati Mariamma was 3 children, namely Munegoda, Rajana and Sri Kariyappa.
The second son, Rajanna, and his wife Siddhamma had
No,
four
no, no,
children.
please wait. All those are not necessary. What is the suit for?
So they suit for partition, my lord. The suit scheduled property is my father's grandmother property, my
You are
lord.
the plaintiff or the defendant?
I am for the impleading defendant, my lord. Defendant number 17.
You have filed an IA. That is
Yes,
allowed
my-
or that is dismissed?
Dismissed, my lord.
Please come to the order.
Kindly see the page number, my lord.
Page number?
See the page number.
Page number 59.
Yes, my lord. 59. '63 in the order, IA number 19 is proposed, defendant number 17 under order rule 1 is hereby rejected for the reason stated in page number 62, my lord. The father of this proposed defendant is already on record and defending the suit by filing written statement. Under these circumstances, without the presence of proposed defendant, effective decree can be passed. The presence of the proposed defendant is not necessary. Admittedly, the father of this proposed defendant is already on record and filed written statement. The father of the proposed defendant filed his written statement for dismissal of the suit. Under these circumstances, as rightly contended the plaintiffs, proposed defendant is not a proper party and necessary party of this suit.
What is wrong with the order?
My lord, this is my grandfather, my father's grandmother's property, my lord. On that OS number 5096 of 1995, order dated on 18 September 2008, my lord. On that suit is pending before the court. The defendant number 5 in the original suit number 3167 of 2015.
What is correspondence? Yes.
Defendant number 15.
7. Cell number 7. Kankajappa MG.
Petition. The petitioner filed insolvency petition. Insolvency.
Use the mic.
The petitioner is filed the insolvency petition, my lord, before the trial court, and the respondent number 15 and 16, 14 and 15 and 18 also filed IA for the Order 7 Rule 11D, reject the plaint, my lord. But the trial court has passed the order, my lord. IA is allowed against the 14 to 22. Suo motu another defendants also dismissed. That is wrong, my lord. Only filed IA defendant number 14 and 15. IA number 2. IA number 3 filed is defendant number 18.
Order, let me understand from the order.
Page number 52, my lord. 51 is the starting. Last order settled. Again,
yes.
the matter take up so and so. IA number 3 filed under Order 7 Rule 11D CPC, reduce section 8 and 25 of the Prevention of Insolvency Act 1920, filed under respondent number 14 and 15. I have also gone through the decision of Honorable High Court, Allahabad Report AAR 2021, and so on so. So and so. As rightly submitted, respondent number 14 and 15, as per section 8 of the Prevention of Insolvency Act, no insolvency petition shall be presented against the corporation or against any association.
Insolvency petition. Come to your insolvency petition. Where is it?
Annex A, my lord. Annex A, my lord. Page number 20. The petitioner is the business loss, my lord. Due to corona.
Who are the respondents?
Respondent, my lord. Total respondent is 42 members.
That's what we'll see.
The 14 to 22 is the corporation
no, 13,
and bank, my lord.
13 is Beeralingeswara agencies. 15 is ICICI Bank. 16 is ICICI Bank.
Please. Up to 22 is the bank, my lord.
19 is Cholamandala Investment.
Please.
Bajaj Finance. 21 is IPL Finance.
I have no income, my lord. Due to corona, business is very heavy loss, my lord. There is no income, my
All
lord.
banks are
Yes.
included in this.
But other bank is not filed any application, my lord. The trial court is suo moto allowed the application, my lord. Without application. My lord.
I'll take notice for 15 and 16. No, Section 8 says no insolvency can be maintained against a corporation or the companies. Because trial court has dismissed against the companies.
I have no
And,
income. My lord.
and if a suit and if
What is wrong with the order? I'm not able to understand.
if a suit is dismissed against the companies, Mulats,
It's only against them. For
And it-
remaining people, you can pursue.
other people he can always pursue.
Please come. The
But petitioner is no income, my lord.
No, that is true.
And,
Whatever it is,
How
when
is
Section 8 is very clear,
How is possible to recover the amount, my lord?
if they
Insolvency
can't
petition.
recover, they will leave it. But you
There is
cannot Section 8.
Outstanding is 89 lakhs in this case.
No, my lord.
Only for
Single
ICICI.
paisa is
Only for ICICI Bank.
Oh, agreed with the order passed. And
Because it is not prevention, it is Provisional Insolvency Act.
provision.
where do you get the prevention insolvency? The agreed with the order dated 21/20/26 passed with the principal district and session judge at Chitradurga and insolvency petition number 1 of 2024. The petitioner is before this court. The court, by order impugned, had allowed I number 3
2 and 3, my lord.
again. No, when I number 1, 2 and 3.
Only 2 and 3, my lord. No,
I number 2 and 3.
2 and 3.
2 and 3. And the petition against not only R15 and R16, even against R17 and 22 is also dismissed. And also against R18 is dismissed. Then counsel for the petitioner submits that when the insolvency petition is filed, the petitioner has filed the petition against as many as, how many respondents?
42, my.
42 respondent defendants. It is stated that the IA number 3 and 2 and 3 are filed by respondent.
18 and 14 and 15.
18.
15 and 16.
IA3 is filed by 15 and 16.
IA3 is filed by 15 and 16 and 2 is filed by 18.
18.
IA2 is filed by 18. But the court has dismissed while allowing the IA, has dismissed the case against 17 and 22 also.
17 to 22.
17 to 22. 17 to 22. It is submitted that when there is no application by the concern and while passing orders, the court ought not to have rejected the petition in respect of the other respondents who have not filed any application. Having heard the counsel for the petitioner, next before that, Learned Counsel so and so submits that he has instructions to file wakalat on behalf of respondent.
15 and 16, my lord. ICICI.
15 and 16. Next. The petitioner has filed an application under the Provincial Insolvency Act 1920, wherein he has showed the companies, the financial institutions, also parties to the said insolvency petition. An application is filed, IA number 3 and IA number 2, IA number 3, IA number 2 and 3 by respondent number 18 and 15 and 16. It is their case that as per Section 8 of the Act, no insolvency petition shall be presented against any corporation or against any association or company registered under any enactment for the time being in force. Hence, not only against 15 and 16 and 18, the respondent 17 to 22 are also companies, hence the court has dismissed the case. the contention that when there is no application, the court has dismissed the case against them. It has no legs to stand for the reason. When Section 8 applies to all the companies, considering the fact that the others are also financial institutions or the companies registers under the Companies Act, the court has rightly passed the order, and this court finds no infirmity with the said order, accordingly dismissed. Next.
Question number 8. Chandrasekhar, HB.
Petitioner, Your Lordship. Lord, this is the petition filed by defendant number 2, my lord, where a application to appoint her as guardian to represent the minor, who was the son of defendant number 4, Lord, got dismissed.
What is the suit for?
Suit for partition, Your Lordship. During the pendency of the suit, my lord, defendant number 4, who happens to be the father of defendant number 1, died. Lord, his wife died predeceased the defendant number 4. Lord, when the fact remains thus, my lord, an application under Order 22 Rule 4 was invoked by the plaintiffs, requesting to issue notice to the legal representative or legal heir of defendant number 4. Lord, he happens to be the minor. So defendant number 2 was taking care of the minor son, and she makes an application under Order 32.
What is the relation between defendant number 2 and?
Lord, she happens to be the, my lord, the paternal aunt, that is the sister of the defendant number 4. Lord, that application came to be dismissed. Lord, what had happened is, my lord, when admittedly the plaintiffs had filed application under Order 22 Rule 4 is still pending. Lord, the court posts the matter to record the evidence of plaintiff. Lord, the interest of the minor has not been protected by the trial court. Lord, this particular act.
See, then according to the court, who should take care of the minor?
Lord, no, even the court guardian has not been appointed, which is essential, my lord, to protect the interest of the minor. Even that particular thing has not been done. Straight away, the matter has been posted to evidence. No guardian is there to represent the minor now.
Please come. Then counsel for the petitioner, defendant number?
Defendant number 2, my lord.
Defendant number 2 submits that after the death of defendant number 4,
please,
his legal heir, the minor was impleted, and petitioner, being the paternal aunt of the child who was taking care, has filed an application to
appoint her as guardian.
Appoint her as a guardian of the minor. That application came to be dismissed by order impugned dated 29 July 2024, and counsel submits that. Now the court is proceeding with the trial. The interest of the nobody is appointed to take care of the interest of the minor, and the court is proceeding with the matter, which is not in the, and this is contrary to law. Considering the submission, there shall be stay of all further proceedings. Notice to the respondents in addition hand summons, and a memo shall be filed in that regard by 23rd, or else a stay granted by this court stands vacated. 9.
Number 9.
Gratefully ordered.
Chetan R. PC.
Petitioner, my lord. Defendant petition, my lord. The petition, there are 2 suits pending before the parties. I have filed suit for declaration and ejectment of the respondent. Respondent are cultivating the land. Total extent is 1 acre 7 acre 22 guntas. In that 1 acre 22 guntas is cultivating by the respondent, which belongs to me. So now I filed a suit for declaration and ejectment. They have filed a suit for injunction. In that I file a memo. Kindly see Annexure C, my lord, is a memo that I undertook before the court that I will evict them under the due process of law. On that basis, the court has to pass order on that memo. No order has been passed. Thereafter, after 3 months, I filed the written statement along with the application, which has been rejected, which is under challenge before your lords. Only the question of law is when the suit for substantial question regarding declaration and ejectment is pending before the jurisdiction court, that memo has to be decided. I undertook before the court that I will not evict.
What is impugned order?
Kindly see the impugned order. The relevant page is page number 43, my lord. Annexure F. My written statement was rejected. When I filed the memo, the court doesn't pass any orders. Thereafter, I filed the written statement along with the application.
What is the delay?
Delay is 4 months, my lord. And the age
after 120 days, 4 months.
Yes, yes.
Please come. let
80
counsel
80 years of age, I have reason.
petition submits that court has dismissed the application. This has refused to take the written statement on record on the ground that it is filed beyond 120 days. And then counsel submits that in the light of the order passed by a coordinate bench of this court, where the operation of the amended provision is suspended by the court ought to have not considered the amendment to the CPC. In the light of the orders passed by a coordinate bench of this court in so and so, there shall be stay of all further proceedings and so and so. And the particular next,
One more. The year of the 80 years of age, petitioner is 80 years of age.
granting stay.
Please.
Stay of all further proceedings pursuant to the order dated so and so. Same hand summons, memo notice, edition hand summons, memo to be filed 23rd, or else a stay granted by this court's transfer case.
Cell number
Public.
10.
Petitioners, please.
Manish,
On this matter.
Govind.
My lords, this petitioner's writ petition from a dismissal of a civil disobedience petition, my lords. The civil disobedience petition, my lords, was listed for evidence. Both parties appeared and filed a joint application under Order 17. We appeared, my lords, stating that we are taking steps towards settlement and sought for an adjournment. Unfortunately, my lords, despite our presence and a joint application, Order 17 Rule 2, a dismissal of the disobedience petition comes to be. My lords are aware, under Order 17 Rule,
Let's see the order.
please,
Come to the
Annexure A, my lords.
Page number?
25. Relevant portion is at 26, my lords. Lords have 26. Lords, you'll see the first line. Both the counsel are present. Counsel for petitioner filed adjournment application under Order 17 Rule 1. In fact, my lords, it's a joint application. However, this matter
Joint
is
application for?
adjournment, because both of us said that we are settling the matter. There was a compromise under
This
it.
matter is reserved for the evidence of petitioner.
It was
This
not
is a-
reserved for judgment, my lords, and that's my difficulty. It was dismissed under Order 17 Rule 2, my lords. Under Order 17 Rule 3A, if both of us are present, then it may have been posted for orders based on the existing material. But it is in fact dismissed under Order 17 Rule 2. I filed, of course, my lords, the order sheet also to show that from 2023 till 25, there was an IA for addition.
Is dismissed the
Entire disobedience petition. My lords, you'll see the last line in that page. Accordingly, the adjournment application is hereby rejected and the petition is not survived for consideration as the petitioner is not interested to proceed.
when counsel of the petitioner submits that, when both the parties, as they want to settle the matter, and they filed an application for adjournment, the court, as while rejecting the said application, has dismissed the miscellaneous 68 of 2022 itself.
Please, ma'am.
Commercial miscellaneous of 68 of 2022. It is submitted that such a course is not available to the court, and there was no occasion for the court to dismiss the miscellaneous itself, considering the submission. There shall be stay of.
I've not sought for an interim prayer, my lords, because it's an order of dismissal. I didn't. I've not
They
sought
said
for
the
a prayer.
order, the operation of the order dated so and so shall be stayed
Notice.
until next date of hearing.
Notice I have not.
Notice to the respondents, hand summons, memo by 23rd, or else the interim order stands vacated.
Cell number 11. Mahadevi Hiremat.
Appear for the petition. I'm the defendant number one in the suit, which is a money recovery suit, and we filed the application for one application for framing of an issue. At that time, there was an error on our part, and therefore we made another application for recasting the issue. But the basis for the
That was
correcting
dismissed?
yes, that was
Where is
the
it?
second one is dismissed.
Where is that
123, my
order?
lord. The learned judge admits.
Page number?
Page 124. 123 is the relevant one portion of it, my lord. Para 8. Para 8, my lord. Admittedly, the defendant herein, in his written statement, has taken a specific contention. My lord, has it?
Where are you reading?
120, running page 123, para 8.
which is part of the order. I'll just read that and then I'll expostulate.
We can read from that.
Admittedly, the defendant herein is in his written statement has taken a specific contention that majority of the invoices, 144 invoices out of 146 invoices are barred by limitation. So it is accepted here
Let's read the complete order.
that we have said this. Now, my lord, kindly take the application itself, my lord. This is the
No, we'll complete the order.
We'll complete the order. Yes. In my opinion, the issue number 6, which is already framed by this court, casting burden upon the defendant number 1 to prove that the suit filed by the plaintiff is barred by limitation, is sufficient to answer the query raised by the defendants as far as the issue pertaining to limitation is concerned. So the issue that was framed was that the entire suit is barred by limitation, which cannot be. Otherwise, I would have filed a 711. Then, my lord, as for the case of the plaintiff, they have raised issues from the year invoices from the year 2017 till 2019, and the suit which is filed in the year 2024 is well within the period of limitation. If the
Where is your application? What issues according to you to be framed?
Please see the IA is at page 91.
100 and?
Page 91.
Yes.
So the earlier issue as it was framed by the court was whether the defendant number 1 proves that the suit filed by the plaintiff is barred by limitation. That could not be, because we have not said that all the invoices are there. We pointed that out to the court that in the first instance we made an error.
He has filed a suit for recovery of money based on these invoices.
On 146
invoices.
We have
so
said
the issue is framed whether the suit is barred by limitation. Limitation in the sense he is seeking recovery of the money basing on those invoices.
On those
So
invoices.
why not this issue is covered in that?
Because of this reason, I'll point out that.
Yes.
Please take page 20 of the plaint and and then 36 of our written statement. Why it is necessary that it should be that dealt with separately. Page 20, my lord.
Yes.
This is I'm reading from the plaint. Para 5. The defendant approached so and so. My lord. I'll read from the 5th line, my lord. The purchase orders.
You're reading para number?
Para number 5, running page 20.
Yes.
I'm reading from the plaint. The purchase orders were instructions from defendant number 1 to the plaintiff to render services. The plaintiff would then provide the services as per the terms of the purchase orders, which were separate and independent contracts governing the relationship between the parties. Now, each of these purchase orders and each of these invoices are separate and independent orders and independent contracts. Once they are independent contracts, each has to stand on their own. That is why we have said that 144 of them, according to us, are time barred. The rest of it, 2 of them are not, because it's one after the other, spread over a period, as my lord saw, from 2017 to 2019. Therefore, it is necessary that it should not be.
We'll notice the respondents.
Not a short date, because a very small point.
The petition is permitted to take out hand summons on the council and shall file a memo to that effect by 21st July.
A shorter date, because my lord has seen that it's a very narrow compass. If my lord
That's
feels
true, but how the matters will come up
24th
in
is the next date of hearing, incidentally.
List the matter on 16th of July.
I'm obliged.
If the memos are filed by 15th, then list the matter on 16th.
Obliged.
Cell number 12. 12 Prakash K.
Lord, appear for the petitioner.
Yes.
Lord, this petition is filed by the defendant, my lord. Plaintiff suit is for declaration and for recovery of possession of 4 guntas of land situated in the Schedule B property, my lord. The defendants files IA number 8, my lord, under Order 26, Rule 9, to appoint Taluka surveyor as the court commissioner to identify whether there is an encroachment or not, my lord.
Where is the order?
Order is at Annexure D, page number 24, my lord.
Page number?
24, in page number 24.
Come to the reasoning part.
Reasoning part, my lord, I'll just take my lord to page number 28, my reasons. The plaintiff has submitted no objection, madam. Even despite that, the trial court rejects the application.
Read the reasoning part.
Reasoning point number 1, page number 28.
Yes.
On perusal of the materials available on record, admittedly the plaintiff has filed present suit against the defendant for the relief of declaration and possession in respect of the suit scheduled property. When the matter is set down for arguments on merits, at this stage the defendant has moved this IA. It is the urge of the defendant that the plaintiff and his family members own lands bearing survey numbers so and so, which are situated adjacent to the defendant's land in survey number 171. And in order to ascertain the exact boundaries and to determine whether any encroachment exists, measurement of all the adjoining survey numbers is necessary. Therefore, the appointment of court commissioner is very much necessary to measure the plaintiff's property, defendant's property on all lands adjacent to owners of plaintiff and defendant property. On the other hand, counsel for the plaintiff submits no objection to allow the aforesaid IA filed by the defendant. The counsel has said no objection, despite that the trial court rejects. Next parameter. On perusal of the material placed on record, admittedly, plaintiff has filed this suit against the defendant to declare that the plaintiff is the absolute owner of suit A scheduled property and for recovery of B scheduled property from the defendant. In a suit for declaration and recovery of possession, the burden of proof is always lies upon the plaintiff to establish his title over the suit A scheduled property and encroachment of B scheduled property by the defendant. The main contention of the defendant is that appointment of the court commissioner is necessary to measure the defendant property.
Yes, I've seen what's wrong with the order.
Yes, my lord, actually the plaintiff's property on the other side has taken for road widening for 4 guntas. By concealing that, he is coming on the other side to the defendant's property. If that is measured, where the 4 guntas has gone to the road will be identified.
No, that is his suit. Burden lies on him. Why do you want?
But the 4 guntas of his land is taken for road widening on the other side of my property, his property. He is coming, by concealing that, he is coming to my property for 4 guntas. The land is surveyed and the 4 guntas taken by the
service is available on the before the court.
No, my lord. Survey of that identification of the land.
Plaintiff has already, in the present case on hand, the plaintiff has already produced a certified copy of the survey sketch.
Yes, my lord. That is, my lord, that is before road widening, before acquisition, 4 guntas. By concealing that, he has filed.
Where did you say all this? Where did you say all this? Where is your IA?
IA. It is in page number 21, my lord, annexure C.
Please read it and tell the court.
Yes, well.
Now, what all you are submitting now is the reason for this application.
Yes, well. My lord, in the affidavit, my lord, I submit that the above the one.
You have not stated. I don't read entire one. Please, from your affidavit, please point out about this. What is this acquisition, road widening? Where did you say?
It is said in page number 23, my lord.
Read.
I submit that the defendant submits that a proper scientific measurement by a competent survey authority is essential for effective adjudication of dispute and for enabling this honorable court to arrive at a just conclusion.
That is not your submission.
Next paragraph. I submit that unless a court commissioner is appointed to measure the above properties with reference to the village records, survey maps, and revenue documents, the real controversy between the parties.
That is already on record. What is already on record?
The survey sketch what exhibit P13 has produced, that is before acquisition, 4 guntas.
Where did you say that's why I precisely asked you to come to your affidavit.
Yes,
you have not asked for that before the court. Please come. The petitioner is agreed with the order. Passed on number 8, invoice number 60 of 2020, dated 27th March 2026. The respondent herein has filed a suit for declaration, injunction, and recovery of possession. In that, the defendant, who is a petitioner herein, has filed an IA under Order 26 Rule 9 Red with Section 151 CPC to appoint the Taluk surveyor as court commissioner to measure and demarcate the lands bearing survey number 172/1, 172/2, 172/3, 172/4, 172/5, and 172/6 belonging to the plaintiff and his family members, and survey number 171 belonging to the defendant, with reference to revenue records and survey maps to note the physical features and possession if any encroachment exists, and to submit a detailed report along with a sketch map to the court by allowing the application. That came to be dismissed by order impugned. While dismissing the application, the court has observed that on perusal of the material placed on record, admittedly the plaintiff has filed the suit against the defendant to declare that the plaintiff is the absolute owner of the suit A scheduled property and recovery of the B scheduled property from the defendant. In a suit for declaration and recovery petition, the burden of proof is always lies upon the plaintiff to establish his title over the suit A scheduled property and encroachment of B scheduled property by the defendant. The court has observed that the main contention of the defendant is that the appointment of the court commissioner is necessary to measure the defendant property, plaintiff property, and plaintiff's family members' properties in survey number 172/1, 172/6, and 171/1 and 171/2, which is situated adjacent to the suit scheduled property, and to submit the report of the same. It is observed that the defendant's property and the adjacent owner's properties are not subject matter of the suit, and the same cannot be done. And it is also observed that it is well settled law that mere non-objecting the IA by the other side is not a ground to allow the IA, but it has to be decided on the merits of it. In the present case, the plaintiff has already produced a certified copy of the survey sketch in respect of the suit scheduled property, which came to be marked as Exhibit P11 to 13, which clearly shows that the Taluka surveyor has already surveyed the suit scheduled property and prepared the rough sketch. Hence, there is no necessity to measure the property and all adjacent lands of suit scheduled property once again. The court observed that the evidence available on record is much sufficient to decide the dispute between the parties. When such being the case, at this stage, if this IA is allowed, it is nothing but a parallel proceedings for collection of additional evidence and to fill up the lacuna of the case of the defendant. Hence, the court is not inclined to allow the application and dismiss the same. Next parallel, and counsel appearing for the petitioner submits that the court has failed to consider the application filed by the petitioner. It is submitted that the survey report which is placed on record is before the land is acquired for road widening, and after the road widening, what is the present stage has to be surveyed by the commissioner, by the surveyor. This aspect was not considered by the court, and the order impugned needs to be set aside. Next para. Having heard the counsels on either side, the counsel for the petitioner, there is a material on record. The affidavit that is filed in support of the IA do not contain any of the reasons as argued before this court. Nowhere in the petition it is stated that after the acquisition of the land for the road widening, there is a requirement to survey the lands. For that, he has filed this application. The court has rightly observed that already a certified copy of the survey is on record, which shows about how the scheduled properties are situated. In those circumstances, the court has rightly held that there is no necessity to appoint the advocate commissioner and dismiss the petition. This court do not find any reasons to interfere. Dismissed.
So number 13, by K. Narayan Sharma.
Similar matter has been adjourned to 8/7, my lord.
List along with so and so. Give the number, write on a paper,
Please,
and give.
please.
It's 14.
So number 14,
Plaintiff's writ petition,
Case Ganesh.
suit for partition. Though served, defendant did not appear at the initial stage, my lord. When the matter was posted for judgment, he filed his written statement along with IA number 8, seeking to include two properties in the plaint, claiming that those are the ancestral properties, my lord.
Suit for partition.
Suit for partition. Now, my submission is, my lord, I have no objection if the defendant makes a counterclaim in his written statement, forcing me to incorporate those two properties in the plaint causes prejudice to me, my lord. Order 6, Rule 17 says the court may, at the instance of the either party, direct the amendment may be allowed. Order 6, Rule 17 may call into
No, if it is a case of the defendant that those are all the sue scheduled property, these properties are also joint family properties, and as per the same, it has to be decided by the court. What is the
No, I have no objection, my lord. But let him make a counterclaim. I have no objection. In his written statement, if he claims that these two properties are the joint family properties,
Oh, what will happen ultimately? What is how, if this way or that way?
because it goes contrary to my pleadings, my lord.
No, that is his case. So now when the issues are framed, an issue will be framed that whether the defendant has, whether the burden will be cast upon him.
No, burden will be placed on me only. Burden will be, suppose he claims in the written statement, I have no objection, but ultimately the burden will be placed on the defendant.
Yes.
But here, what happens is, if I included those properties in my plaint, burden will be cast on me, my lord.
Please to the respondents, petition is permitted to take out hand summons and shall file a memo to that effect. Once a memo is filed, list the matter.
Cell number 15.
Stay of the matter.
Your suit, why should it
No,
be
already
stayed?
one matter is one submission. One property, the proposed property, my lord, is subject matter of compromise petition. That was also allowed. Even the defendant is forcing that to include that property also to the.
No, now I'm issuing notice. Once they come up, the matter will come. Why should yours stay?
Any date may be fixed, my lord.
Please, if the memo is filed, list this matter on 30th of July.
I may permit to serve through the.
Hand summons.
Cell number 15. Narasimha. S. Narasimhan.
No representation, list this matter in the month of September.
Cell number 16. Shilpa.
Petitioner.
Numbers for petitioners.
This is the suit for partition filed in the year 1995, and after the full fetch of trial in the 2008, it has been declared as 1/8 share. And subsequently, the petitioner has filed the FDP proceedings before the trial court in 2011. And till today, the case is being continued on. In the 2020, Honorable High Court, the same court, has directed the trial court to expedite the process of public auction, expedite the process of FDP by sale of the property by way of public auction. And it has been stipulated time of 2 months. So.
When is that order?
That is order Annexure C, my lords, page number 69. Page number 69. And later, due to pandemic of COVID, the process has not been able to complete it. And once again, the petitioner seeks since the scheduled property is completely dilapidated condition. My lords, why is the direction has been issued, my lords, in this matter?
I am not issuing a direction. The petition is filed to expedite the final decree proceedings in FDP number 94 of 2020.
Then 1 month I am seeking, my lords.
Because we submitted that earlier earlier orders were passed.
Because
by the court to dispose of the matter within 30 days from the date of said order. It is a grievance that even till now the FDP proceedings are pending. The Registrar Judicial is directed to call for a report from the concerned court. Why, in spite of an orders passed by the court, the FDP proceedings are not disposed of. List this matter on Monday.
Oh.
Today is Thursday. List this matter on Wednesday.
Okay.
Yes.
Number 17. Uday Prakasham for petitioner.
Judgment.
What has happened? The judgment referred by the trial court. That is a coordinate bench judgment.
Let's see that.
Which is against me. Which says, but the division bench judgment, my lord, it's.
That we'll see. Both will see.
Both I'm placing both. And one, the previous judgment also, 2006 judgment, which. What?
This judgment goes against you.
That judgment goes against me.
Where is that?
That is the first,
Paragraph number?
His Lordship Justice Suraj Govindraj. said that.
Paragraph number?
That, my lords. That's at the end, my lords. At para 9. In the present case, it is not that surveyor who was asked to survey the property is not competent to do any of the above. The only contention taken is that the ADLR could not have delegated the survey work to the surveyor. By the very designation of the officer as surveyor.
I've seen that. Then please come to the division bench order.
Division bench judgment, my lords, is that is para 15, my lords. Did my lords. Looking into the records, the actual commission work was executed by the Taluk surveyor and not by the ADLR. Undisputedly, the Taluk surveyor was not appointed by the court as a court commissioner for partition of the agricultural lands. As per order 26 of the Code of Civil Procedure, the court appoints court commissioner as an officer of the court to do certain acts, and such acts done by the commissioner is as good as the court, as of the court. Under such circumstances, the court commissioner himself was delegated to do certain acts personally or under his personal supervision. He has no authority to redelegate work assigned to him by the court. Any such acts of the court commissioner would be illegal. The ADLR has not done the work.
Then counsel for the petitioner submits that when the court has passed an order directing, appointing the ADLR as a court commissioner, but the same was delegated by the ADLR to the
town surveyor.
It is submitted that is contrary to the order passed by the court. He relied on a division bench judgment in arising out of RFA number 1004998 of 2024, dated 29th January 2025, in case of SHR Sri Shail versus Basvaraju and others, wherein the division bench has observed that when the court appoints an ADLR, he cannot delegate the work, and the acts of the surveyor in executing the commission work is nothing but without any legal authority. The trial court, while dismissing the application, has considered the judgment of a coordinate bench of this court in Krishna versus Srimati Sevanta and others, arising out of WP number 1000056 of 2024, dated 4 January 2024. In the light of the division bench judgment, there shall be stay of all further proceedings pursuant to the order dated so and so, so and so. Same notice. In addition, hand summons memo shall be filed by 23rd July, or else the stay granted with this court stands vacant.
Number 18. 18. Mohan Kumar D.
Let's appearing for petitioner Mallards. Let's I am the defendant before the trial court Mallards. Let's the plaintiff has filed IA number 7 under order 39 rule 10 Mallards. It has been allowed by the trial court Mallards. Let's may read the IA number 7 Mallards, which is at page number 33. Mallards, they have prayed this honor pleased to direct the defendants herein to pay the admitted rents in the respect of suit schedule property.
What is the suit
covering
for?
Suit for eviction and eviction Mallards.
Are you admitting that you are the tenant?
Mallards, I am admitting that I am the tenant.
And also the rent?
No, Mallards, I have specifically denied Mallards. I have produced the.
Then without paying the rent, how?
No,
how
no,
you
Mallards.
become a
The what
tenant?
has happened, Mallards? My husband was the originally leasing Mallards. My husband has expired. Mallards, they are claiming the rents which has already paid by my husband, Mallards. That is the issue, Mallards. That has to be divided.
When your husband died?
Mallards, in the year 2024, Mallards.
Give the date.
Mallards, only. Mallards, 14/5/2024, Mallards.
So after that, have you paid?
Mallards.
After that, after his death, have you paid? Is it your case?
Mallards, no, Mallards. I have not.
So you need to deposit at least from 14/5/2024.
Yeah, Mallards, what has happened here, Mallards? That's after the death.
They're also asking 15/7/2024.
Yes, my lords.
And that is after the death.
My lords, 15/7/2024 to 14/8/2025, my
So
lords.
your husband died on 14/5/2024.
Yes, ma'am.
They're seeking writs from 15/7/2024.
Let's hear the what happened is, Melas, the issue is, my husband has invested huge amount of 12 crores, Melas, in the property. And now, Melas, the plaintiff has not allowing us to do the peaceful business, Melas. Due to that, Melas, everything as the business has collapsed now, Melas. It is a big chowdhury and farmers has been constructed my husband. Millets, what we are seeking, Millets, as a out of court talks also, Millets, we have sought to settlement, Millets. We have invested huge money, and my husband has expired now. Millets, at least we are asking for a settlement that some amount may be returned off, which we have invested for the Millets, and we are ready to vacate the premises also.
Got a notice, sir.
Millets,
Notice.
Millets, no, and summons may be served, Millets.
Notice, in addition, and summons.
May be permitted to serve on the trial court. Its
Also,
date may be fixed, my lords.
if the memo is filed by 29th of July, list on 30th.
Much obliged.
Serial number 19, Ashwath CM.
For petitioner, my lords. My lords, this is the petition filed by the defendant before the trial court, my lords. Against the petitioner, I am the purchaser of the suit schedule property, my lords, and for some reasons I could not file the return statement, my lords. Thereafter, I makes an application seeking permission to file the return statement, and
after how many years?
My lords, I was out of town. It is 2.5 years, my lords.
Notice.
My lords, may I make one submission, my lords? In this, the contesting defendants are respondents are only respondent number 1, my lords. For 2 to 23, it may be dispensed, my lords.
The memo is filed seeking dispensation of notice to respondents 2 to 23. Petition is permitted to take hand summons on respondent number, counsel appearing for respondent number 1 before the trial court, and shall file a memo to that effect. Yes.
Well, it may be posted on Monday, my lord, because the matter is posted before the trial court on Monday for defendant arguments, my lords. So before that, I will serve the summons and furnish before the your lordship.
But I should have the time to hear all that now.
Any short accommodation, my lords, because matter has been
Every
posted.
matter, if short accommodation, how many matters I can?
I understand you.
Hear? Not possible. Yes, next.
Any date in the next week, my lords.
Not in the month of July at all. Yes.
Serial number 20,
For the petitioner, suit for money recovery, I am the defendant. I have filed an application for extension to file a return statement. That application came to be rejected.
What is the delay?
120 days, 4 months.
After 120 days, 4 months.
Oh, yes, my lord.
Then counsel for the petition submits that. There is a delay in filing the written statement. And the court has failed to take the written statement on record. Seem that a coordinate bench of this court, the similar orders are there. That the amendment provides that same order. Yes, notice same 23rd. They have to file the memo.
Serial number 21, Mahesha BJ.
What the plaintiff's writ petition, my lord.
Huh?
Plaintiff's writ petition. Application seeking amendment, pre-trial amendment, my lord. Evidence is not yet commenced. Initially, suit
of the year.
No, suit is of the year 2022. Initially, suit was, my lord, for the relief of bare injunction. It is my contention that taking advantage of the fact that there was no ex parte order of injunction was granted, subsequent to the filing of the suit, the defendant has encroached some portion of the property and put up a construction. Then I have sought for the relief of this, the declaration, mandatory injunction, and also specifying the extent of the encroached portion as item number 2. But the trial court says, my lord, it changes nature of the suit, and there is a limited, the relief sought for is
comes to the conclusion, prayer sought by the devout to protract the proceedings, and which will cause injustice. Which court is this?
I have just elaborated, my lord, contention regarding my title, since because I am adding the relief of declaration.
You're seeking your declaration of title basing on a
No,
compromise.
that is
suit.
not, my lord, that is not correct. I say, this is the portion which
Let
was,
us see your application.
Yes,
Come to
ma'am.
the application.
this is the portion which was allotted to me.
Page
That was my
number.
contention.
Page number.
The application is at annexure, my lord, D.
Definitely, you cannot take source of your title
No, my
from
lord,
that
that,
and now seeking
that I have also
declaration.
stated in my injunction suit also. In earlier plaint also, I have stated about that. That
Please
is, my lord.
please come to your affidavit.
Yes, my lord. Annexure D, my lord,
Let's
page
see the affidavit.
30.
Yes.
Affidavit, yes, ma'am. Page 38, my lord. Paragraph 2. I further state that as on date of filing the suit by accidentally unable to clarify the boundary of suitable property of item number 1 in certain side of the
They have
same.
denied your title to the property.
That I have stated in the,
No, the defendants have denied your title.
they have denied my title.
Please come when
taking
counsel
the,
with petitioner submits that. The suit is filed in the year 2022 seeking injunction. And it's a case that the defendants have denied the title of the plaintiff and also they've occupied a portion of the suit scheduled property. In those circumstances, he has filed an IA seeking declaration
and mandatory injunction to remove this
mandatory
structure.
injunction. And that came to be dismissed by the court, that it is a belated application. It is submitted that the trial is not yet commenced, considering all this, there shall be stay of all further proceedings, and so, pursuant to so and so. Same notice, hand summons, 23rd, or else a stay granted with this court stands vacated.
Cell
Yes,
number
22.
22, Subha Reddy Kane, for petitioner.
For the petitioner in this matter, my lords, seek for a short passover, my lords. seen
Yes,
as on
passover
the-
next.
Cell number 23.
My lords, I'm sorry, my lords. Can I make one submission? I'm sorry to intervene, my lords, in the list. My lords, in the Dharwad bench matter, serial number 3, I have filed my wakalat.
Can you come at
My lords,
12:35 and make, I'm sorry. Yes, call the list.
Cell number 23.
Lord, petitioners, my lord. This is an order, my lord, challenging. The suit, petitioner is a defendant in the suit in the court below, my lord. There is an order that was passed on 19th of June, my lord, wherein the interim order was previously, which was not granted, which was pending consideration to be passed after hearing both the parties. Lord, on a false submission by the defendant, plaintiffs, my lord, an interim order was passed until the report of the court commissioner is going to be filed. Now, what has happened here? Not a court commissioner has not issued any date fixing the schedule or a date to inspect the property. Meanwhile, there was also a direction to appoint one of the surveyors of Taluk surveyors as the person to measure the property. So the Taluk surveyor was also not been appointed by the Tahsildar. So that being the position, and in the absence of the defendants, this order comes to be passed. So which is saying that, there should be an interim order not to put up further construction in the property. That particular
Come to the order.
at page 26, my lord.
Case called out.
Please, madam. Plaintiff is present. Promising for the plaintiff submits the defendants are deliberately evading the completion of commission work and are making hectic efforts to put up permanent structures over the suit scheduled property. With these, prayed to restrain the defendants from putting up further construction or activity over the suit scheduled property till the completion of the commission work, and also played for police protection. So then going forward, my lord, in the case on hand, the plaintiff specifically claimed the defendants are encroached the
You
portion.
have not entered appearance.
I have entered appearance, I have filed my written statement, objections to everything that has been recorded. Thereafter, this particular order of appointment of commissioner was passed on 2nd of May. Then these particular things happen. In fact, my lord, if I may request my lord to have a look through.
Oh, the court has granted temporary injunction.
That was, see, my lord, initially it was not granted. Notice was ordered.
Who? Now by virtue of this order,
please, my lord.
court has granted.
Please, my lord. It is not this. Either it should have been heard and both the
That's
parties.
what I'm saying. By this time you have entered appearance.
Please, my lord.
You were not heard.
I was
You
not
were not
heard.
present on that day.
On that time when it was called, I was not present. So this order came to be passed even after filing of my, almost 1 month before I had filed my objections and everything. And the one shot, another issue, my lord.
Only restrained the putting further or any other action. Completion and work. So far as the police had concerned.
And another question is that, my lord, the question of encroachment, Lordship may turn to page 46. That extent of the land, what is being claimed by the plaintiff has already been encroached by.
Land counsel appearing for the petition defendant submits that. Initially, the court has not granted injunction, and after the defendant entered appearance, they filed the written statement. And when the matter was called on 19/6/2026, court has granted the injunction restraining the defendants from putting up further construction and till completion of the commission work. So far as police are concerned, the plaintiff is at liberty to approach the jurisdiction police for warrants. It is submitted by the learned counsel for the petitioner that the court without an IA, giving an opportunity to the defendants to file their objection, and without an opportunity has passed this order. Considering the same, there shall be the order dated 19/6/2020, the operation of the order dated 19/6/2026 is stayed till the next date of hearing.
Another matter, my lord, serial number 28.
Huh?
There is another matter, serial number
Same
28.
order?
Same order, same connected
20?
petition, 28, my lord.
Same order in that,
Same
just look at any of numbers won't change. Yes, same, in hand summons 23rd memo, yes.
Cell number 24. 24. Sheikh Rappa for petitioner.
Appear for the petitioner, my lord. Plaintiff filed this petition, my lord. Plaintiff filed suit for declaration and recovery of position, my lord. The time of plaintiff evidence is completed, my lord. Posted for dependent evidence. At the time of my lord, dependent number 1 filed the application 26 rule 10(9)
Where is the order? Please come to the
page
order.
number. Annexure A, my lord. Page number 18, my lord. My lord, the suit for the plaintiff is one of the relief of declaration and.
So you have not reduced the evidence so far?
Not coming, my lord. Dependent.
Why you want Advocate Commission to be appointed?
My dependent filed the application is allowed, my lord.
Huh?
Dependent filed the application is allowed, the trial court, my lord. Application is allowed, my lord. That is my ground. Not commence the dependent.
For reasons, sir.
No reason. Matter post, now is posted but depend.
Learned counsel for the plaintiff submits that even before the trial has commenced, basing on an application filed with defendants, the court has appointed the advocate commissioner. Is nothing but for collection of it amounts to collection of evidence. Considering the same, there shall be stay of all further proceedings pursuant to the order dated 21st February 2026 by the principal senior civil judge JMFC at Sierra, invoice number signed.
Notice.
Same hand summons and memo shall be filed by 23rd or else a stay granted by this court stands.
Notice is dispensed, respond number 3 to 6, my lord.
Huh?
Notice dispensed, the respond number 3 to 6, my lord.
Give it. Memo is filed seeking dispensation of notice to
Respond number.
respondents 3 to 6. Hand summons to respondents number
1
and 2. Yes.
Cell number 25. YP Vijay Vasanti Kumari.
In this case, I appear for the petition, my lord. The petition is the plaintiff invoice number 25118 of 22, my lord. He filed a suit against his father and brothers, that is respondents 1 and 2, and father has been deceased during the pendency of the suit. For the suit for the relief of partition and separate possession in respect of their joint family properties, my lord. The first and second defendants, that is deceased father as well as the first respondent herein, have filed a written statement. Then separate written statement has been filed by the second respondent herein, claiming some of the, by setting up a counterclaim in respect of the properties which are situated in Andhra Pradesh for the relief of declaration that he is the absolute owner, and also for cancellation of the sale deeds which are not binding on him, which have been executed in the Andhra Pradesh, my lord. And he has set up a different dispute in respect of the properties altogether, the different from the suit schedule properties which the plaintiff has been claimed. The first respondent.
According to him, how he has acquired those properties?
He says that it is acquired by him as a self-acquired properties.
Then why should it be part of this suit?
That's what the second respondent.
The order impugned.
The defendant has filed an application under order 1, rule 10 to my lord.
Come to the order.
The order is at page number 20, my lord. Shall I read from the
reasoning part?
Pardon, my lord?
From the reasoning part.
The plaintiff has filed the present suit against the defendant number 1 to 3 for the relief of partition and separate possession of his 1/4 share in the suit schedule properties by metes and bounds and for other reliefs. In this suit, the defendant number 3 claiming that he is the absolute owner of plot number 171 and 172 and accordingly he prayed for declaration in respect of said plot number 171 and 172 by way of counterclaim in his written statement. Admittedly, the properties plot number 171 172 are not at all subject matter of the suit schedule properties. It is the submission of the learned counsel for the defendant number 2 is that the plaintiff, by misusing the general power of attorney given by the defendant number 3, had illegally sold both plot number 171 and 172 in favor of proposed defendant number 4, and he in turn sold the same in favor of proposed defendant number 5. However, the defendant number 3 had no intention to sell the said properties as there was no need for him for any financial assistance as he is working at Australia and getting handsome salary. The plaintiff and proposed
Suit is for partition.
Pardon, my lord?
Suit is for partition.
Partition and separate possession.
That counterclaim is allowed?
That application has been allowed. The order 1 rule 10(2) has been filed by the first respondent as a GPA holder of the second respondent. Those properties are situated at Andhra Pradesh and they are not the subject matter of the suit. And the proposed defendant, that is 3 and 4 respondents herein, are no way connected to the either to the parties or to the suit schedule properties. And simply by making them as a parties, the suit will be defeated, my lord.
When counsel for the petitioner submits that.
IA number 2 of 22,
The
my
suit
lord.
for partition, the court has allowed IA number 22. IA number 2 or 22?
Also. Yes, my lord.
IA number 2.
IA number 2 of 22.
IA number 2. I've allowed the IA number 2 of 2022, filed under order 1 rule 10(2), read with section 115 CPC, where the parties are setting up a counterclaim in respect of the properties which are not the suit schedule properties, and claiming that they are the self-acquired properties, and seeking a declaration in respect of those properties, and also to set aside the sale deed.
Sale deeds.
Sale deed, which is
And also for
situated in-
permanent injunction in
also, which is
against all
situated
the
in,
parties.
Andhra Pradesh, and also for permanent injunction. We submitted that this is nothing but enlarging the scope of the suit for partition, and all these aspects need not be decided in a suit for partition, and the petitioner can file a separate suit considering the submission. Stay, notice, hand summons, 20 by 23rd memo shall be filed, or else the
Your
stay.
lordship may kindly order for issue of notice to the respondents, my lord, because their advocate is not representing over there.
Here.
And also
You don't want
parties
to
are
take
also-
hand summons.
No, my lord. Let the notice be ordered for them.
Who is appearing?
One advocate is appearing for the respondent 1 and 2 for the impleading, that is respondent 3 and 4.
Respondent 1 and 2 hand summons.
Yes, my lord.
For other respondents notice. Yes.
Bill number
Much
26.
obliged. Stay may kindly be granted.
Yes.
Stay may kindly be granted, my lord.
Stay granted. If you don't file the memo of 1 and 2 by serving the hand summons, it will be vacated on 23rd. Yes.
Much obliged.
Bill number 26.
My lord, appear for the petitioners in this case, my lord.
Hmm.
Suit for declaration and permanent injunction against the defendants, my lord, not to put up any construction in the suit schedule property. My application under Order 39 Rule 1 and 2 was allowed by the trial court, and the same was confirmed in the High Court of Karnataka. Thereafter, my lord, the defendant number 8, the respondent number 8 in this case, my lord, he approached in filing MFA challenging the order of temporary injunction in MFA number 6109 of 2016 as per Annexure E, my lord. There, the High Court didn't interfere in the order of temporary injunction against defendant number 8 from putting up any construction in suit schedule property. And my lord, there he has undertaken by filing a memo and affidavit saying that if he is putting up construction in suit schedule property, he will not claim any equity in future. That undertaking was taken on record as per Annexure E by the Honorable High Court of Karnataka.
That means the court has let him to make construction.
Permission was not at all granted. In case if I am proved,
Where is a question of claiming equity unless the court permits him to construct?
permission was not granted to solve.
If the permission is not granted, there is no reason to file an affidavit also.
Thereafter, that's why, my lord, thereafter, we filed application for examination, spot inspection. Commissioner, that is Assistant Director Land Records, has surveyed the suitable property and found there is encroachment, and he has put up the construction. And here marked the extent of construction put up by the defendant number 8. Immediately thereafter, I filed application for amendment of my prayer for seeking possession. It's only the prayer, because suit for his declaration and permanent injunction. In spite of injunction order, he has violated, and in view of change of circumstances, I sought for amendment of my plaint.
Come to your affidavit.
Yes, madam. My affidavit, application. Yes, annexure, my lord. G, in page number 58, my application, it is in Kannada. I have stated in detail by basing on the commission report. I have exactly mentioned of what extent he has encroached and put up the construction.
If you tell the court what is the crux of it, that is not sufficient. I have to look at that affidavit.
Yes, madam. Yes, madam. Definitely, madam. In page number 58.
File the affidavit.
It is in
The translation you need to file.
That's
because without understanding that, I'll not be in a position to appreciate the case.
Yes, one more point, my lord. I've stated the grounds and exactly mentioning the ground for amendment of plaint, but the trial court in the impugned order not discussed any point.
That's why we will discuss it. Please file your, the council shall file
My lord,
the amended
my lord,
copy,
matter is posted.
typed copy of the
I'll file today itself, my lord.
translated. Tomorrow I will take up.
Urgent similar, it's posted for final arguments.
When is it posted?
Day of tomorrow, 4th, my lord.
Tomorrow I will take, that's what I'm saying. Tomorrow I will take up if you place the translated copy.
By 2:30, my lord. I can do it.
That much of hurry is not required. This is matter tomorrow in the first list. The petitioner shall place the translated copy of the affidavit that is filed in support of the yes.
Yes.
Number
Much obliged.
27.
27.
Mahesh
I
Shetty.
appear for the petitioner in this matter.
Yes.
My lord, I am a CL9 licensee.
Mm.
My lord, I have a valid license. If your lordships could kindly peruse, my lord, annexure.
Is it the same like the other matters?
No, no, no.
It's a different
Here,
one.
what has happened is, my lord, on 18/4/2026, my lord,
Please come to the prayer. I'll understand from the prayer what
please,
what
my
is
lord, I have
seeking.
sought for quashing of the order wherein the revenue DC exercises his powers under section 29 of the Excise Act.
Suspending the license for a period of
Yes.
30 days.
Yes. Here,
Against
what-
it, so you don't have an appeal?
My lord, appeal is, there is error of jurisdiction because revenue DC doesn't have that power at all.
Revenue?
Revenue Deputy Commissioner, he's a regular revenue DC.
Who has
My
the
lord, it is
power?
for the license issuing authority. Here, license issuing authority is the Deputy Commissioner of Excise. Section 29. may
I'll
kindly
demonstrate, my lords. There is a serious law and order problem here. There is a murder which has happened in the bar. So for that reason.
No, 1 minute. No,
My lord,
suspension of license.
Please.
Who is competent? That's for, let's
My
have
lords,
the
I'll
clarity on
demonstrate, my
facts.
lords. I'll demonstrate, my lords. Section 29 of the Excise Act, my lords. Now, subject to such restrictions as the state government may prescribe, the authority granting any license. The word here is authority granting license, my lord. The authority granting license is described in Rule 5 of IMFL, my lords. Now, the
Who grants license?
the DC with the sanction obtained from Excise Commissioner.
here, my lord, if your lordships
But
could
according to
kindly.
the revenue DC will grant.
My lord,
Yes, please.
annexure A and B. For that reason, my lord, I requested your lordships to look into
Grant
the-
of license.
One nimsh.
Let's see what you're saying.
Annexure A may kindly be looked into, my lord.
Power to cancel or suspend license.
Yes.
Subject to such restrictions, so and so.
Granting authority has to cancel.
And the authority granting any license or permit under this act, then you're relying on Rule 5.
Rule 5
Yes,
of
let's see.
Sale of Indian and Foreign Liquor Rules, 1968. Rule 5, my lords. Rule 5 of Sale of Indian and Foreign Liquor Rules, 1968. The marginal heading says as grant of license.
1 minute. You said the rules are called?
Sale of Indian and foreign liquor rules. My lords, I'll give you a copy.
On receipt of the application under Rule 4 and subject to the provisions specified in Rule 4A, the Deputy Commissioner or the Excise Commissioner,
Yes, yeah.
as the case may be, may require such other particulars as may deem necessary and may make inquiries for verification of the particulars furnished by the applicant and also such other inquiries as he deems fit. If the Deputy Commissioner or the Excise Commissioner, as the case may be, is satisfied that there is no objection to grant the license applied for, he may grant the license on payment of the fee prescribed.
Yes. If it is read along with 29, it is for the issuing authority. My lord, here there are two cases wherein the Deputy Commissioner of Excise can issue the license or the Revenue DC can issue the license. In my case, it is the Deputy Commissioner of Excise who has issued the license. And it is for him only to cancel and not to the Deputy Commissioner. That is what the provision says. My lord, section has to be, rule has to be read along with the section and not in isolation. And with regard to this particular case, what has happened is, my lord, on 18th, after the bar closed down, my lord, there was some outrage in the between customers, which resulted in one person pushing him from the steps. He fell down and he expired. Voluntarily, we closed down the shop. We cooperated with the investigation. Till the investigation, completion of investigation, my lord, we voluntarily closed it. We brought to the notice of the Excise Department also, indicating that we are closing the shop in view of this incident. We were permitted to open. We opened. Now, after lapse of 2.5 months, my lord, now they say there is a law and order problem, you close it. And suspension also, initially they issue a show cause notice. Same replica, there is no reasoning also, if your lordships could kindly see. Now, moreover, it is a error of jurisdiction. Whatever the terms and conditions with regard to law and order, we will abide by that. My revenue is at loss, my lord, because already I have closed it for 1 month during the period of investigation. Now, once again, my lord, if I am...
Where is the order?
My lord, order, your lordship should find it, my lord, annexure. L, my lord. Initially, they pass an order at, my lord, annexure. That is the first show cause notice, suspending for 2 days. Immediately thereafter, same notice, 30 days, they have suspended.
However, there is an appeal provision, my lords.
My lord, appeal provision, if there is error of jurisdiction, my lord, I need not have to prefer an appeal.
Lord,
if it is a jurisdictional
DC
error.
Revenue is the head of the district.
No,
He has all the powers, my lord. DC
The Act
Revenue.
contemplates that it is for the...
DC Revenue is the head of the district, my lords. He has all the powers, my lords.
Power, my lord, it cannot be arbitrary exercise.
What is the law and order problem?
There's a murder, my lords. There's a murder happened. To that effect, FIR is being filed here. And investigation is going on, I believe. I lack instructions in that case, my lords.
No. Some untoward incident has taken place and somebody died in that mishap.
Please.
But what is the reason for cancelling his license?
Beyond license hours, my lord, they were opened the bar. If you see, my lord.
That you issued a show cause notice.
No, that apart, my lord, the police.
Have you issued a show cause notice to him saying that contrary to the terms and conditions of your license, you are running the bar?
And moreover, the
1 minute, let him say. And is it have you issued a notice to him?
No, my lords.
And if some incident happens at a place where there is no contribution from this person, you cannot call it that it is a law and order problem.
My lords, kindly see page number 16, my lords. The conditions imposed in the license itself.
That's what I understand. You say that a particular.
Beyond 11:30, my lords.
But where is the show cause notice for that? That should be the show cause notice.
Lords, the offence is cognizable in nature.
No. You're not dealing
it's a
with
murder, my
criminal
lords.
one. Police will take it about a cognizable offence. Excise department is not concerned with it.
But still,
Your
the
license-
DC excise, DC revenue I'm talking about.
Whoever it is, if you have to suspend the license, there should be on violation of the terms and conditions of the license. For that, you should have issued a show cause notice to him saying that beyond the hours, you are running the bar. Because of that, it resulted in an untoward incident. Nothing.
And they
But that
permit
is
me to
wrong.
operate
Going
for 2 months.
That way is wrong. You please, I'll post this matter tomorrow in the first list.
Please.
Get instructions. Now, I will set aside this order.
Please.
Whatever you follow the procedure will not preclude you from following the procedure.
Please.
Get instruction.
Please.
Tomorrow. AGA accepts notice on behalf of all the respondents. List is marked tomorrow in the first case.
Please, oblige.
The AGA shall get specific instructions. Yes.
Serial number 28 order, 29. Serial number 29.
Yes.
Sarah.
Petitioner in this case, my lord. The respondent in regular appeal was before this honorable court, my lord. The respondent petitioners are the plaintiff before the trial court. By suit for declaration and permanent injunction was came to be decreed. My lord, defendant approached filed the regular appeal, my lords. After filing the appeal, after lapse of 5 years, my lords, he filed application seeking amendment of the written statement. That application was allowed, and the trial court, for limited purpose, remanded the appeal to send back the file to the trial court to record the findings on the issue of the limitation. So, but kindly see, I am produced the application, my lord, at annexure E. Trial court exercise, the appellate court exercise power under Order 41 Rule 5.
Let's see the impugned order.
Impugned order is in Kannada.
So what?
For a moment, my lord, I kindly see the application, my lord, for a moment. This affidavit, the seeking amendment of.
I have to understand what is the order.
Please.
So what do you want the court to do now?
If the lordship see the application, my lord.
So by seeing the application, I can't visualize what has been.
Please, is
written by judge.
the filed application for amendment of written statement,
File
my
the
lord,
translated copy.
on the ground that
When can you file the translated copy?
day after tomorrow, master.
Day after tomorrow in the first list.
Yes.
At the request of counsel, the petitioner, petition shall place impugned order as well as the application that's filed in support
Application
of the
is in English only, master.
Then the impugned order.
Only impugned order.
Yes. Translated copy of the impugned order. Yes, next.
6, 7. Yeah. Saturday.
7.
Saturday, sir.
Day after tomorrow is, what is
Saturday.
Monday, list on Monday.
Serial number 30. 30. Deshmukh.
Appear for the petitioner. Lord, this petition is filed by the decree holder before the executing court. Lord, the decree holder filed execution proceedings seeking to enforce an arbitral award, Lord, dated 1/4/2022. By the arbitral award, my lord, a sum of about 9.86 lakhs was awarded to the decree holder, along with interest at the rate of 18% till a certain date and 10% thereafter. Lord, after the award was passed, in the month of October of 2022, a memorandum of settlement came to be executed between the decree holder and judgment debtor. The decree holder was given to understand that the judgment debtor may become insolvent. Therefore, a settlement was, the awarded amount was, quantum was reduced to 7 lakhs. And a timeline was fixed for payment, my lord. By March 19th, 2023, all the sums ought to have been paid under that compromise, the memorandum.
By March?
March 19th, March 2023, my lord. A 6-month window was fixed. Till 20th of March 2023, no amounts was paid. On 20th March 2023, a sum of rupees 2 lakhs was paid. The balance 5 lakhs remained unpaid. Thereafter, my lord, there was absolutely no payment made, which required the decree holder to obtain the award from the center by paying the fees that the judgment debtor had not paid. Then thereafter pay the stamp duty on an application filed by the judgment debtor before the executing court, and thereafter execute the award. Now, during the execution proceedings, the application is filed under section 47, my lord, seeking an inquiry to discharge the liability of the judgment debtor under the alleged memorandum of settlement. Two applications came to be filed. First, the same application was filed, registered as IA number 2. May request, the order was passed, that application was rejected. May request.
Which order is impugned before this court?
A second application, similar application, Annexure L, my lord. That is also under, the first one was dismissed with an observation in the order saying that 5 lakhs, admittedly 5 lakhs itself is not paid. Therefore, if that is the version of the JDR, he ought to deposit that 5 lakhs and then come seek the necessary order. Also, there was a finding that this is a valid arbitration award. The decree holder is entitled to execute this decree. My lord, After that finding, 5 lakhs was deposited, and then another application came to be filed. Against this application, my lord,
Let's see that impugned order.
please, at page 122, the reasoning begins at 124, my lord, para 4. No points for consideration, but the reason is, may I read, my lord, para 3.
In order to execute an arbitral award, pass and serve award order for the present execution petition for the 2 years.
Para 4, may I read? Not the
1 minute. So without paying the amount, he wants the discharge from the.
Please, my lord. Our objection was that, my lord, since the twofold on facts and also on the procedure to be as contemplated by Order 21 Rule 2, any compromise or adjustment of a decree or award was to be certified and recorded in the manner provided therein. That objection was raised and the judgment of Honorable Supreme Court was placed. That judgment is cited, my lord, at para 7. And in fact, it is quoted also, but the finding is completely contrary. May I read, my lord? Para 7, about the 10th line, my lord, it says the Honorable Supreme Court held that Honorable Supreme Court held that an uncertified payment of money or adjustment, which is not recorded by the court under Order 21 Rule 2, cannot be recognized by the executing court. The Honorable Supreme Court further held that in a situation like this, the only inquiry that the executing court can do is to find out whether the plea taken on its face value amounts to adjustment or satisfaction of the decree wholly or in part, and whether such adjustment or satisfaction had the effect of extinguishing the decree to that extent. Well, there is a word missed out in the next sentence. The Supreme Court said if the executing court comes to the conclusion that the decree was adjusted wholly or in part, but the compromise or adjustment or satisfaction was not recorded and are certified by the court, the executing court would not recognize them and will proceed to execute the decree. The finding of this, the executing court, my lord, is at para 13. Contrary to this.
Please come. When counsel appearing for the petitioner submits that. The court has framed the issues and proposed to conduct a summary inquiry on an application that's filed under section 47 of the CPC. It is submitted that the same is contrary to the settled law. And the court has only appreciated part of the judgments of the Honorable Apex Court referred to in the order. Considering the same, they shall be stay of all further proceedings. So and so, question to the order. Notice to the respondents. Petition is permitted to take out handsome memo by 23rd, or else the stay granted by this court's transfer. Next.
Cell number 31. Anirudh.
Hearing for the petitioner, my lord. Senior is on legs, maybe passed over.
Passed over. Yes, 32.
Cell number 33, 32. Cell number 32.
For respondent 1, my lords, senior is out of station, my lords. Kindly a short
I
adjournment.
appear to the petition in the first matter, my lords.
You have an interim order?
There is an interim order, my lord.
Yes, this is matter in the month of September, interim order earlier granted.
I make one submission. In the first matter, there is no interim order, my lords. Your lordship in the last occasion had directed to serve a copy. I had served the copy. The issue is only this: an amendment application is filed. He himself said he is not the owner of the property.
How many times we will list these matters? How many times this will be adjourned? And every day morning, 100 people are ready. Advocates are ready with.
I am ready, my lord. He is seeking for a time. My
No,
only
you are
submission
ready,
is
he
that
is not
interim
ready.
order
I
might
can't
be
hear only you. I have to hear him also.
interim order might be at least granted to that extent, my lords. Apparently, in 32.1, there are 3 orders passed on the same order is passed on 3 applications. Order 1, Rule 10 is granted. Interim order is granted in 32.1. 32.
Will I grant interim order in 32 also?
Yeah, short accommodation.
On last occasion, why the matter is adjourned?
Matter was urgent to serve the copy, my lords. It's a clear matter.
Matter finally on Wednesday. On the day, if the respondent is not ready with the matter, interim orders will be granted. Yes.
Cell number 33.
In the first list only.
Cell number 33.
Interim order in second matter, kindly be.
Yes, interim order in 32.1, extended.
I represent the petitioner.
33, yes.
the respondent's writ petition before the Honorable Court in a second round of litigation, wherein, my lord, earlier partition suit came to be filed before the trial court. That came to be decreed. Thereafter, my lord, appeal filed, and thereafter it is concluded before the Honorable Court in RSC. During the disposal of the RSA, my lord, this Honorable Court found that, my lord, the improvements made by the petitioners herein has to be looked into and taken into consideration at the time of final decree proceedings. My lord, that was not considered by the trial court. Then in the FDP proceedings, we made an application before the trial court saying that what are the properties and what are the improvements made by the before the trial court. That was not considered and rejected the application. Against that, my lord, another writ petition came to be filed before the Honorable Court at Annexure F, my lord. Lakshmi, kindly see impugned order, my lord. This order passed by the.
Right.
Yes, ma'am.
And you're permitted to produce such document to show the improvements made.
Yes, my lord, we produce everything, my lord. In spite of it, my lord, the trial court, once
This is
again.
now after that, this is the impugned order.
Yes, my lord.
Come to the order, page number.
19. 19.
19. That is in 24 is the page.
Come to the reasoning part.
My lord, ADLR Magadi is hereby appointed the commissioner for carrying up so and so for demarcating the land and the subject feasibility party to the subject to the properties, commissioner fee of so and so is fixed. Straight away, my lord, without considering this fact, direction issued by this Honorable Court. Once again, it has been rejected.
After the matter is remanded by this court, what was the IA that is filed by you?
We filed an application.
Where is that?
My lord, that is application at Annexure E, my lord.
Page number?
Page, my lord, 67, my lord. And we have also evidence was given before the trial court. That was rejected, and it was questioned before the Honorable Court in a writ petition.
No.
These are the properties involved.
Where did you say about any alterations that are made to the property?
Please, my lord.
As per the order passed by this court,
Yes, my lord.
you have to place the necessary material with regard to the, what is that, adjustment or alteration?
Yes, that was produced before the trial court itself.
Where is the averment? Please
My
come
lord,
to the
evidence has been led into the trial court. That
68, 69, did you say anything about this?
Please, madam. In that, my lord, we have clearly stated, my lord, previous order has been passed by the Honorable Court.
Where is that? That I want to see.
That order has been produced before the Honorable
Not the
Court.
order, subsequent to the order, what is the application filed by you or what is the material produced before the court?
That was produced in the previous proceedings, my lord. Therefore, my lord, I'll produce that.
Not that. Please come to page number 70. This is a order. What did the court say? The court observed that
Yes.
the impugned order so and so is to the extent of rejecting the contention with regard to the improvements made by the deceased defendant number one by investing his hard-earned money
Yes.
is hereby set aside.
Yes.
Petitioners are permitted to produce any such documents to show the improvements made.
We have produced, madam.
Where are they?
That's already produced, madam. I'll produce the copies. Copy.
Now, if without any document,
Yes.
how can you say that
Right.
the court has
We have
not
produced the
considered-
document, right, for the sake, right, we have produced the documents and we have led in evidence and that was not considered and rejected. Thereby, my lord, the writ
Something
petition,
to show to this court that you have done something.
yes, my lord,
When?
I'll produce,
When can you file?
Tuesday, my lord.
Yes, what's the matter on
Well,
Tuesday in the first place?
13th, my lords. 13th, my lords.
13th.
But now they are hurrying the matter to the proceeding to the commissioner.
The order
Till
passed
such
on the
time, my lord.
application seeking appointment of commissioner, my
What is your
lords.
difficulty on this Monday?
Council on record is not in station, so that's 13th, my lords.
That is you.
No, my lords.
Anyhow, you are arguing today, the other day also you will argue.
On that day, I will not be, my lords. That's why, my lords, 13th, my lords.
This is the matter on, then don't precipitate the matter.
Let them not proceed it. Otherwise, my lord,
This is matter on 13th till such time, the respondents are directed not to precipitate the matter before the trial court.
Please.
Yes.
Bill number 34. Bill number 34. Parikshit,
Lord,
Yes.
appear for the petitioner before you. Lord, I am defendant number 1 and 4, my lord, in a suit which is filed by my lord, them, lord. Lord, your lordship will see in the plaint, they don't produce a single document, my lord. Now they claim to have purchased the property. Even that sale deed is not produced before the court along with the plaint. Suit, my lord, is for declaration, my lord. Injunction, I'm so sorry.
You're the defendant in the suit.
It's for injunction.
What is the IA that is filed now?
Now, initially they file a IA, my lord, for temporary injunction, which is granted, which I have not challenged, my lord. Now, I did not challenge it. My instruction is that I did not challenge it because, my lord, I am in possession. Though they claim that I am their vendor. My claim is that I am not executed such a sale deed and I have not parted with possession. Now, my lord, after the order is passed, now they file an application under 151 saying, give me police protection. And that is the order which is impugned before your lordship, where the court says,
When an order of injunction is passed.
yes, my lord.
Your assumption or your feeling that you are in possession of the property will not be the.
I agree, my lord.
It is an order of the court.
Lord, I
saying
agree, my lord, that we should have challenged. We should have challenged the order that is not challenged.
Order is passed by
But
the
what I'm submitting to your lordship is, without a finding that, my lord, I have either violated the injunction order. My lord, by giving police protection, my lord, I cannot be thrown out of the property, my lord. Now, my lord, I have also filed an application before your lordship, my lord, for appointment of a court commissioner, my lord. If your lordship, feel that, my lord, we have to ascertain.
What you are supposed to do, you don't do.
I don't
And
do
you
there.
can't-
I am.
We can't expect the.
No,
court
but
to do
what I'm,
something else.
Lord, what I'm submitting to your lordship is, my lord, that the injunction order, my lord, your lordship may kindly see what in the injunction order is at page index.
No, there is an order of the court.
Order page
For
15.
complying with the order, if police protection is required.
No, but except giving a police complaint, my lord, there is absolutely nothing recorded even by in this court. Lord, there is a judgment of this honorable court, my lord, which says that it cannot be, police protection cannot be granted. So, my lord, just for the asking, there should be a recording, my lord, of finding of fact that there was violation of the interim injunction, my lord.
Now he says,
Yes.
according as per the order of the court, he is in, when an injunction is granted, as per the order, he is in possession of the property.
Lord, that also, my lord, I can point out that that finding which is given, my lord, is not based on any material on record.
Cannot find fault with it because you have not.
Because I have not challenged it. I agree, my lord. But the point is this, my lord, can a person, my lord, who is not in possession, though he may get an order of injunction, lord, and my lord, throw me out by using police protection?
That is a very far-stretched
No, my lord,
issue that we can't deal
Lord,
with.
that's the reason why, my lord, we have filed an application also, my lord. Your lordship may order a court commissioner, some advocate of this honorable court, even today itself, my lord, to verify, my lord, who is in possession.
No, that is contrary to the order.
No, but then, Lord, if they have to, Lord, can a temporary injunction order be executed by taking police protection, my lord?
No, you have not questioned it.
No, they have not even. Please see their application, my lord. They don't even say, my lord, kindly see the order impugned. There is absolutely nothing which says, my lord, that I have violated the injunction order and I have tried to dispossess them.
Defendant cannot say that I'll keep quiet when an injunction is granted and when police protection is granted, then he will awake.
They challenge my sale deed, they suffer a decree. They challenge my sale deed, they suffer a decree.
No, the decree is pending. Suit is pending.
OS, my lord, 196 of 2021.
Is decreed.
My lord, is filed by my vendor for cancellation.
Is decreed.
No, it is not. It is pending, Lord.
Huh?
It is at evidence stage. It is pending. Lord, after this suit, when they claim to have purchased.
What do you mean by suffered a decree?
My lord, they suffered, the suit, my lord, which they filed. My lord, it got dismissed.
When?
My lord, two suits were filed. My lord, one Giri Gowda OS 128, that got dismissed and it is in the appeal. And subsequently, please, my lord, the person who sold the property in my favor, they filed a suit for cancellation, my lord, which has got dismissed.
No, my lord, it is pending. I can show just now, my lord, it is still pending. Partition suit, I am not even, Lord, partition suit is by other family members.
Page 42, para 14.
Yes.
Page?
42, para 14.
There is no para 14 here.
Page 42, para 14.
Probably,
Plaintiff has
Page-
produced the certified copy of the order in IA number 1 in so and so. Jayamma
IA.
has filed. IA number 1, I stand corrected, my lord. IA number 1, they filed a suit for injunction, my lord, which got
No, I have,
dismissed.
my lord, there, my lord, I have sought a declaration that, my lord, I have not executed the sale deed. This is a false sale deed which is fabricated. Now, please see just a few lines before that, that is page 47, my lord. Para 13. On what ground, my lord, the possession is held to be in their favor? Totally based on, my lord, some other person's statement. But plaintiff has also produced a compromise petition filed by Giri Gowda, Shivanna Puttalakshmamma. Now, my lord, the person who they say who has sold the property is Jailakshmamma and Ramakrishna. Jayamma and Ramakrishna, my lord. On perusal of the above compromise petition,
As far as order dated 9th July 2024 is concerned, we will not even look
no,
at it.
my lord, your lordship.
Please come to the present order.
Yes, my lord.
Where is the present impugn order?
My lord, that is at page 14,
Yes.
Annexure A.
We'll see.
Please come to page 15, para 2, my lord.
Yes.
In the affidavit annexed to the application, the plaintiffs have averred under order 39 rule 1 and 2 seeking a temporary injunction against the defendants, restraining them from interfering with the peaceful possession and enjoyment of the suit scheduled property. Said application came to be allowed. Against the said order, defendants have not preferred appeal. When the situation thus being, the defendants, in spite of said order, are causing obstruction for peaceful possession of the over the suit scheduled property by the plaintiff, and they disobey the court order and breach terms of the court order. Hence, the plaintiff has approached the jurisdictional police, but in vain. But the police have issued NCR and orally advised the plaintiff to bring the order from the court to give police protection. Hence, she has filed. But absolutely, there is nothing to show, my lord, that I have violated. If I have violated, my lord, there should be an inquiry. There should be an inquiry, my lord, whether I have violated or not. Now, please see the findings also. Reasoning at page 17, paragraph 7, my lord.
Yes.
The plaintiff has filed the present suit for the relief of permanent injunction against the defendants in respect of the suit scheduled property. In this case, the court allowed the IA number 1. Further, this court has passed an order by restraining the defendant, their agents, or anybody from acting on their behalf from interfering with the peaceful possession and enjoyment of the suit scheduled property by the plaintiff. Against the said order, defendants have not preferred any appeal. Moreover, further, it appears that there are so many litigations are existing with regard to the property. In OS number 128, right of the present plaintiff has been upheld. My lord, this again, my lord, if your lordship will see the plaint.
The court is referring to the injunction order probably.
My lord, I'm so sorry.
Court is referring to the injunction order.
Injunction order. Yes, my lord. But what I'm submitting, my lord, for your lordship is that, my lord, if you're, even if your lordship dismiss my writ petition by, clarifying that the police will not use this order to dispossess me, my lord, I am satisfied. If your lordship.
That will frustrate the order of.
No, to dispossess. I am saying, my lord, the police will not use this order to dispossess the person in possession, my lord.
Then you are accepting that after the orders are passed, you have.
No, my lord, I have not. Lord, my case in the written statement itself is.
Without questioning that order, your client cannot have any kind of relief from any of the courts.
My lord, I would submit, my lord. Now, please see, my lord, I have referred to, my lord, this judgment of this honorable court at page 18, my lord. Please just see that. Lord, that unfortunately, my lord, my colleagues have not brought that. It's a reported judgment where, my lord, similar case, my lord, temporary injunction was, lord, said to have been violated. This honorable court said, my lord, that there are provisions in the civil procedure code. If there is a violation, then you have steps to take. You cannot ask.
No, unfortunately, your client is coming up with a case contrary to an order passed by the court, which is not questioned.
No, I agree, my lord, I agree. But my lord, I am putting a question to myself, my lord, in this court.
Assuming even an inquiry is conducted.
Yes, my lord, and it is.
In the inquiry.
Yes, my lord.
You say that you are in position, they say that you have trespassed into the property after the orders are passed. Then what?
No, that finding should be there, no, my lord. I'm only saying, my lord, that even if your lordship send this back to hold an inquiry, my lord, then I am satisfied, my lord. Lord, let somebody at least say that, yes, that I have trespassed on such and such a day, my lord.
What is the inquiry contemplated?
There's under 151, there is no provision, my lord, to appoint us, my lord, provide police protection. That is what the Supreme Court also says, which is relied upon by this honorable court, my lord. Lord, if your lordship pass it over, my lord, I'll bring a printout of the judgment, my lord, of this honorable court. Yes, please.
35.
Appear for the petitioners. But suit for partition, my lords.
Yes.
one Sidde Gowda is my father.
What is IA?
Lord's application is few subject matter properties have been notified by KDB for acquisition, my lords. And KDB is about to disperse the compensation amount, even when the suit is pending. Therefore, an application was made. The amount should be deposited before the court. It shall not be dispersed.
You are the defendant in this suit.
I am the plaintiff. I am the plaintiff. I said
Now it is going to be dispersed in favor
of defendants.
Defendants or defendant?
Few of the defendants. There are so many defendants.
What is the relationship between you
First,
and?
plaintiff are the daughters of the first defendant Jayamma. The property originally belonged to one Sidde Gowda, who is my father. He got these properties from his ancestor. These are my ancestral properties. Totally, there are 7 suit schedule items. Out of these 7 suit schedule items, only 3 items are subject matter of acquisition. That is item number 2, item number 4, and item number 6. So far as item number 2, my lords, I will give up my claim. Because, my lords, earlier I had filed an identical application in favor of item number 2. The trial court rejected it on the count that this property was sold during the lifetime of my father in the year 1997 itself. Since the sale is prior to 20th December 2004, which is the cutoff date as per the section 6 of the Hindu Act, I am not entitled for any share in so far as item number 2 is concerned. Therefore, my application is not maintainable. Therefore, my lords, I do not press on item number 2. So far as item number 4 and 6, which I made for the second time, the trial court cites the reason which was given in the first time, which was only in respect of item number 2. So far as item number 4 is concerned, my lords, that still remains intact. There is no partition of item number 4 and that property has not been sold. Now my brothers are intending to take compensation in respect of item number 4. And so far as item number...
Let's see the finding.
Please, my lords. The impugned order, my lords, will get at page 22. Your lordship may kindly come to reasonings which starts from page 28. Defendants has emphasized on the order of the court on IA number 1 so and so, wherein the plaintiff had sought for temporary prohibitory injunction to restrain opponent.
Para?
I am reading internal page 8, running page 29, my lords, para 8, which starts from page 28 and then spills over to page 29. The learned counsel for the defendant has emphasized on the order of the court on IA number 1 filed under order 13 and rule 112, read with section 151 of CPC dated 18/8/2021, wherein the plaintiff had sought for temporary injunction to restrain opponent number 1 from claiming compensation from opponent number 2 towards acquisition of application schedule property. After contents, it came to be dismissed on the ground plaintiff rate is yet to be decided possible only after trial. Further made an observation that item number 2 property was sold before 2012-2004, therefore rejected the application. Alike application was filed by the plaintiff. Now, the reasoning which is applicable for item number 2, which was sold before 2012-2004, is not applicable for this item number 4 and 6 properties.
Please read further.
Application to KDB from releasing compensation amount to third defendants towards acquisition of application schedule property. It is in respect of item number 2. After contest, the said application came to be dismissed on 18/8/2020. The application was filed by plaintiff on same grounds. Now there is no change in circumstances. The present application is filed for the same relief as sought in IA number 2. Further, I am satisfied with submission of learned counsel for defendant number 0 that order passed on IA are not challenged by the plaintiff. It has attained finality. The matter is of the year 2018. As far as the order dated 9/4, it is true that 4 defendants
This is pertaining to item number
4 and 6 as well as item number 2. So far as item number 2, I will give up because it was already rejected and that has attained finality. But item number 4 and 6, my lords,
how they stand on a different footing?
Because there is no sale of item number 4 at all.
No, 1 and 2 are sold.
Item number 2, so far as item number 2, it was sold during the lifetime of my father itself in 1997. Therefore, it was sold before 20th December 2004. It stands on a different footing. So far as item number 4, it still remains. And my lords, if it is money, my lords, if it is dispersed, we cannot recover this.
When counsel for the petitioner submits the petition is filed, I number, this is I number
15.
I number 15 under section 94E, read with section 151 CPC, seeking a direction to the praying to restrain the defendant number 4 from disbursing the compensation amount to any of the defendants while directing the opponent to deposit the compensation amount before the court. That came to be dismissed by order impugned. The court, while dismissing the court has dismissed the application on the ground that earlier IA number 1 and 2 which are filed on similar grounds or dismissed, then counsel for the petitioner submits that earlier applications are dismissed as there was a sale in respect of the said properties much prior to the cutoff date in the year 2004.
Yes.
As such, the court has dismissed the application, whereas this item number
4 and 6.
4 and 6 are concerned, that reasoning will not apply, and the court has failed to consider the case of the petitioner as stated before as presented before the court, once he has come before the court. Considering the submission of the learned counsel for the petitioner, there shall be a direction to the which respondent.
KIDB, my lord, say is.
There shall be a direction.
Respondent number 6, my lord.
Respondent not to disperse the amount in respect of item number 4 of the suit scheduled property till the next date of hearing. In the same like and summons by 23rd, they shall file a memo or else a stay granted with court transfer case.
Grateful.
Bill number 36. 36.
I appear for the petitioner on this matter. This is a defendant's writ petition in a suit for declaration, injunction and possession. The IA is regarding permission to take written statement on record after a period of 7 years filed by a co-defendant. Your lordship will find the IA at Annexure D. The trial court has allowed the IA, my lords. I am aggrieved by it for the reason that the co-defendant has filed a written statement supporting the case of the plaintiff. It's a collusive written statement filed after a period of 7 years. And my lords, the suit is at the stage of evidence of the defendant, is at my evidence cross-examination. I have already cross-examined the plaintiff. Plaintiff's evidence is completed. At this stage, my lords, they file this IA.
The order.
Please, my lords, your lordships will find the impugned order at page 69. The reasoning your lordship will find at page 71.
Let's read.
My lords, at paragraph 8, my lords,
Yes.
at the foot of the page, as rightly contended by the learned counsel appearing for the defendant number 1, the present written statement sought to be, defendant number 1 is me. The present written statement sought to be filed by the defendant number 2 is on 18/8/2025. It is after nearly 7 years. It is also true that the evidence of the plaintiff is already completed and the case was in the stage of cross-examination of DW1. Under these circumstances, there is an inordinate delay in filing the written statement. But as contended by the defendant number 2, it is an admitted fact that the Department of its cooperation has disqualified the entire board of D2 society in the year 2018 and appointed a special officer to the D2 to manage the society. The other fact stated in the affidavit annexed to IA number 24 is that VV-Puram police had seized the entire record of the defendant society is also not specifically denied. It is a contention of defendant number 2 that the administrator of the society has not taken steps to file the written statement, more particularly as the entire records of the society were seized by the police. It is also not in dispute that as per the direction given by the Honorable High Court in WP number so-and-so dated so-and-so, the administrator has conducted the election to the D2 society on 4/4/2025 and 15/4/2025, and thereafter present written statement has come to be filed on 18/8/2025. The learned counsel appearing for the defendant number 1 has relied on recent amendment. My lords, that is stayed. I'm not pressing that. Then kindly see, my lords, page 74.
Yes.
Middle of the page. Admittedly, there was no executive body to manage the D2 society, even if a special officer administrator was appointed.
Defendant number 2 has executed the sale deed in favor of the plaintiff as well as defendant number 1. That is you.
There is a sale deed in my favor by defendant number 2. There is no sale deed in favor of the plaintiff.
Paragraph number 12.
My lords, those are that is why I'm disputing this order, my lords. I may be permitted to contest this
No,
order.
I have read this order. Already that paragraph 11 I have read.
My lords, they don't have a sale deed in their favor.
No, just look at paragraph 12, read paragraph 12.
It is necessary to note that initially the suit was filed only against defendant number 1. The defendant number 2 is impleaded on the contention of defendant number 1 that D2 is a proper and necessary party. It is also not in dispute that sale deeds were executed in favor of the plaintiff as well as D1. No, my lords, this is not correct.
We will see. Under these circumstances.
Under these circumstances, presence of D2 will help. My lords, it's not a, my lords, I may be permitted to submit on this order. First of all, my lords, they filed wakalat in 2018. It is not that they did not even file wakalat, they were placed ex parte. They filed wakalat. Even at the time when there was no board, the administrator has filed the wakalat. Thereafter, my lords, WS is taken as not filed. They have been contesting the matter without a WS. Thereafter, my lords, they come up with this contention of filing the written statement on 2 grounds, namely that the board was recently constituted, even though they were contesting the matter, and secondly, that the records were seized. Now, my lords, regarding records being seized, not a single document has been produced along with the written statement. Secondly, the written statement is collusive to support the plaintiff. If that was indeed their case, there was no requirement for records at all. When it was seized, whether these particular records were seized, not mentioned.
Order in the writ petition. What is this in WP number 27482?
My lords, that was a writ petition that was filed by the Sangha. This defendant number 2 is a cooperative society. They had filed a writ petition to hold elections. In that writ petition, elections were ordered to be held. Therefore, the elections were held and this new board is in existence. They're using that as a reason to justify their not filing a written statement, even though they were contesting the case for the last 7 years. Then secondly, my lords, the finding that there is a common sale deed is incorrect. They claim title under a GPA from the Sangha in favor of their vendor who has executed a sale deed. They have no direct sale deed from the Sangha in their favor. My sale deed is executed by the Sangha. So therefore, my lords, my humble submission is that it has now, your lordships are also aware that if there is a defendant who is supporting the case of the plaintiff, such a defendant should be permitted to cross-examine the plaintiff first. Only then the other defendants have to do so. There's a judgment to that effect. And my lords, it's also a rule that is recognized. They were contesting the matter. Even without WS, they could have cross-examined. That is also settled position. They don't do that. I have cross-examined. Plaintiff has given whatever admissions. Now, my lords, they are filing a collusive written statement, putting the clock back. The trial court only says that because the board was not there, they could not do so, ignoring the fact that they were on record contesting the matter. They were never placed ex parte. And they say because of administrators' alleged negligence, they should not suffer. But my lords, what about my prejudice? The trial is already at a stage where it's in my cross-examination. Tomorrow, if they filed a written statement now, they will seek to cross-examine the plaintiff. Now, my lords, I have already cross-examined her and elicited all the evidence, admissions in my favor, and they have filed a collusive written statement. If it was a written statement denying the case of the plaintiff, my lords, that would have been a different thing. Now they are supporting, even without the written statement, they can support the case of the plaintiff. But the only difficulty is now with this written statement, next they will seek to cross-examine her, but that stage is already closed. It's the stage of my evidence, my cross-examination.
I will not cross-examine.
You appear for whom?
I appear for the second defendant, Lord, first respondent, the society.
Karmikara, right?
Yes, Lord, that's a society, Lord. In 2018, an administrator has been appointed. 2025, a new body has come into force. There were elections held, a mandamus was issued by this honorable court, and new managing committee has come into force. After having looked into this, they have come and filed a written statement. Lord, it is their case. They got me impleaded. They took up a contention that without me being a party before the court, I was impleaded subsequently.
Why records are not available when the administrator is there?
Lord, administrator cannot file a written statement. He is there only to conduct an election within 6 months. He does not do it for 7 years. Under the cooperative society, administrator is only the name. He has no powers. He can't take steps on behalf of his job is to hold things as it is for within 6 months.
So to dispose of this writ petition, the presence of two is also necessary.
Plaintiff, she's not necessary because they are all colluding.
My lord, collusion, my lord, is a
If, my
question.
lords, kindly see the written
Collusion means,
statement says allow the suit.
Different aspect. That is your contention.
No,
that
no,
he
they've
is-
written decree the suit in the written statement. The prayer is kindly decree the suit. The defendant is asking for the suit to be decreed.
My lord, I can sail with the
Say
plaintiff. That does not
he is
mean
not
it
a
is
necessary
collusion.
party to this. I'll pass orders. File a memo saying that he is not a necessary party. D2 is not a necessary party to these proceedings. No notice is required to him.
My lords, then they will come and recall, my lords. They are all, let them take
No.
a stance. If your
That
lordship
is the case,
finds.
we have to issue notice.
Very well, my lords. The matter is on 16th. It's for my cross-examination now in the trial court.
He doesn't want to cross-examine.
My lords, it's
That's what
not
he's
just
saying.
about not cross-examining, my lords. It's also about the fact that the written statement has
That
been.
I'll deal with it. No, the immediate necessity to pass any order. For that, I'm saying, anyhow, you can proceed with the matter. He is not going to, he said that they will not, you said,
I will not cross-examine the plaintiff. I will not file a recalling application. My lord may take, I will not cross-examine them also. Though I am a defendant contest, I will lead my evidence at the end after they finish.
My lords,
And
them
my
leading
lord,
evidence depends on whether the written statement is on record or not.
that's what, to pass that order, number 2 has to be here. That's what I said.
Please, my lords.
The notice
So
to
then,
the-
my
notice to
lords, your
respondent
lordships
number
may then
2
record his
petition is permitted to
undertaking.
take out hand summons on the council, appearing for the respondent number 2 before the trial court. So and so your name is there in, for-
They are on
Yeshu
KV.
Mishra. Yeshu Mishra.
Yeshu Mishra, Guru Prasad, Devika.
so and so submits that he has instructions to file wakalat on behalf of respondent number 1. When can you take the notices?
My lords, I'll,
Yaro.
any day after 1 week, my lords.
The memo shall be filed before this court by 20th of July. If it is filed, list this matter on 21st July.
My lords, may I request your lordships to record his undertaking that he won't cross-examine me
My lord,
or
that is if it
plaintiff.
is being disposed of, my lord.
Very well.
If the other party is coming, then I may have a say in the matter, depending on their stance.
No urgency at 1:30.
Can I make one submission?
I'll not hear. Yes.
Dharwad bench.
Huh.
Dharwad bench matters, publish number 1. Serial number 3, Malas, I have filed my wakalatnama along with modification application. It is only with regard to liberty for me to section 14 limitation. That's all, Malas. That is the idea.
When was the Dharwad bench?
Malas, it is.
When was the Dharwad bench? When you are seeking section 14?
Malas,
When is the application?
Malas, application I filed it. It is listed today. My name was not reflected. I have filed my wakalatnama. My name is not reflected.
No, not about that. When I pass the order, when are you seeking section 14 limitation?
Malas, we have.
How can I grant?
Malas, I have filed my.
I can grant from that day. Only from that day.
From the
30
date
days,
of.
30 days from that day. After that,
Yes,
I
yes,
can't.
Malas. He has filed the essay from that date. Malas, section.
Very casually, court orders are
Malas.
taken so casually and coming up with applications like this.
Withdrawing the petition. Matters become
Malas, can it
influential.
be
Is that matter?
One matters become.
I will not hear any of the mentionings. I made it very clear in the cause list. Please don't trouble the court.
Malas, can it be passed over?
That matter pass on.
Darun.
Madam, serial number 86. Serial number 65. Judgment
Court officer? Sir? Sir?
Court officer. Court officer. Court officer.
ತರ ಅಲ್ಲ ಸರ್ ಬೇರೆ ಕೋರ್ಟಲ್ಲೆಲ್ಲ
My lord, on
Lord's kind permission.
submission, my
My
lord.
profound apologies for moving the court at this hour. My lord, this was a date given matter. My lord, if I can submit, this was a date given matter. In fact, yesterday lordships had directed the
Where
matter
were
to
you in
be
the
listed
morning?
today. My lord, lordships had directed the matter to be listed today, my lord.
Where were you in the morning?
Apologies, my lord. Morning I met with an accident, so there was some delay in reaching. If it could be taken up at least tomorrow, my lord. My lord, the proceedings arise out of an RDDB Act action, my lord. The recovery of the bank is stalled, my lord. The complete recovery of the bank is stalled by virtue of an interim order passed by this court.
Take that.
My lord, on submission, on submission, my lord.
He will answer to all that for making a mention at this hour. Your colleague will answer to this.
My lords, my apologies, my lords.
See how this is how is it possible for the court to control all this?
My profound apologies, my lords.
Call the list.
List number 1, CL number
Please.
37,
There's a pregnant lady in the house. Not selected.
Yes, call the list.
37.
Yes, I'm appearing for the petitioner, my lord.
Yes.
My lords, suit for partition. I am the plaintiff, my lords. I had filed an application for impleading a purchaser or subsequent purchaser that came to be rejected, my lords.
Come to the order.
I am number 28. Order, my lords, page number 35 is the operative portion, my lords. The reasoning. Page number 35, my lords. In between, my lords, it states, may I read, my lords?
Yes, please come to para 14
Yes, my lords.
at page 36.
Yes, my lords.
Yes. Further, about 4 lines from the top.
Yes, my lord. Further, when the plaintiff has admitted of the suit schedule of the fact that suit schedule properties are the properties acquired by the grandfather of the plaintiff, and that plaintiff and defendants and his siblings have already effected division. But this is not the case. What has happened? The plaintiff and defendants, that division did not even happen. So this is, I don't know where the learned court took this line
Please
from.
come to the IA you have filed.
Yes, my lord.
Where is the IA?
My lord, IA is the next page, my lord, page number 38. Affidavit is page number 39, my lords. Point number 3, my lords, page number 39. The TDR has been sold, my lords. Schedule C and D properties, during the pendency of the suit, it was done. The suit is of 2016, my lords.
No.
The sale.
Yes, Where from all these findings are made by the court?
I don't know, my lords. I don't know, my lords.
Plain governments only indicates the suit schedule property are the absolute and
It is-
self-acquired property
it is
of
on the application, my
great
lords.
grandfather, Mr. Channappa. Channappa,
Not-
plaintiff's
not
great grandfather Channappa.
1 minute, please wait. Yes.
He had two children by name Muniswamappa Krishnamurthy, and they divided in the year 1972. And it is the self-acquired and absolute property of his father, defendant number one, that is M. Narayanaswamy. When that being the case, the alienies, impleading of the alienies during the
Just now he read that portion at page number, internal page 36.
Further-
Page 36.
Further-
Please read.
when the plaintiff has admitted of the fact that the suit schedule properties are the properties acquired by the grandfather of the plaintiff, and that plaintiff and defendants and his siblings have already effected
Here is the
division.
plain. And come to the relief. What is that he is seeking?
Plaint is at page number 51.
Come to the reliefs that are sought. Prayer, partition, division of the suit property, and put the plaintiff in separate portion of his 1/4 share in the suit scheduled property.
Directing the defendants to pay the plaintiff his legitimate 1/4 share in the means profit in respect of the suit schedule premises.
No, if according to him is only entitled to the share of his father, I mean partition in the share of his father, why should he add all these properties and seek for partition?
That is what
To the court, already partition is effected. He is only seeking partition
In
out
his
of the
father's-
properties fell to his father's share. In that case, why all these properties are included?
that is our contention before this one.
Huh?
That is our contention.
And let's see, where did he say so? That only I am entitled for so and so in the plaint.
Para number 4 of their plaint governments, please.
Well, let's see.
The plaintiff submits that during the lifetime of Y. Muniswamappa, all the children of Y. Muniswamappa started living separately, and the family partition deed dated 9/2/1972 was acted upon by all the parties. The properties which were allotted to the share of defendant number 1 became ancestral and joint family co-partnership property in his hands, and they did not become his separate or exclusive properties. Consequently, the properties allotted to the share of defendant number 1 partook the nature of ancestral and joint family co-partnership properties in his hands, is what their contention.
Next, the plaintiff submits that.
The plaintiff submits that the plaintiff and the defendants herein continue to be the members of Hindu undivided family governed by Mitakshara law. There has not been any partition or division of the ancestral joint family properties among the plaintiff and the defendants till now.
Who are
And
the defendants? Defendant number 1 is father.
initially the suit was filed
Defendant number 2
between.
and 3 are brother and sisters, my lord.
Let's see, come to the plaint. Let's see the cause title.
Cause title, the
This is the
plaintiff is the
amended
son of
plaint,
defendant number
lords.
1. Defendant number 2 and 3 are the brothers and sisters of the plaintiff, who are none other than the children of
Initially,
defendant
it
number
was
1.
filed only against these people, my lords. Later,
Defendants
pleading
4
application came
to-
to be filed.
Defendants
and
4 to 9 were subsequently
9
impleaded in this suit, just for the reason the impartible estate, which was decided in the year 1972 and which was admittedly an impartible estate, have also been incorporated in this suit schedule property as Schedule C and D properties.
No, the parties are only D1, the father and the children
Siblings.
of D1. So he is entitled for partition of entire suit properties.
My submission, my humble
Not
submission
your
is
submission,
Schedule C and D properties, his father has only 1/10 share. But for the reasons best known to the plaintiff, they have incorporated the entire schedule in C and D property. His father has only 1/10 undivided share in that Schedule C and D property.
1/10 share.
1/10
Now
share
the properties now that are sold in favor.
have not been read as the schedule to this plaint at all. They are not the suit schedule properties.
No, forget about that. Now he wants to implead somebody. Which properties are sold to them?
It is
Schedule
the
C and D properties, my lord. Schedule C and D property. There is a
portion of
TDR, my
land
lord.
was
May I
a
submit, my
portion
lord?
of
There is a TDR, transferable development rights. So what happens when the property is acquired by the government, they give a TDR in favor of the landowners. That TDR has been sold, my lords, during the pendency of the suit. There is an interim order operating against them during that time also. A separate miscellaneous is also pending against them. Due to inadvertence, I could not implead this person. Now, as the matter was stayed by the Honorable High Court of Karnataka because of an application filed by the defendant based on res judicata, that came to be disposed just this year, my lords. An order was passed to finish the matter within 3 months of time. Because of that, that particular order, this application is being rejected. Now the TDR is sold, admitted, my lords. They don't deny that they have sold. When there's an interim order, they have sold. He will be a necessary party, my lords, to
No,
make
earlier
claims.
there was an interim order in respect of this property.
Yes, my lords. It is confirmed
Where is
also.
that order?
Was
Have you filed
interim
it?
order, my lords, it can be seen in the order sheet, my lords.
Where is it?
My lords, interim order starts at page number 118, my lords. Page number 118.
118.
It starts from page number 118. The order is at page number 120, my lords. It is passed on 15/6/2017. Then it gets confirmed, my lords. The confirmation order is at page number 125, my lords, order sheet. This order is passed on 12/12/2017.
Thereafter?
Thereafter, it continued, my lords. It was never challenged.
No, it was an order of status quo.
My lords, it was confirmed, my lords. Basically, issue temporary injunction restraining defendants and so and so.
Where is it?
Transferring
I'm looking at page 120.
125, my lords. Confirmation order is at 125. Twelve 2017, this order comes to be passed. Issue temporary injunction restraining the respondent
No,
defendant
this
number
order,
1.
would it go contrary to the earlier orders?
Well, that's
No,
what
please.
happened. The defendants appeared and
This is only against defendant number 1.
arguments
I
were
represent
addressed.
defendants 4 to
No. Temporary injunction, servants from alienating, encumbering, transferring, disposing in any manner till dispose of all the
suit schedule property. None of
Yes,
the
ma'am. All
properties
the
which
suit
are
schedule
alienated
property.
under the sale deed which has been impugned in IA number 27 and 28. Another
Please,
petition is
please
also
look at
filed
my
by the petitioner.
application, my lords. My lords, my
Those
learned friend is
properties are
confusing
not
the
the
court,
matter
my
of
lords.
suit at
I'm
all.
really sorry to say this. He is literally confusing the court because the interim order is passed in my favor. It gets confirmed. Non-alienation order is there since 2017,
Your defendant number?
2020.
Let him complete.
Your defendant number?
Yes, please. I represent defendants 4 to 8.
4 to 8, my lords.
Who are the purchasers?
No, I am the family members. I am the
He is
brothers
also
of
family member, my lords.
I am the brothers of defendant number 1.
How are you parties to this suit?
Yes, please. Honest would kindly appreciate the genealogy of these parties first to understand this. Muniswamappa had 7
I
children.
understood all those facts.
Please.
According to you and according to him, he is seeking partition of the properties which are which went to the
Allotted.
share of D1.
Yes, please. I am claiming interest in Schedule C and D property. The entire property has been made as a schedule to this suit, is what my concern is. His father, that is plaintiff's father, has only 1/10 share in that Schedule C and D property, whereas per contra, the entire schedule is
And what is
extracted here.
what is the implication of this order at page number 125?
125, it doesn't apply me at all. It is only against defendant number 1 and the suit schedule properties only. I have not sold any portion of any suit schedule property to any other alienees, pendant alike.
But to prove this only, I need this particular person as a defendant, my lords. Whatever he's saying, that it does not affect him, that they were sold when the suit is pending. After they get impleted, they sell
But
the
your
particular
injunction is
property.
against your father, not
Let it
against
be,
other
Malats.
defendants.
Yes, Malats. I will claim it in a separate manner, Malats. But this particular individual who has purchased the TDR has to be arrayed as a party, Malats. This application comes to be rejected.
Purchased
That is
from whom?
affecting my right.
Purchased from
Purchased
whom?
from everybody, Malats. All the defendants.
Including your father.
Yes, including my father, my sister, my brother, my uncles, their children,
So there
everybody
is an
apart from
injunction
me.
against Stephen from
That
alienating.
property which has been alienated is not the subject matter of the suit itself.
I think what he said was you're confusing. Both of you are confusing the court without stating the correct facts.
Please.
Malats, what has happened? May I,
If that
Malats,
is not the suit
for a
scheduled
moment?
property, why will there be an injunction?
That is a suit schedule property, Malats. That is what I told the court, that is a suit schedule property, schedule C and D. A subsequent purchaser had to be impleted. That is what my submission is, Malats. During the pendency of
TDR,
the suit,
the sale deed executed by the brothers, I will place it before your lordships. The TDR itself, let me place it.
Defendant has sold out part of the schedule C and D property to proposed defendant number 12, but registered deed of so and so. How can you
I'm
say
placing that registered instrument before your lordship now. He ought to have produced that instrument. He has not produced it. Anyhow.
Yes.
That is not a subject matter of this.
Finding of the court. Court says it is. No, in the affidavit, what he stated. Look, come to the affidavit.
At page number
Court dismissed
39.
it altogether on a different ground. Court dismissed it on altogether a different ground, and your submissions are not
Appreciating
contrary to
the,
what the court has
the
observed.
trial court appreciating the order of the judgment of the division bench of this honorable court, it has dismissed it.
What is the division bench judgment?
Division bench judgment is at page number.
Where is the appreciation of division bench judgments in the order? Please tell the court.
Please, let me.
Not that judgment in this order. Where is the reference?
The very same judgment has been appreciated by the honorable trial court in this impugned order.
it was passed on 16th, Malats, of this month. What judgment my learned friend is talking about?
There shall be stay of all further proceedings in so and so. This is matter on 30th of July.
Please.
The learned counsel for the petitioner submits that the court has dismissed an application filed under Order 1 Rule 10 to implead the purchasers without giving proper reasons. Learned counsel for the respondent submits that these are not the suit scheduled properties, but from the affidavit that is filed and the order that is passed by the court, it does not. This court is not able to appreciate the submission of the learned counsel for the respondents, and there shall be stay of all further proceedings pursuant to the order dated so and so. This is matter on 3rd of August. Notice to the other respondents.
3rd of August would delay the process, please, Your Lordship. A date may be fixed, earlier date may be fixed in this
There
matter.
are so many matters to the court to next.
Middle of this second week of, the only intention of the petitioner is to drag on the proceedings and keep the trial court proceedings in
Yes.
pending, please, Your Lordship.
Yes, 38. Issue notice. For what?
Yeah, what? 3/8/26. An earlier date may be fixed in this matter.
Yes. Yes.
An earlier date may be
Court
fixed. In this
pause. Yes, call the list.
Cell number 38. Bari Swami K, petitioner.
Request to petitioner in this case. A suit for bare injunction filed by the respondent and plaintiff before the trial. suit for bare injunction
Hmm.
filed by the respondent and plaintiff before the trial court.
Hmm.
After that, I have filed an IA under 7 Rule 11A and D of the CPC, but not disclose the cause of action and barred by law, Your Honor. Already, the plaintiff has instituted in another suit before the trial court in OS number 7740 of 2022. The suit is not maintainable. The suit is dismissed. Good evening. I have produced the order sheet of the, because of the defendant is, admittedly the defendant is possession of the scheduled property made in the awareness of the
That
plaintiff.
judgment you are producing, that is not produced by the plaintiff along with the plaintiff, isn't it?
I am for the defendant, Your Honor.
That I understand. Defendant will only file order 7 Rule 11. Come to the order. Order impugned.
Order impugned. Earlier suit I have filed an.
Earlier suit we can't see, we can't look at the documents which you have filed. We have to look at the plaintiff averments and the documents filed along with it. So what is the finding of the court? Let's see.
But
Para number 9, please read.
Page number 39.
13, page number 13, para 9, please read.
Suit for permanent injunction, the essentials of ingredients of the lawful position interference of the plaintiff contains necessary and material requirement relating to the discharge of the at this stage. The court cannot be go to correctness and the otherwise of the said requirement. Therefore, it cannot be said that the plaintiff does not disclose cause of action against the suit contention of the defendant. The plaintiff does not disclose the cause of action is not acceptable. Well, on submission, I produced in previous this instituted by the plaintiff. The plaintiff is admitted by the defendant possession. On that ground, the trial court has been earlier suit rejected. On the ground, they are filed again suit for bare injunction. My lord, I have produced an order copy of.
Please come. All those the court cannot see. Come. Agreed with the orders passed in I number 6, invoice number 4745/2024, dated 18th February 2026.
One submission, my lord, the plaintiff is admitted by the my defendant position of the plaintiff averments. The suit is bare injunction not maintainable.
The 18th
In
February.
page number 39 of the petition. Para 6, length para, my lord. 37, page number 37.
Yes.
Para 6, ninth line. Now he is not even bothered that you have illegally acquired by the plaintiff property 7 by 20 square feet. The defendant have acquired as well as he has built up the wall and attached the plaintiff property. But the previous earlier suit also is admitted by my position.
I will record all your contentions. Please don't worry about it.
On submission, Your Honor, I have purchased the property from my vendor in 2008. The constructed property I have purchased.
Yes.
From the 2008, I am in the possession of the property.
Yes.
I have produced the CL deed also. CL deed.
Yes. Anything?
No, I can consider
Yes.
my application.
The agreed with the orders passed in I number 6 invoice number 4744/2024 by the 11th Additional City Civil Session Judge Bangalore, dated 18th February 2026. The defendant is before this court. The respondent herein has filed a suit for bare injunction in that the present IA is filed seeking rejection of plaint along with the application. An affidavit is filed. In the affidavit, it is stated that stated that earlier, the plaintiff has filed a suit in the year 2022 for permanent injunction and other consequential reliefs in OS number 7740 of 2022 before the City Civil and Session Judge at Bangalore. At the time of filing of the suit, the plaintiff lodged a complaint before the Gangamagudi Police Station on 27/10/2022 in NCR number 296 of 2022. Basing on this NCR, the plaintiff has filed the suit in 2022 and the said suit is withdrawn without seeking any liberty. As such, the present suit is not maintainable. It is also stated that petition is in portion of the property, which is 7 into 20, within brackets encroached property, but but the defendant has not encroached the suit property. He is the absolute owner of the property, which he has acquired through registered sale deed dated 23/4/2008. He purchased it from one Mir Haider Ali under the registered document registered before the sub-registrar of Pina at Bangalore. As he has, as being the owner of the property, he has been in peaceful possession and enjoyment of the property. In those circumstances, question of encroachment does not arise, and the suit for injunction is not maintainable. The suit is barred by law. The suit is liable to be dismissed. Hence, the present application for rejection of plaint. The next paragraph. The court, by order impugned, has dismissed the application. The court has observed that it is well settled principle of law that while dealing with an application under Order 7 Rule 11 CPC, the court has to look only at into the amendments made in the plaint and the documents produced along with the plaint. The defense taken by the defendant or the documents relied upon by him cannot be considered at this stage. The test to be applied is whether the plaint as a whole discloses a cause of action for the relief claim. The court has observed that in the plaint, the plaintiff has claimed that he is in peaceful possession and enjoyment of the property, and the defendant is interfering with the possession. In a suit for permanent injunction, the essential ingredients are lawful possession and interference. The plaint contains necessary material. Hence, it cannot be said that the plaint does not disclose a cause of action and is not acceptable, and accordingly, the court has and further the court has also observed that with regard to the earlier suit, OS number 7740/2022, and whether the present suit is barred, that cannot be decided at the stage of Order 7 Rule 11D. In the plaint, it is stated that the earlier suit was withdrawn and the present suit is based on continuing and recurring cause of action arising out of interference with the possession. The court observed that in cases relating to injunction, every act of interference gives rise to fresh cause of action. Hence, there is a cause of action, and accordingly dismiss the suit, dismiss the IA that's filed for rejection of plaint. Then counsel appearing for the petitioner plaintiff submits that there is no cause of action for filing the suit. And further, in the light of the earlier suit being withdrawn without seeking any liberty, the petitioner is barred from filing the present suit. He has purchased the property by way of a registered seal deed, and on the strength of it, he has been in peaceful possession and enjoyment of the property, and there is no question of encroachment or interference, and the suit for injunction is not maintainable. The court has failed to consider the judgment, that is the order in the earlier suit, which is placed by the petitioner before the court along with the IA. Anything else?
No.
Along with the IA, it is submitted that the court, without considering all these aspects, had dismissed an application filed under Order 7 to 11D, and the order impugn need to be set aside. Next para, having heard the counsel for the petitioner, there is a material on record. Now the present suit is filed for injunction, wherein the plaintiff has claimed the interference by the defendant, and as such has filed the present suit. According to the plaintiff, according to the defendant, earlier suit is filed and it is withdrawn, and as such the present suit is barred. The court has rightly observed that to find out whether the present suit is barred or not, the court has to look at the other material filed by the defendant with regard to this, then that cannot be decided in an Order 7 to 11D application. All the contention that are raised by the petitioner cannot be the grounds for the court to reject the plaint, and the court, considering all these aspects, has rightly dismissed the application, and this court do not find any reasons to interfere. Accordingly dismissed.
Cell number 39. Patil Diana and Subrai Gowda.
Here for the petitioner's counsel, my lord.
Non-arraying of defendants number 2 and 5 to 15. What is this? Some notice put up.
Plaintiff party ಬೇರೆಯವರಿಗೆ
The we have made only the plaintiff as a party. No relief is claimed against the. ಮಾಡಿದ್ರೆ ಹೆಂಗ್ ಬರ್ತದೆ 711
Causes should the cause title should show that, and then the note should come,
Please,
isn't it?
we'll do it, my lord.
Yes.
Sorry, that was
Of the
even otherwise also, they may be, it's a Order 7 Rule 11 application, they may be necessarily a formal party also. We'll make that.
The office objection shall be complied with, and all the defendants shall be, all the parties to the IA shall be parties to this petition. Yes.
Please.
Cell number 40. Lakshmi Kant.
For the petition number. List number 2, serial number 29, which is also connected to this matter. Both are arising the same property.
Connect, post along with so and so. Yes.
Today it is unlisted.
Anyway, it will not reach today. So whenever that goes to that date, this matter will also go. Or if you want to independently argue this matter, you argue.
I will argue.
Huh?
Argue.
You will argue.
Please.
Yes.
But on the last occasion, your lordship has directed me to produce the list of documents. But they
Filed along with the plaint.
Please. Please, in that, my lord, may kindly see the plaint averments. The OS number 55/2003.
List of the documents, a certified copy of RTC extract, mutation register, Xerox copy of the resolution deed, the CC of the judgment and decree in OS number.
Which is required to be CC of the judgment.
Xerox copy of the committee registration.
Please.
Now please come to your affidavit in support of the IA.
Please. Affidavit, my lord, at page page 24, my lord. In the para 4, my lord, relevant portion. Para 4.
What is the suit for?
My lord, a suit for, my lord, possession of the property, my lord. The earlier
Sir, only
possession of the property. Earlier, my lord, they filed a suit in OS number 55/2003, wherein they sought for
read your. Have sought for declaration and
possession of this property. The court was pleased to declare the prayer sought for the in the suit, but the possession of the property has been dismissed. Therefore,
so declaration is granted.
Please.
And the other relief is negative.
Dismissed. Now, my lord, they sought for without challenging that decree, my lord. They have filed another suit for possession of the property. In the plaint averments also the same, my lord, they concealed the fact that insofar as the decree is concerned. Para 3 of the plaint, page 14, my lord.
Now please come to the impugned order.
Please.
The reasons at page 32, my lord. 31. I have gone through the record. When the matter is posted for amendment of the plaint, the counsel for the defendant come up with its application seeking rejection of the plaint on the ground that this court has no jurisdiction. I have gone through the plaint wherein it is stated that on 8/3/2018, the defendant refused to vacate the suit premises, so and so, so and so. The said government specifically shown the reason for filing the suit and cause of action, on which the day
Please
caused arose the suit.
When counsel for the petitioner submits that the earlier suit that is filed for recovery of possession, declaration recovery of possession was dismissed, where the court has granted the relief of declaration, but recovery, as far as recovery position is concerned, the court has dismissed the same, and that order copy, that judgment and decree is placed along with the plaint. The court has failed to consider the same, and there is no discussion with regard to that in the order impute. Considering the same, there shall be stay of all further proceedings in so and so, so and so. Notice to the respondents, and petition is permitted to take out hand summons and shall file a memo to that effect by 23rd, or else the stay granted by this court transfer. Yes.
Number 41. Neeraja Karan.
Hearing for the petitioner. So application under order 7 rule 11 Millers has been dismissed. Millers impugned annexure A Millers is the impugned order. The suit is one for partition. The petitioner is the defendant number 10. The plaintiffs are the sisters of the defendant number 10 Millers. They had filed an earlier suit Millers, which was contested and it was dismissed Millers. Now this is the second suit Millers, on the basis of which Millers this application was filed.
He said so in the plaint.
Plaint, it has been stated Millers, page number 36 Millers. It has been clearly stated that, may I read paragraph number 11 Millers of the plaint, page number 36. The plaintiffs further submits that the plaintiff's brother Munishamappa, sons N. Nanjundappa, Hanumantappa, Narayanappa, and daughter Sakama, and plaintiff number 1. Sakama is the plaintiff number 2 Millers. Plaintiff number 1 jointly filed the suit before this Honorable First Additional Senior Civil Judge at Kolar in OS number 191 of 2010 for the relief of partition and separate possession with respect to the properties herein, agricultural properties bearing number, all the survey numbers have been mentioned, Millards. In the next page
They
also,
have not mentioned about dismissal of the suit.
they have mentioned,
Where?
Millards. Page number 10, Millards, around 10th line, Millards. After the contest, the said suit is dismissed. They have
Did
stated.
you get that? After the contest.
Yes, Millards. On the basis of this statement, Millards, we had filed the application, Millards.
No, plaintiff's brother Munishappa sons.
Munishamappa sons, Millards. Munishamappa is.
This plaintiff is different.
No. She further says, Millards, she along with her brother's children, Millards, had filed this suit, earlier suit.
No. Plaintiff is Muniamma, wife of late Muni Venkata Gowda.
Please, Millards. She states, Millards, in paragraph number 11, Millards, the plaintiff further submits that plaintiff's brother Munishamappa's sons, wives N. Nanjundappa, Hanumantappa, Narayanappa, and daughter Sakama, and plaintiff number 1. Plaintiff number 1 here, that is Muniamma. And I've produced the judgment also, Millards, wherein Muniamma's name is there.
No, is it produced by them?
No, they have not produced. We have produced along with our application, Millards. But they have stated in the plaint, Millards, that they have filed the suit and it has been dismissed after contest. And then there was a proposal of settlement by from us. And we have not given any property. That is why they have filed this
Come
suit.
to the impugned order.
Please, Millards. Impugned orders, it starts at page number 16, Millards. Page number 23, Millards, are the reasons portion. Millards, paragraph number 10 and 11, it is stated about the plaint averment. Paragraph number 12, Millards, is the
finding. May read, my lords. The suit is for partition in separate possession, 1/8 share in the suit schedule properties. The case of the plaintiffs is that suit schedule properties belongs to one Ramaya, who is the Karta and manager of the Hindu undivided joint family. Plaintiffs are entitled for share in the suit schedule properties, but the defendants
We'll
refuse
see
to.
notice to the respondent. Petition is permitted to take for handsome. I'll file a memo to that effect. This is matter on 5th of August.
That sought for stay of the proceedings, my lords. In fact, the properties are not available, my lords. It has been acquired.
Let's.
Cell number 42. Kiran Joseph for petitioner.
Again, my lord, an application under order 7 rule 11 which has been dismissed. Against that, we have come before your lordships. The plaint, my lords, get that at page 218.
What is the suit for?
Suit, my lord, was for, so-called partition, saying that there was a partnership firm way back, my lord, 40 years back. My father was a partner. My lord, he died. Thereafter, my lord, there has been a reconstitution. I have a share in that. Therefore, my lord, I must get.
So now which defendant is before this court?
My lord, all the my lord, partners of the erstwhile firm. What has happened is there was, my lord,
Plaint and the cause title.
please, my lord, please come to, my lord, page 218, my lord.
Page?
218. That's the plaint. I must tell your lordships this, my lord. There was a auction in the, my lord, what happened was that dissolution, my lord, way back in 1990. In fact, I know that. I had appeared. There was, my lord, between the partners, there was, my lord, an auction. These people, my lord, purchased it. Thereafter, my lord, the father went out, taking, my lord, the money. He did not, my lord, come here at all. And the petitioner before your lordships, plaintiff, my lord, at page 218, was, my lord, a minor at that time. She became a major, my lord, another 5 years later.
I couldn't find the.
So, page 218, my lord.
218
Volume 2,
is
my lord.
not the 218.
Yes, my lord.
Eight is the order. I think this first volume ends with 217.
218 is volume 2.
Second volume, 218.
Yes.
So please tell what is the relationship between the parties?
Parties, my lord, are brother and sisters. These are the brothers. She is the
Padmini
sister of, my lord, respondents 1 to 4. 1 to 3.
One is the sister, 2 is the brother, 3.
One is, my lord, Govindra, yes, sister. 2, 3 siblings. I mean, I can use the expression, but siblings. 2, 3, 4 are siblings. That 5, my lord, is that partnership firm, my lord, which these people purchased, my lord, way back in the year 1990. Mangalore Ganesh BD Works Limited. That was, my lord, in the year 1991.
What is the 6th one? Authorized officer, hotel thing? Huh? Tenant of the property.
What happened was.
Now let us go to the application that's filed. What
Yes,
are the
ma'am.
grounds?
Before that, can I seek only one indulgence subject to my being corrected by my lords, my lord? Can I request your lordship, just look at, there was an injunction order passed by the trial court. Matter came before your lordships. Please look at page 244 for a minute. I'll tell your lordships why. Injunction order was vacated and para 13, my lord, if your lordships come to page 252, this court specifically, my lord, holds there's an inordinate, unexplained, last 3 lines, my lord. There is an inordinate, unexplained delay of 40 years in asserting the rights over the properties is fatal to the claim of the respondent. The settled delay laches, etc., etc. Injunction is, my lord, vacated by this honorable court. And there is no challenge against this order before the Supreme Court also. She accepts it. 45, my lord, 40 years later, a suit is filed saying that my father was a partnership, my lord, there was a partition, my lord, there was an auction. These people purchased it. Father went out. Therefore, my lord, there was, and she became a major 5 years later, 91, 96, 97, my lord, she became a major. 2000, my lord, if your lordship sees, 2025, the suit is filed. On the face of it, it's hopelessly barred by limitation. Trial court says it's a mixed question of law and fact. I will thereafter look into it at the time of trial. Supreme Court, my lord, any number of judgments, if it is, my lord, on the face of it, is barred by limitation.
That's why, please come to your affidavit that's filed in
Yes, my
support
lord.
of the
Please come to
IAS.
my lord, running page.
Yes.
The application file, my lords, get that. At running page, my lord. 256. 256, my lord.
Yes. Which paragraph is relevant?
Can I persuade your lordships? Just come to my lord, running page. 263, my lord, for a minute, para 6.
Now this rejection of plaint is running more than the plaint.
My lord, sometimes we, my lord, para 6 at page 263. 9 years in the year 1975.
That's when the father died.
Yes, 70, that's right. It's noted that date of birth of the plaintiff is 65 and therefore plaintiff attained majority in 1983. Assuming that the plaintiff had any right to claim intestate inheritance as class 1 legal heir of her father, she could have done it, my lord, latest by 86, that's 3 years later. And when the right to sue accrues, this is that in terms of Article 130, my lord, they've put some law also. I'm sorry, I owe an apology. Then, as such, the suit was brought, as such, no suit was brought within time. Present suit is barred by time. In the said paragraph, it's an averment that although she was entitled to join different partnership firm as one of the partners, this averment is an assertion by the plaintiff that her late father's right to the partner, as to be a partner in the partnership firm, was an inheritable right. As stated supra, such an assertion is barred under Section 5. Section 5, my lord, if your lordship sees, my lord, Article 5 of the Limitation Act. 3 years, my lord, when the right to sue accrues. So, admittedly, 19, my lord, 86, even if 3 years is taken, 1989. After, my lord, 25 years, she has filed the suit.
Now please come to the order. Order. Where is the order?
Please come to my lord. Page, my lord, 61. My lord, your lordship may, you asked the application running more than the plate, the order, my lord, runs into.
They have to extract all that is stated. I think it's
157 pages. Page 217, you'll actually get the last page. Submission of the plaintiff, submission of the defendant, submission of this, ultimately. That's right, I know. Please come to my lord, page 216. After my lord, judgments, contentions, plaint, averments, written statement, averment. 216, my lord.
what is the purpose of writing this kind of?
I don't know, my lord. My lord, I also don't know. I was flummoxed, my lord, when I saw 157 pages of and all that is said, my lord, is plaintiff said this, plaintiff has said this, defendant has said this. Plaintiff no averment, written statement averment. This averment, that averment. This judgment, that judgment.
In fact, Supreme Court has clearly said, it's over as a partnership firm. You cannot ask for partition, there's no cause of action. In fact, Supreme Court affirmed rejection of pleas on the basis. And there is no case. Because they
No,
cannot
where the discussion starts in the order.
The most,
One-
have to find at para 117, at page 187, one para.
That also one paragraph.
187, para 117 is what we could decide. Because everything is reproducing contentions of both parties.
Para 117.
Para 117, page 187. Internal page 127 of that. Internal page 120, page 187.
That also is.
Keeping the above ratio. Let's read this. 117.
Keeping the said ratio, court gone through the plaintiff arguments along with the documents produced by the plaintiff. As per the plaintiff arguments, the plaintiff and the defendants are members of a Hindu undivided family. Well, a joint family doesn't exist. I'll point out, no plea.
This on report here, there is no plea, it's stated in the order.
I'll point out if it's needed, my lord, that also I'll point out. In the order, my lord, passed, which I showed to your lords, in that 40 years delay, that also is there. Suit scheduled property belongs to the father of the plaintiff, defendants, and defendants are admitted in relationship with the defendant. They have taken specific contentions that plaintiff is not a joint and constructive possession over the suit scheduled properties. Plaintiff did not have right over the suit scheduled properties. Defendants counsel vehemently argued that in the pleading, plaintiff did not mention that she belongs to Hindu undivided family. Plaintiff has no joint constructive possession of the suit scheduled properties. In such circumstances, plaintiff has to prove her case as she's having joint possession of the suit scheduled properties. She is a member of the Hindu undivided family members as per the plaintiff averment. Pleading shall be proved with supportive and corroborative evidence in trial, and the aver of the plaintiff disclose the fact which ought to be proved by way of trial. Cause of action is a bundle of facts. Facts narrated by the plaintiff have to be proved. Further, the contention taken by the defendants about the non-pleading of HUF in the pleading. In fact, my lord, if your lordship sees, earlier he says there's a joint Hindu family. He himself admits, the judge. Further contention taken by the defendant about the non-pleading of HUF in the pleading. Verification is not proper as contemplated so and so. Failure of the fundamental plea renders a consequential relief not maintainable, cannot be accepted under the provisions of Order 7, Rule 11, CPC. As these points are not comes under the clause A to F of Rule 11. I don't know. After this, my lord, then 100 and 216 onwards. That 2 pages.
Then
16th page. After, my lord, calling out that judgment, I mean, this judgment, that judgment, all that.
166.
156.
66.
166. That's all.
If the father dies and the firm continues.
Firm, my lord, there was in fact, it's a part of the record. There was an auction, my lord, in this honorable court. Justice Thakur, as he then was, Justice Hakim and Justice Thakur. In fact, I had appeared, my lord, in that matter. There was an auction between the partners, and my lord, all these partners went out, Govindram and others. There was, my lord, the others purchased it. That is, my lord, the appellant before your lordships.
Issues are already framed. Issues are already framed.
No. Issues is not framed. I know that. Limitation is a mix. Sorry. Limitation is a mixed question of law and fact. In fact, Honorable Supreme Court has time and again held, on the face of it, my lord, if it is barred by limitation. So actually 2.5 pages of reasoning. Rest, my lord, is 157 pages are.
Para 160 is directly contrary to Supreme Court. Supreme Court says if a person
Correct.
dies, the heirs cannot sue for partition. And it has been rejected on one of the basis, 2022 Supreme Court.
Where is that affidavit? You said page number? Affidavit 118.
Yes. IA, my lord, your affidavit in IA, my lord, 256, my lord, I'm sorry.
That 263, you have said they taken this.
257, it's correct. 257, it starts, my lord.
Please come to first respondent herein. has filed a suit for partition. In that, the defendants have filed the application under Order 7 to 11 seeking rejection of the plaint. It is a case that the suit is barred by limitation. The father of the plaintiff and the defendants expired intestate in the year 1975. The date of birth of the plaintiff is 12/11/1965, and she attained majority on 12/11/1983. The suit is filed in the year 2025. As such, the suit is barred by limitation. The court, though, has passed an order running into hundreds of pages, but has concluded saying that the limitation is a mixed question of fact and law. It is submitted that on the face of the plain amendments, the amendments makes it clear that the suit is barred by limitation, and the court ought to have considered the said submissions made by the grounds taken by the defendant. Without considering the same in a hyper-technical manner, the court had dismissed the IA as it is a mixed question of fact and law. Considering the submissions, it shall be stay of all further proceedings in so and so. The petition is permitted to take out the hand summons on the appearing for the respondents before the plaintiff. Only plaintiff now. All defendants are here. Only one.
Yes.
Is the petition is permitted.
Only thing
to
is
take
that for,
The other petitions filed will be 4.
that's all.
40?
43.
Huh. Same, 42, 40, connect all these matters, 42, 43, 44. Only 42. 42, 43. For 42, 43, in both the matters, they're permitted to take out notice, they're permitted to take out hand summons on the first respondent.
Please.
Yes.
Great.
Silver.
Connect these both the matters, tag both the matters.
Yes.
Hmm.
ಮಾಡಿದ್ದಾರೆ.
No, stays
State
granted.
further proceedings.
Then number 44.
The same suit, 2 stays not required. Just tag on that along with that. And in that also notice to the first respondent alone. Yes.
My lord,
Sir, number 44. Ruparan.
my lord, in a summary suit filed by the petitioner, my lord, the defendants enter appearance, file an application seeking leave to defend, and the trial court has given them an unconditional leave to defend, my lord. Being agreed by that, the present petition is filed.
What is it? Suit for?
It's a suit for recovery of a loan amount.
When was it filed?
The suit was filed in the year 2020.
Uh,
When the defendants enter appearance,
Hmm.
they file an application seeking leave to defend.
Hmm.
In the application, my lord, they admit the receipt of the loan. They admit the receipt of the loan. Then the court hears that application, and in spite of their admission, an unconditional leave to defend is given, my lord. Being agreed by that, the present petition is.
Please come to that. Order impugned.
I appeal for the respondent. I appeal for the respondent.
Hmm.
Actually, we have defendant filed application for defending the suit. And
That's her case. She will argue. What is that you want to say?
actually, the application was allowed on 13th October 2025. We filed a written statement, and now the stage is for cross-examination of PW1, further cross-examination of PW1. Now the revision petition at this juncture is not permissible. Moreover, we have the Honorable Trial Court categorically held that there is tribal issue.
Petition. Why are you arguing? That I'm not able to understand. She has to complete her arguments. Yes.
My lord, the plaintiff has lent a loan to
So
the
what are you
defendants.
doing in an order that's passed in the month of November or October? Why are you questioning it now?
My lord, I filed it immediately, my lord, within
And not complied with the office objections till now.
No, the office objections are complied.
When it is coming up, how many times it has come up before the court?
No, my lord, it had come up in January and then notice was ordered. After that, I've moved it. All the objections are complied.
No. You have not complied with the objections till 10/6. Till 10/6 you have not complied with.
10/6, my lord. No, the
Yeah,
objections were
office
complied
objections
in.
are here.
Please, I'm not aware because January when the matter came up before the court, where
On
notice was
filing
issued.
of an so and so having served copies.
Please, no, we had to serve. I had taken permission to serve them in the trial court, my lord. They never appeared in the trial court.
No,
So
no,
then
my
no
lord.
notice was
No, my
issued
lord.
and then I've served them, my lord.
We'll hear
Oh,
it
my-
some other day. No urgency for this. This is matter in the month of August.
My lord, considering the age of the petitioner, my lord, he's 76 and he's dependent on these sums. And the summary suit, the entire purpose of filing the summary suit was that there should be speedy trial. That application.
Anyway, you are
itself-
waiting from the last 7 months. It can wait. This is matter in the month of August.
For orders matter 45, Joseph Anthony.
I appear for the respondent to
Hearing for the petitioner, my lord.
the short point before lodgement. But the order was, interim order was granted by this honorable court.
On taking of steps in respect of.
4 times notice were issued. The only one of the defendant has expired in 2017. They are taking for a dead person. And one more person who has sold the property deliberately is avoiding for more than 4 times.
Take out paper publication.
Yes,
That
my
they are
lord,
not
that's
doing
all.
it, my lord. 7
week's
years.
time may be granted.
7
We will
years.
file appropriate application.
2019 CRP.
My lord, my vacating application is pending from 1 year. 7 years interim order. They don't comply.
You that?
But suit is over there 2012, 14 years.
My lords, my only humble submission, a week's
We'll
time may
hear
be
the
granted,
matter.
my lords.
Please, my lord, only
We-
short
It's a
point.
shame that the 2019 CRP on a stay is continuing in the High Court.
Lords,
By
then the
staying
matter
in suit
kindly be
proceedings.
passed over, my lords. My senior is held up in another court, he'll come.
Ask him to come.
Please, please.
Then number 46, Sirajuddin Ahmed.
So appear for the petitioner, my lords. My lords,
What
in
is
this
this non-filing of the joint memo by both parties?
I'm for the
Lords,
urban, Your Honor.
my lords, there was a chances of settlement, my lords, but the parties had
No,
not
Your
agreed,
Honor.
my lord.
They've never approached us for any kind of talk or settlement. In
Argue the matter.
Your Honor, this matter has already been heard. In the last occasion, April 2025, this honorable court had directed both the parties to either file a joint memo or asking petitioner and the respondent one how much time they need to evict. Tenancy is proved, termination is proved. This matter has been.
Yes, what do you say?
My lords, from 75 years, I am in the
When are
possession
you,
of
when are you
something.
going to vacate the premises?
My lords, because it is a small business, my lords, I have my customers are there, my lords. I am ready to pay the amount as per the market value, my lords. I am paying the rent continuously, my lords. Except that I don't have any source of income.
They're
It is a small
depositing the rent
stationery
in
shop, my
this
lords.
honorable. They're
It is very
depositing
small
the rent
stationary
in
shop,
this.
my lords.
They're
Very small.
depositing the rent in this honorable court, Your Honor. They are already depositing the rents in this honorable court. They just last occasion, this honorable court had just asked them how much time they need to vacate this. We
Yes,
are
my
ready to
lord.
give another 3 or
It's-
6 months or so, Your
It's
Honor.
true, my lords. It's true, my lords. This honorable court has asked me when you are going to vacate. My humble submission is that it's a small stationery, my lords, stationery shop, my lords. I am paying the rent continuously without any delay, my lords. Just they are demanding excess
You
amount, my
cannot
lords.
compel him to sell the property.
No, my lords. They are not selling the property, my lords. They want to. They want to give it on for rent for
We
another
want
person's,
to,
my lords.
my lord, by humble submission, we want to use this shop for our own use. We have an adjacent shop just next to this
This
shop,
is
Your Honor.
matter on 20th of July as a first matter on the top of the list. By the time land council for the appearing for the tenant shall get specific instructions
Much obliged.
within what time they are going to vacate the premises. Yes,
Till number 40,
interim order earlier granted is extended till then.
47,
Oblige, my lords.
GK Bhavana, petitioner. Swami B for respondent.
The respondent number 6, who's passed away,
is plaintiff number 2, my lord, suit for partition and separate possession. I have to file an application seeking for bringing the LRs of respondent number 6 on record.
What is this application? Let's see whether really any notice is required. If this court is going to dismiss a writ petition, no notice is required. You can do it before the trial court. What is IA?
My lord, I order 7 rule 11 CRP. That is basically, my lord, what has happened is, my lord, one Chikke Gowda was the owner of 13 item numbers of the properties, and he got those properties by virtue of a registered partition deed dated 16/2/1960. And he died intestate.
This matter on 20, earlier matter I said 20th, no? This one on 21st, top of the list. Interim order earlier granted is extended. Is 48?
Till number 48.
Much obliged.
Till number 48.
Petitioner, no?
You are appearing.
It's not there.
Memo dated 5/4/2026 is filed seeking retirement. Advocate for respondent GS Venkat Subbarao. As other counsel has already entered appearance, the same is taken on record and is permitted to retire from the case. Yes.
This is not suit, not ex parte decree for a specific performance was allowed. Then not miscellaneous was filed, not it has been dismissed on the ground of not delay. And then not I filed a not miscellaneous appeal. That is also not dismissed. Not it is my as against that not this CRP is filed. Not the suit, no notice was served.
Let's see the order.
Yes, ma'am.
Let's see the order.
Yes, ma'am. On the page miscellaneous appeal order at page number 17, you also.
Page number 17.
17 is the miscellaneous order. Para 12 node is the relevant for that. As per the article, para 12 node, page 19. As per Article 123 of the Limitation Act, the petition to set aside the decree passed ex parte shall be filed within 30 days from the date of decree where the summons or notice was not served, not duly served when the applicant had the knowledge of the decree. The case of the appellant would fall under section or second part of the Article 123 that when the appellant had knowledge of the decree as he is claiming that the summons was not duly served upon him. So the appellant had to establish the date on which he had knowledge of ex parte.
When did you receive the notice and the execution petition?
Execution is not still pending, Lord.
When did you receive the notice?
That is not mentioned
Then
here.
how can you not say that? Without saying it, how can the delay be, from that day the delay starts?
Correct, Lord. By the execution notice, I will ascertain and make my submission next week.
20, which year is this writ petition? 24 writ petition,
Yes, ma'am.
interim order. And in 26, you will ascertain about
The
that.
interim order is only execution, Lord. It is a
That is sufficient.
specific performance of an agreement of sale executed by GPA holder.
So how long it will be pending? Now, you cannot develop the case. When you have filed an IA under section 5 of the Limitation
Yeah,
Act,
yes,
that's your duty to say, you have not said so.
I would
Then the court was right. You can't evasively say, when I have received the notice in execution, I came to know. When is the notice? When is the execution?
Yes.
Then in that case, the order was right. Why should we interfere with that?
That was not meant. I will ascertain, I will make my submission next week, Lord.
There is no submission in this. What submissions you will
Only
make
not my
on
submission
Monday?
is not to not in the ends of justice, my lord. I would have been not given an opportunity to defend
What
my
was
case.
what was that agreement?
My lord, I have filed in OS petition under specific performance suit.
due to, so they failed to register sale deed. So I have filed, the court has, sent a notice, he refused to receive the notice. And based on that, they made ex parte, the order given. And after that, he filed that,
I'm asking what is the property, suit scheduled property, what is the agreement of sale? What is the amount paid by him, paid by you?
amount be 20 lakhs something. 25 lakhs sale consideration, 25 lakhs.
How much is paid?
15 lakhs we paid.
1/5.
Yes, 1/5.
Which year?
2015, my lord.
2015.
July 7th.
Yes. From that day, you are ready to pay the interest on that, then forego the interest on that, then we'll allow this IA.
Your lordship may, reasonable cost may be imposed.
No reasonable cost for these many years of delay, 10 long years. This is matter, you get your instructions from the client. This matter on 22nd, first matter in the list.
Cell number 49.
Interim order earlier granted is extended.
Yes.
This is 49.
The 48.
For petition.
48.
49.
Please, my lords.
ಅದು CS.
It's 2 days time may be granted, my lords.
Where is this advocate, Savita?
She has not appeared, it seems, my lord. Morning, he made some.
ಲಾಯರ್ ಇಕ್ಕಿದ್ದೆ ಸ್ವಾಮಿ ನಾನು ಆ ಲಾಯರ್ ಏನು ಅನುಮತಿ ಕೊಡಿಲ್ಲ ನಾನು ಬೇರೆ
What is that she saying?
ಬೇರೆ ಲಾಯರ್ ಇಕ್ಕಿ ನಾನು ಕೇಸ್ ನಡೆಸ್ಕೊಂಡು
The party is present. It is submitted that they want to engage another advocate. This is matter after 4 weeks. Interim order earlier granted is extended.
Grateful, ma'am.
Yes,
Cell number
50.
50.
Tell her.
Where the liars engaged. Cell number 50.
Appearing for petitioner, madam. Madam,
Hruday Kumar.
in this memo has been
Memo
filed
is
for
for seeking dispensation of notice to R2 to R23.
Please, madam.
Memo is taken on record and notice to the respondents is dispensed with. Then R1 is already served.
Please, madam.
Yes, what
Please.
is the matter about?
Madam, this is a suit for partition and separate possession, madam. It has been filed in the year 2008 by the respondent number 2. The suit came to be decreed in favor of the respondent number 2 and
This is
respondent
matter
46.
on
But there
15.
is a near urgency of stay, my lord, because the evidence has been started. In second
matter.
round of FDP, my lord.
15th, list this case as a first case.
Hello.
On 15th.
Please.
Yes.
Cell number 51.
I appear for petition, my lord.
Yes.
I find memo to the effect that this petition is to be converted as writ petition on the ground that the office has raised the objection.
What is the impugned order?
Impugned order is, we filed application order 1 rule 10, my lord. Orders has been passed on IA number 3, holding that the proposed purchases of the portion of the item number 6 of the social property, they are not necessary parties, and the learned judge has dismissed the application. So therefore we are aggrieved by this order. We have preferred this revision petition.
How can there be, how the CRP is maintainable?
CRP, because it is not available order, one thing. Another thing is there is some perversity in the order.
The office has raised the issue of maintainability. that the CRP is not maintainable. Memo is filed to convert this CRP into a writ petition accordingly. Permission is accorded. The petitioner shall convert the same within 2 weeks from the date of receipt of the copy of the order. The
Much
study
obliged,
case
madam. Much obliged.
The writ petition is disposed of. Is 52?
52.
Yes.
For petitioner, Your Lordship. There's a question on maintainability, Your Lordship, wherein my this ex parte eviction order is passed 18 clause 3. I have once a judgment, Your Lordship, which says that CRP is maintainable.
Take that.
Page 11, Your Lordship. Page 11.
So here it is. You're relying on a judgment of the Bombay High Court.
Yes, Your Lordship.
Now in Karnataka, WP, CPC and CRP are two different things.
Yes.
For example, if it is in Telangana or Andhra, every CRP, every 227 or 115 is a CRP.
Yes, Your Lordship.
So that you cannot rely on that judgment.
Obliged.
The office has raised some objection with regard to maintainability, and the petition is at liberty to convert the same, to file an appropriate petition, 2 weeks time. For statistical purposes, this CRP is disposed of. Yes.
Grateful, Your Lordship.
53. Cell number 53.
For the petitioner in this case, my lords,
For the respondent.
it may be disposed of with the liberty of filing RFA in this case, my lords.
The petitioner, the office has raised objection with regard to the maintainability. Office objection with regard to the maintainability is upheld, and the petition is at liberty to file avail the appropriate remedy within a period of 2 weeks. In an earlier matter also, 2 weeks. And in this matter, all original documents to be returned. Statistical purposes is disposed of. Is 54?
54.
So,
Gangadharappa AV.
I respect for the petitioner.
Respondents.
Yes. The rectification of office objections raised on I number 1 of 25 for vacating stay.
Is filed by respondent number 8.
That's what the objection is on your I.
I am for 1 to 6.
Huh?
I am for 1 to 6.
Oh, it's filed by 7 and 8.
Please.
Office objection shall be complied with.
My lord, matter may be taken up for hearing, my lord.
Oh.
My suit has been stayed by the writ petitioner, my lord.
That you thought.
Yes. Virtually, my lord.
Thought it, you're enjoying it from 24,
Oh, my lord,
enjoy it.
my
for some more
suit has
time.
been stayed. I'm the plaintiff in that.
No, you are
airport.
happy from the last 2 years, enjoy that.
Lord, I
This is
tried
matter.
many times. I tried to.
Objection shall be complied with. First of all, why did you ask for stay of your suit? This is matter on 10th of
Application
August.
may be taken for final hearing itself.
Matter could
There
be.
is no necessity for vacating the interim order.
10th of August.
55.
The person who has filed has to say that. Is next.
55 urgent. 56. Nagaraja.
Interim order earlier granted is extended. That's 56.
56. Nagaraja.
For respondent.
Letter of for extension. Where is that? WP in WP number 7748 of 20. No, earlier, this court has disposed of the writ petition directing the trial court to dispose of the suit as expeditiously as possible, but not later than 1 year from the date of receipt of the certified copy of the order. Now the letter is addressed by the learned judge seeking 3 months further time of 3 months to dispose of the case. Looking at the reasons stated, this court is granting another 3 months from the date of receipt of the copy of the order, and no further time will be granted. It is made clear that no further time will be granted. It's 57.
57.
Much obliged.
Rakshit DJ.
Appearing for the petitioner, my lord, we have taken necessary steps to issue.
When did you take steps?
Today morning, my lords, we have taken necessary steps.
When did you, interim order is on? When? Interim order is on 25/4/2026.
Please, my
Without paying the process, you're waiting for 2 months.
No, my lords, due to oversight,
It is submitted that the needful is done.
interim order may kindly be extended.
Interim order earlier granted is extended. This is matter after service of notice. Is 58.
Sri Prakash.
That's the council on record in the connected matter may be directed to take take notice in respect of respondent number 2, my lords. Chauri HR may be directed.
I accept the notice for respondent number 2, my lord. And the same, my
In
lord.
58, Mr. Shauri HR is directed to take notice on behalf of respondent number
2.
Respondent number 2. With this, the process is complete.
Please. Yes.
Then what about 58.1? All are served.
Third.
My lord,
58.2. What about 58.2?
Appellant, my lord. The
Then
respondent
who
number
appears for the respondents here? You appear for which respondent?
First respondent, I appear for first respondent.
Your name is already there.
Yes.
What about R2?
My lord, in the connected matter 58.1.
No, Mr. S.V. Prakash is appearing for Manjunath and others.
Please, they are the respondents in connected matter.
Then R2, R4, R6, R7, you take notice. R2 to R7.
R5 also same party in the connected. matter. Respondent number 5 also same party in the connected matter.
R2 to R7. R2 to R7. It's submitted that Mr. S.V. Prakash has instructions to file wakalat.
Interim order kindly.
That suit has been stayed. It's a short date.
Interim order earlier granted is extended. List this matter on 16th as first matter.
Please.
Cell number 59. Cell number
We'll take
59,
fresh steps.
KV.
We'll take fresh steps.
Nasiman.
26, when you had the interim order?
There's no interim order.
No interim
There's
order.
no interim.
The petitioner shall take steps within a period of 2 weeks from the date of receipt of the, within a period of 2 weeks, or
Yes.
else the writ petition shall stand as first.
Cell
Yes,
number
like
60,
61.
Adjan
Great.
61. 61.
What is this report?
ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
It is already disposed on 1/7/2020.
My lords, the actual date was given some other day, but it appears, my lords, let it be, my lords.
No, anyhow, your purpose is served.
There, my lords, that is why I said, my lords, I don't want to make any accusation.
The writ petition is filed. Seeking a mandamus directing the second additional senior civil judge and CJM Mangalore to dispose of the application dated 31/10/2025 in IN number 2 filed by the plaintiff under order 39 rule 1 and 2 read to section 151 CPC. When this matter came up before the court and after hearing the learned counsel for the petitioner, this court has passed the following order on 24/6/2026. Extract this order. Pursuant to the said order, the report is placed before the court. As per the report, it is stated that the judge, in view of the several directions matters by the High Court and giving priority to the whole matters, by inadvertence, the reasons were not stated in the order. And the IN number 2 and 3 will be disposed of today within brackets 1/7/2026. 26. Next parallel counsel for the petitioner also does not dispute the fact that the IAs are disposed of. In that view of the matter, nothing survives a consultation in this writ petition. Accordingly, the writ petition is closed.
Great.
Yes.
Cell number 62.
But court commissioner warrant is
Kalyan
issued.
Basaraj.
Court commissioner warrant is issued to execute the sale deed, my lord. The
This non-compliance of office objections.
kindly go to page number one,
Counsel
small
submission.
objections, page number 20, my lord.
Counsel for the
One
petitioner
word
has
is not
complied
visible,
of
that's all.
objections. Last para of quashing order in page number 20 is
20,
not,
issue of commission warrant, one word is missing, that's all. That
is not
small.
visible. Page number 20.
20, my lord, down below. Office is directed to issue commissioner warrant. That is the order which I am challenging before this court.
What is that? The office is directed to issue?
Court commissioner warrant.
No, something should be there, otherwise.
That is the order. That,
No,
I
if it is not
understand.
visible, you have to file
Certified
something
copy
or you
itself,
file a-
certi-
the typed copy of this or something.
I
you have to
agree
file.
with you, Lordship. Now, my lord, the warrant covers the property which is stayed by
The petitioner shall comply with the office objection within 1 week. Yes.
the commission warrant, the property is covered under the commission warrant, is stayed by the division bench of the Honorable Court. Page number 103, my lord,
You are for the JDR.
JDR. I brought it to the notice of the execution
Yes,
court.
content. What is this order now?
Suit for specific performance.
On perusal of the entire objection, so and so, office is directed to issue commissioner.
Court commissioner want to execute the sale deed.
And where is that order?
Page number 103, my lord. That is schedule B, my lord. This is the decree in OS number 172 of 2008, stayed by the Honorable Court.
103. Where is the order of this court?
Order, my lord, RF order. 114 and 115, my lord. One 115.
There shall be stay of operation,
Yes, madam.
execution of the judgment and decree dated 29/8/2018, passed in voice number.
172.
Principal signature, so subject to appellant depositing the advance amount received by the defendants in the suit
That I have complied.
before this court within a period of 6 weeks from today. This shall invest the same in a fixed deposit any nationalized bank.
So this I have complied. In fact, I brought to the notice of the execution court.
How can the court be like that?
Lord, kindly see the execution petition 171. That is annexure B, my lord. Schedule B property is the subject matter of the appeal pending before the division bench of this Honorable Court.
No, now against the judgment and decree you filed an.
No, there are two decrees, 171 and 172. The schedule B property,
Come to the impugned order again.
impugned order, my lord.
No, this is execution case.
Page number 20, my lord, page number 20.
No, this is execution case number 60,
66 up to 2015, 2018.
arising out of
Arising out of OS number 171 of 2008,
171 of.
2018.
Now let's see the RA.
May I take your lordship to page number 20, my lord?
Passed in, no, this refers to 172.
My problem is 172, they have included the subject matter of the property which is pending before the division bench, which is stayed.
No.
Kindly go to page number 20, my lord.
No, one clarification. The present execution is filed
Huh.
or what you are challenging the
Yes,
impugned
madam.
order is arising out of OS 171.
Yes,
The RA order is
Yes.
in respect of OS 172.
172, where the item number, one of the item in the execution is also a subject matter in RFA.
How can it be?
And rightly or wrongly, all the parties to the proceedings have heard in not bringing it to the notice of the court while passing the decree and also during the course of the execution.
In one appeal, will the court stay the operation of the other decree which is not subject matter of the appeal?
That has been happened here because both
Then you
the,
have to see clarification from the division bench why it has happened. We can't tell that.
we have to go before the execution court only under section 47, my lord. All these issues can be adjudicated by the
No, it is not
executive
that.
court.
Where is the, now there are two decrees.
Yes, my lord.
Why will there be a overlapping of two decrees?
There was overlapping of properties included in the plaint in both the proceedings before the trial court. That is the reason why this issue has crept up. This could have been sorted out in the execution petition itself.
But I'm not convinced with
But
the
nevertheless,
submissions.
the warrant is issued. They have fixed the
But
schedule
I
date
have
for
to,
Saturday.
I have to convince myself for passing any order.
I will clarify, my lord.
Yes,
Page number 23, my lord.
yes.
Schedule B.
First of all, go to the judgment and decree. Have
That I
you
have not
filed?
produced. I have not produced.
You don't
No,
produce a
the
judgment.
decree
and
which sought to be
decree.
executed is in the execution
There
petition.
is a confusion about 171 and 170 about the judgment in the of the division bench.
Schedule, this is the execution petition which they have filed, based on which commission warrant is issued. Schedule B is survey number 113/1, page
I
7.
want to look at the judgment decrees in both the suits. That will.
I will produce it, my lord. Let them not precipitate the issue till.
No. Without a reason, without recording a reason, I will not grant any interim order in any of the cases. If you can produce it tomorrow, I can take it up tomorrow.
Can you take it up on Monday, my lord?
Yes, Monday in the first list. At the request of counsel for the petitioner.
Cell number 63. 63 CH-19 Rao.
Aviator. This is a case.
What are the non-compliance of office objections? Counsel.
Not furnished a copy of the.
Your papers are not served.
Not served. It has been served by email. It has been served. Email. Email. Or we can hand over.
Can you serve him a copy?
Given.
No.
That's all.
Please come. What are the office objections? Come to that.
There are two orders. It emanates from an execution where I consented. Please have the. In a suit for specific performance, I consented.
More than one IA is challenged in single petition.
So,
what are those IAs?
The plaintiff filed an extension application while the defendant had filed an application for rescission of the decree since deposit was not made.
Two different things. You have to file two different writ petitions.
It emanates from the same.
Which writ petition you want to you want to question in this? Restrict your prayer.
Then, because it is a common order.
One submission, my lord. We have already filed execution. Sale deed has been executed by the court commissioner. It's become infructuous now.
How can it be
Yes, food for specific performance, my lord.
Anyhow, the petitioner submits that he is restricting the prayer in this writ petition to IA number.
No, sir. IA number 8 minutes for a moment, which is pertaining to the rescission of contract.
Whatever it is, you look at it and tell.
3 minutes. Could this be posted tomorrow or day after? Tomorrow.
List is smarter tomorrow. By the time counsel for the petition serve the copy of the writ petition on the caveator. Yes, tomorrow.
64 dispose 65. Sri Ram.
The petitioner in this case, my lord, regarding the office objections, both IAs are passed in a common order, my lord.
What is order?
Order is, my lord, dismissing my IA for recalling the stage of evidence.
Office objection with regard to filing of single writ petition.
Yes, ma'am. The case is, my lord.
The silence writ petition question to IS as overruled.
Yes, ma'am. The suit is for specific performance filed by the plaintiff. The present petitioner is not a party before the specific performance in the.
No, what is that? Come again.
Suit is for specific performance, my lord.
You are the.
I am the defendant number 2 after the impleading by the filed by the present petitioner. While filing the suit and also the decreeing the suit, I am not the party to the specific performance.
When were you impleaded?
I am impleaded, my lord. The property is a joint family property. Joint family property, it's already partition suit pending between the families. Without the knowledge of the present petitioner, the joint family person is sold the property in favor of the present respond number 1. He is the plaintiff before the trial court. Specific performance, my lord. Thereafter, my lord, my partition suit is decreed. The present suit schedule property is decreed in my favor. Thereafter, my lord, I have knowledge that, my lord, this present specific performance.
The property involved in specific performance suit fell to your share.
Yes, my lord. Yes, my schedule. Thereafter, my lord, I have got to know that the present specific performance also got decreed by the trial court in the year 2010. Very same, my lord, I have challenged before this court by filing the RFA. I have RFA also I have produced before this honorable court, my lord.
The 10 decree, when did you question?
10 only, my lord. 10 only I filed RFA. And this honorable court disposed the RFA in the year 2022. 2022 by directing me as a impleaded party and conducted trial. Thereafter, my lord, I have filed.
Judgment and decree is set aside.
Yes, set aside, my lord.
Hmm.
And permit me to file a wakalat and file a return statement. I filed my wakalat and filed a detailed return statement. In the meantime, my lord, they already marked the exhibit P1 as sale deed. They already marked. I filed one IA before the trial court that stamp duty is duly not paid. The same is dismissed by the trial court.
Let's see.
Yes, my lord.
Where is the order?
Order is, my lord, page number 73, the challenge by the. But now I am not challenging that order, my lord. Recalling my stage of evidence. But merits of the case, I have to argue on that facts. Only reason is, my lord, the stamp duty is not paid. I have filed IA. My IA is also dismissed. And thereafter, my lord, I have filed one more IA under section 151 of CPC. By review the order passed by the trial court. Same is upheld by the trial court, my lord, by the latest judgment of the apex court. Kindly see the page number 93, my lord. Page number 93, my lord. It's clearly mentioned. 93, my lord, paragraph number 15. Page number 93, paragraph number 15, my lord. I may be permitted to read, my lord.
Yes.
At this juncture, it is relevant to place reliance on the judgment of the Honorable Supreme Court, 2024 INSC 493, in the case between so and so. In this decision, it was held that it is duty of the court under section 33 and 34 of the Karnataka Stamp Act to impound the instruments and collect duty and penalty if instrument is
Notice
not.
to the respondents.
Then number 66.
My lord, the grievance is, my lord, tomorrow.
What will happen?
No, my lord, the only submission is.
If it is impounded, you will not get the money.
Yes, but the thing is, my lord, tomorrow they have posted for judgments. That may be deferred, my lord. Also.
Be deferred.
Yes, my lord.
Why should it be deferred?
It's posted for judgments. And the thing is, my lord, they have challenged this order before this court. The same is pending for consideration. I have filed my.
I'll not ask them to. Yes.
My lord, the judgment may be deferred, my lord. The both petition may be tagged. My lord, they will pass the order, my lord.
Let the court pass. 2010 specific performance suit reopened in 2026. Also, it will continue. When it is posted for judgment, now it has on the ground that the document has to be impounded.
Yes, my lord.
What are you doing till now? Till 2026?
Because of he's a senior citizen. Because of ill health, my lord. With a permission.
No prejudice to him. Leave
my
it
lord,
there.
permission may be given, my lord. It may be disposed of by giving permission to lead the evidence, my lord. Tomorrow they have posted for evidence, my lord, for judgment, my lord. That is the reason. It may be deferred, my lord. A single chance may be given, my lord.
All the more reason he is senior. Let the case be concluded. Yes.
Please.
Next.
66.
Lords, appearing for the petitioner. Lord, I'm aggrieved by my lord. The office objection is with respect to multiple prayers being sought.
What are the prayers you sought?
My lord, at the outset, I'll make a submission that I will not press on prayer number A and C, my lords. I'll only be pressing on prayer number B.
How many prayers?
There are 3 prayers, my lords.
Quashing the order dated 15/11/2025. Quashing the order dated 10/3/2026, 15/6/2026. Why all orders passed in your suit or you're questioning in this writ petition?
Yes, my lords. And the execution proceedings wherein salary attachment orders have been passed. I will only press upon prayer number B, my lords. As far as A and C are concerned.
Then counsel for the petitioner's office has raised objection with regard to the multiple prayers the petitioner sought in this writ petition. It is submitted that he is restricting his prayer to only prayer B, and he'll carry out the necessary corrections. Yes.
My lord, I'm aggrieved by the salary attachment orders. My lords, under the Chit Funds Act, the deputy registrar passes an order. My lord, the respondents before the deputy registrar are all employees of this honorable court. What has happened, my lords? The respondent number 1, who is also an employee, participates in a chit auction, raises a sum of ₹9 lakhs, and the other respondents, and 2 of them are before this honorable court, are stood as sureties. My lords, they were all placed ex parte. As far as petitioner number 1 was concerned, he was not even served with a notice, even though he was a employee of this court, that is reflecting the cause title. However, my lords, a paper publication was taken in a newspaper which is not widely circulated. Thereafter, since all the respondents, even the respondent number 1 who had taken the loan amount, also stood was also placed ex parte, an order was passed wherein the liability was placed to be coextensive along with the surety. And my lords, thereafter execution proceedings came to be filed. Lord, in this execution proceedings, Lord, what has happened is the respondent number 1 who has actually taken the loan, her conduct may kindly be seen. Lord,
The person who has taken the loan and our conduct is immaterial.
Lord,
Because,
she makes
that's the reason why he wants a guarantor.
Lord, she makes a submission before the execution court that she'll only pay her share and she is not liable with respect to the share of the surety, which is not a
Whatever
legal
it is,
submission.
because
And
it's coextensive, he has every right
and
to
Lord's-
recover because you're an employee of the
Lord's-
court. It is easy to recover from you.
And after these proceedings, we came to know that a department inquiry is also initiated against her by this honorable
Or
court.
he benefited.
Lord, the modus operandi, she has been involved in multiple cases, 7 to 8
That's
cases have been
true.
involved.
But as far as the chit fund company is
Lord.
concerned, how it will come out, how all these facts will come to your
Lord,
rescue.
this would be a case of settlement. Lord, if the parties appear, it is a matter of the liabilities around 6 lakh rupees. Lord, the matter could be settled. So in that view of the matter,
How much is the amount? How much? What is the impugned order now? Attachment of the salary.
yes, my lords, 5,000 rupees has been attached. And the award amount by the deputy registrar is 6,57,588 rupees.
How many are in number?
My lord, in all 8.
Before this court, there are 2.
Only 2, my lords.
10,000 per month.
Please, my lords. Lord, there is.
And the order is passed.
Lord, the order is passed. The latest order was on 15/6/2026. This last month.
Take out notice for them. Let's see.
Lord, the next date of hearing.
Some reason to stay it, isn't it?
Lord, the liability is co-extensive. I concede to that aspect, my lords.
No, you tell me one reason. I'll record it and grant interim order.
Lord, the modus operandi of the.
That can't be a ground. Modus operandi and her conduct, they are not the grounds.
And they make a submission that she is only liable to pay her share. And she has several immovable properties in her name. And my lord.
So you cannot tell him that you realize from her properties and don't initiate any proceedings of recovery against us. You cannot, because that is what it is. That is the co-extensive liability.
Certainly, my lord.
Take out. If you want, I'll give a very short date.
Please, my lord.
Take out notice on the.
Please, my lord.
Because the matter is pending before the executing court.
Please, my lord.
The petition is permitted to take out hand summons on the counsel appearing with the respondents before the trial court and shall file a memo to that effect by.
That's by Wednesday, my lords.
By 14th.
Please.
If by 14th, if it is filed by 14th, let's just matter on 15th of July.
My lord, by 8th, my lords. Wednesday, 8th.
Yes, 8th of July. If it is filed, it's the matter on 9 July.
Much obliged.
Yes.
On IAS number 67.
Please, madam, for the petitioners, madam. But the petitioners are the plaintiffs before the honorable.
One of friends, dispensation of production of the certified copy of the
last day order sheet, I have produced the official website copy.
What is the relief you are seeking?
Relief I have sought for the quashing of the order passed by the honorable trial court. My lord, plaintiffs are the petitioners before this honorable court. My lord, this is the third round of litigation. My lord, we have filed application under order 23(1)(a) and B to withdraw the suit on the same cause of action and to file a fresh suit.
Is the suit filed?
Suit for 2012, my lord.
2012. What is the suit for?
Suit for declaration and injunction, my lord.
Why you want to withdraw?
Because, my lord, there was a formal defect.
What is that?
On 15/3/1978, my lord, the plaintiff number 1, my lord, he has purchased the suitable property in respect of item number 1.
Can't be cured.
Right, it cannot be cured by way of amendment, my lord. That is our difficulty. That is our difficulty, my lord. Way of amendment, it cannot be cured, my lord, because in the pleadings they have taken up contention that, my lord, it's a joint family property because it is in fact it is a self-accord property.
Order notice to the respondent. Right. Hand summons. This is a matter on if the hand summons or the memo is filed by 31st of July, list the matter on 3rd of August.
Right, I have sought for a stay because, my lord, day after tomorrow, my lord, they have set down the matter for dismissal of suit, my lord. Yesterday it was there, my lord, since we have requested matter is listed.
This order passed.
Lord, in the March, my lord, but we have applied the certified copy, my lord. They have given on 25/4/2026,
You
my lord.
want any short date I can give you, but I'll not stay the proceedings.
Day after tomorrow, matter is set down, my lord. In fact, my lord, it was listed.
What will happen after tomorrow?
my lord, unless, my lord, the stay is
After
granted.
tomorrow, the entire suit will not be heard and disposed of.
No, no, my lord, what the honorable trial court is insisting, unless we go, means we lead the evidence, we'll dismiss the suit for non-prosecution. That is the reason, my lord.
Then I have to hear it because I'm not convinced with the reason that you have stated. I
Because-
thought I'll give a chance so that other comes and we'll just hear it. If you want, I can, if you want an interim order, I'll hear it on merits. If I'm not convinced, then I'll be dismissing it.
Please, my lord.
Give it.
Lord,
Come to the impugned order.
please, Lakshmi, kindly come to page number 15, my lord. My lord, original, my lord, we have filed application
We'll read.
that
we'll
was
read, we'll
allowed, my lord.
understand from it.
Please.
Hmm. Read from the reasoning part.
Please. Where the page number 20, my lord, from para 11, it commences. The plaintiffs have filed in the present suit for the relief of declaration and mandatory injunction submitted that the suitable properties are the joint family properties of the plaintiff and defendant number 4, and also seeking a direction to the defendant to execute a registered partition deed in favor of the plaintiff number 1. Their case that the suitable properties were acquired during subsistence of the joint family. However, the plaintiffs have taken up the contrary stand, contending that the said properties are not the joint family properties but are the self-acquired properties of the plaintiffs and the deceased defendant number 4. According to the plaintiffs, the pleadings, relief sought and the documents produced are inconsistent with each other, and such defects cannot be cured by way of amendment of plaint. Hence, they have sought permission to withdraw the suit with the liberty to file a fresh suit on the same cause of action. In compliance with the directions of the Honorable High Court of Karnataka to point out the formal defects and list out the technical reasons for seeking withdrawal of the suit, plaintiff number 1 has filed written arguments and an additional affidavit in support of IA number 9. In the said written arguments contended that the plaintiffs have filed the suit for declaration and possession.
What property you said earlier is a joint family. Now you're saying it is a self-acquired property.
My lord, that is the formal defect, my lord. Since we have, my lord, earlier we have filed application, my lord, that was allowed. Against
Because
which,
you can't take contrary pleadings, you want to withdraw the suit.
on the same cause of action, that is the only prayer we are seeking, my lord. And earlier, my lord, our application was allowed. Against which, my lord, they preferred the CRP, my lord. CRP was allowed and remanded. Again, my lord, our application was allowed. Again, my lord, they have filed the CRP before this honor court. Last year, my lord, this coordinate bench of this honor court remanded the matter. Now, my lord, my application is rejected. Only, my lord, kindly see, my lord, the only in one sentence, the kindly come to page number 27, para 21, my lord. Only on careful perusal of the application and the affidavit filed in support thereof, it is evident that plaintiff has failed to specifically disclose any formal or technical defect in the suit. This is the only sentence, my lord, the honorable trial judge has concluded. He has not analyzed any even our affidavit and formal defects which we have mentioned along with the affidavit as well as written arguments, my lord, as per the direction of this honorable court. That is my grievance, my lord. In that one para, my lord, the reasoning, my lord, our application is dismissed. Twice our application was allowed.
Para 16.
Please. Please. The learned counsel for the defendant number 4, A to E, has filed written arguments contending that the present application is not maintainable either in law or in facts and is liable to be dismissed. It is submitted that this is the third round of litigation and the Honorable High Court of Karnataka, while remanding the matter in CRP number 217 of 15 and 295 of 21, has specifically directed the plaintiffs to furnish a list of technical defects or formal reasons for withdrawal of the suit. However, the plaintiffs have failed to comply with this direction despite giving an undertaking before the court. It is further contended that neither in the affidavit filed in support of application nor in the written arguments have plaintiffs disclosed any formal defects as required under Order 23 Rule 1 of CPC. The plaintiffs have merely reiterated the plain arguments and the contents of the affidavit without specifying any technical grounds. It is also contended that the suit is of the year.
For this,
Please,
about the order in the CRP,
order is only, it was remanded on the ground that.
that you have to list out what are the technical
Please, madam.
defects.
I will.
Where is the application?
That should be kindly take. I have a certified copy in the morning. They have ended over it.
Take that.
Please. Kindly, my lord, in the even highlight form, my lord, we have specifically stated in the affidavit as well as written arguments. But unfortunately, the honorable trial judge has not analyzed our formal defect grounds as per the direction of this honorable court, my lord. Twice our application was allowed, my lord.
Please come. When counsel for the petitioner submits that, when an application is filed, under 23-1A and B of the CPC, seeking to withdraw the suit to file a fresh suit with the same cause of action, the court has dismissed the same, stating that plaintiff has failed to establish any sufficient or cogent grounds warranting such permission, and the reasons are assigned or vague and unsupported by material particulars. Then counsel the petitioner has placed before the court the objections that are placed before the court, and it is submitted that the court has failed to consider the same. In fact, on the last two occasions, the court has considered the objections and passed the order. In fact, the application is allowed, and the matter is remanded by this court, considering the submission. There shall be stay of all further proceedings. So and so, the petition is permitted to take out hand summons and file a memo to that effect by 13th of July, or else the stay granted with this court stands vacated.
Grateful.
Call the mentioned matters. Call the mentioned matters.
Mention
Grateful.
matters. Serial number, list number 2, serial number 3.
Now, in this list, what you do?
Waiting for the petitioner, my lord.
1 minute. In this list. Let it continue. Let it continue. But in list 2, wherever partner matters are there, leave them along. Yes.
My lords, the respondent herein is the plaintiff in the.
There is a. Yes.
The respondent herein is the plaintiff in the original suit, my lords. They have filed the original suit seeking the relief to declare that the plaintiff has got easementary right in the Schedule C property, my lords. In the same, I had filed a application seeking to recall, my lords, IA 1 of 26, to recall the stage to cross-examine the PW1.
Cross-examine closed. Yes. When was the cross-examination?
It's not cross-examination, please, Lordship. I have cross-examined the PW1 and I was confronted the document. And that document was refused by the PW1. Subsequently, my evidence was commenced. I filed the application for recalling the PW1 for.
Was the evidence of PW1 concluded?
The PW1 evidence, please, Lordship, it was concluded in the month of September 2023, sorry, 24.
Present IA is filed.
Present IA filed in the month of January, please, Lordship, 2016, 26.
Come to your affidavit.
My affidavit, please, Lordship. Para 2.
Where is page number?
In page number 30, please, Lordship.
So So now that the
33.
matter is posted for arguments, you wanted it to
For
be?
matter set down for the judgment today, please, Lordship.
Hmm.
Yesterday, I requested for today the matter is set down for judgment. It is a easement right. I have confronted the photograph to the PW1, please, Lordship. In page number 34, please, Lordship.
What were you doing from September 2024 to 2026 January?
January, I have filed the writ petition, please. When the matter was rejected, immediately I filed the writ petition.
No, that is, I'm not talking about what are you doing after the case is filed. Why have you not filed the application?
My evidence was going on, Lordship. They have cross-examining my evidence. On that occasion, I have not filed.
Look at your affidavit. What is that you have stated? Please look at the
Para 2, please, in page number 34, please,
Yes.
Lordship. I further submit that the plaintiff, when my further cross-examination going on, that time he confronted and produced some document and photograph to this honorable court. On that documents marked as exhibit P series and posted for arguments. I further submit that on that document photograph.
Please come to the order now.
Please, Lordship.
Where is the order?
The order is in page number 39, please, Lordship. The 40 is the continuation of the order. It is worth to note that PW1 was completed cross-examination in the year 2017. It's a PW1 two occasion was a cross-examined the PW1 in length. Therefore, thereafter, matter was posted for defendant evidence and defendant and another witness examined to the DW1 and DW2. It is fact that during the cross-examination DW1 application, applicant certain document was confronted through witnesses and marked as exhibits. Now the defendant intended to recall the PW1 to show cross-examine him on the document admitted by the DW1 in his cross-examination, which were confronted to him during his cross-examination by the counsel for the plaintiff.
Cross-examination was done in the year 2017, not 2023 as you said.
My cross-examination I have.
PW1 cross-examination.
I'm sorry, PW1 is much earlier.
20.
On 2017 and subsequently also I have cross-examined, Your Lordship.
Read it. It is worth to note that PW1 was completely cross-examined in the year 2017.
Yes, that is mentioned.
PW1 on two occasions was exhaustively cross-examined. PW1 at length. Thereafter, matter posted for defendant's evidence and defendant and another witnesses examined as DW1 and DW2.
Please, Lordship. Admittedly, DW1 in this cross-examination has admitted those documents which are confronted to him under those circumstances when the PW1 long back cross-exam in length, merely because DW1 admitted some document which are confronted to him in his cross-examination. It is not proper to recall the PW1 for further cross-examination. No ground made out. Recall application of PW1 for further cross-examination is rejected. On that occasion, the matter was rejected by the trial court, please, Lordship. On the way.
Rightly. Please come. The presented petition is fine. Agreed with the orders passed.
One opportunity maybe, please, Lordship.
Not necessary. 2017 cross-examination is over. Now you say that you will again cross-examine him in 2026. The agreed with the orders passed on item number 1 and 2. This is 1 or 2 or both?
Both, please.
IA number 1 and 2 of 2026 and OS 26273 of 2014. By the Principal City Civil and Sessions Judge Bangalore in OS number 26273 of 2014. The petitioner is the petitioner defendant is before this court. After the matter is posted for evidence, the present IAs are filed to recall and to reopen the evidence and recall PW1 for further cross-examination that came to be dismissed by order impugned. The court, while dismissing the application, has observed that PW1 was completely cross-examined in the year 2017 itself. On 2 occasions was exhaustively cross-examined PW1 at length. Thereafter, the matter is posted for defendant's evidence and defendant and another witness examined as DW1 and DW2. Admittedly, DW1 in his cross-examination had admitted the documents which are confronted to him. when PW1 long back cross-examined in length, mainly because PW1 admitted some documents which are confronted to him in his cross-examination. It's not proper to recall PW1 for further cross-examination. No good grounds are made out to recall PW1 for further cross-examination and accordingly dismiss the application.
Imposing cost and one last opportunity may be granted, please, Lordship.
But I will not stall anything. If you want an order, then take out notice to the respondents. Once they come back, we'll whatever you are asking, then that time we can see. But I will not stall anything.
I request only 1 week may be deferred. I will take
that should be an order after hearing the other side, and in their presence only I can pass the order.
Please, Lordship.
Notice to the respondents.
My humble submission, judgment may be deferred 1 week, please, Lordship. Otherwise, today they will pass the judgment.
Dismissed.
230 mood matter. Pratik Chandramouli.
Yes.
My lords, this is a fresh filing, my lords. I'd move the matter seeking my interim prayer may be allowed, my lords. Brief of the matter is that the IA and the impugned IA, my lords, the stems out of an FDP proceedings.
Come to the order.
Yes, my lords. My lords, the order starts on page number 21, my lords. The fundamental challenge in regards to this order, my lords, is 2 points, my lords. That is, one, on page number 37, my lord, internal page number 11, it is mentioned that I am for the petitioner, my lord, respondent number 4 in the FDP. Over here, it's mentioned that, my lords, the petitioners in the FDP, along with 2 of the respondents, have filed a joint IA before this honorable trial court, stating that the price of the suit schedule property must be fixed at a sum of 3,80,000, and thereafter the court has gone on.
Number 4 or 5 before the trial court.
5, my lords. 5. They have prayed that the price of the scheduled property may be fixed at a sum of 3 crores 80 lakhs, and thereafter the court has gone on to accept their IA, stating that we have first preference, we being the petitioners, the LRs of the original respondent number 5, have first preference to pay this sum and purchase the property from the petitioners therein. Otherwise, the court will be constrained to force us to sell our share of the property, our share being 1/14. My lords, now the challenge in this matter is on one fundamental point, my lord. Previous to this IA, we had approached this honorable court via a RFA, my lords. RFA in the year 2021, my lords. Subsequent to that RFA, this honorable court was pleased to direct that public auction must be held, and everyone, all of the parties in that FDP are allowed to participate in the public auction, my lord. Pursuant to that order, the learned trial court has appointed a court commissioner, my lord. Therein, the court commissioner had valued this property at a sum of 5 crore 27 lakh 80,000 rupees, my lord. This was in the year 2021. The petitioner's prayer is to this extent, my lord. Without there being a re-evaluation, without the petitioners in the FDP producing any material on record, without the court referring to any guideline value, how could the learned trial court arbitrarily fix the amount at 3 crore 80 lakhs? That is the first point of consideration, my lord. The second point of consideration is that does the learned trial court have the power to direct me to either purchase the land or to direct that it will then forcibly vacate me from a land that I am lawfully holding a portion of and sell my lawfully held portion to the petitioners?
How do they execute the decree?
My lords,
there should be a equitable partition.
Equitable partition, correct, my lords. I bow down to the submission of this court. Our question here is, when you classify, when the value of the land is now 1.5 crores lower than the amount,
then counsel for the petitioner submits that the value of the property was fixed by the court at 3 crore 80 lakhs without any basis, and basing on the submission of the respondents, and now an order is passed directing the petitioner either to purchase the petition schedule property for a sum of rupees 3 crore 80 lakhs or the LRs of the respondent number 5 from the, what is this, or The LR of respondent number
LR,
5.
LRs of respondent number 5, my lord. The respondent number 5 has subsequently come to be deceased, my lord. So
Property
we are
for
the
the
LRs.
amount. It is submitted that the this the figure that is arrived at, that is 3,80,000, is without any basis. And from the on the earlier occasion, when the matter is pending before the RFA court,
RFA, my lord.
when the pending RFA, the amount that was what was the amount that time?
The amount fixed was 5,27,80,000 rupees.
5,27,80,000. And now after 2 years,
Yes, my lord.
this now it is fixed at 3,80 lakhs. It is submitted that there is no basis for the same. Considering the submission of the land council to the petitioner, there shall be stay of all further proceedings pursuant to the order dated so and so. Yes, next.
Serial number 2, Thakur Rishabh Raj.
It is that list. Give the list that mentioned matter.
My lords, I'm appearing for petitioner. I'm
Yes.
placing a memo. There was a stay granted by this honorable court.
That
The order of the trial court I've extracted from e-court's website. It is at ink page 4. Counsel for petitioner, plaintiff filed memo for extension of ex parte TI order. In the interest of justice, ex parte TI order is extended till next date of hearing. Counsel for defendants number 3 and 4 filed memo with online status of WP number so and so, wherein the Honorable High Court of Karnataka was pleased to stay the further proceedings of this case. Await further orders by 7/8/2026. Now there is a stay on the all further proceedings by this honorable court on 24th of June.
what was placed before the court with regard
The
to
same order was up.
It is the order sheet is placed.
Yes, same order. Same order I have downloaded from the High Court website. I had requested this court to upload the order on the same date because the next date was the trial court matter. And it is acknowledged.
This court.
There is a ex parte temporary injunction of 14th January. I pray that that may be please state specifically.
This court on 24/6/2026 has passed the following order. In the said order, this court has observed that the circular issued by the court that the court, the principal senior civil judge and JMFC Bantwal has no jurisdiction to grant injunction. It's only the designated court, district court, as a jurisdiction. It is submitted with the land counsel for the petitioner that this order dated 24/6/2026 is brought to the notice of the court on 25.
Yes, my lords.
On 25/6/2026, and the order copy is placed before the learned judge. The learned judge has passed the following order. Extract the order. Firstly, the order discloses that as per the circular issued by the High Court, the court has no jurisdiction to pass an order of injunction in matters of this nature, where the court has restrained the petitioner herein from laying the electric lines.
400 kV high transmission.
400 kV high transmission electric lines.
Yes.
When this court has specifically stayed all for, what is the interim order?
The interim order was of 14 January,
All
but
further proceedings.
all further proceedings were stayed.
All further proceedings in the suit were stayed. The learned judge has extended the interim order. Await further orders by observing that await further orders by 7/8/2026 on the face of it in clear disobedience of the orders passed by this court. An order has been, the order is passed by the learned judge. The registrar judicial is directed to call for a report from the concerned judge. it is made clear that the order of the lineage judge extending the interim injunction till 7/8/2026 is suspended until further orders.
Please, my lords.
This matter on 8th of July, by the time the
Let's-
report of the learned judge.
My lords, can I
shall be
have
on-
it on, after 10th? I am out of station on 8th, 9th.
No, you have nothing to do with this now.
Please.
On 7th, by the time the report of the learned judge shall be placed before the court. Yes.
Pass over serial number 22, list 1, serial number 22.
My lords, if I may make a small submission, my lords, in the previous matter on which my lords had provided an order, if hand delivery may be given.
Handed.
Serial number 1, good matter. List, serial number 22, list 1, serial number 22, pass over matters.
Yes, but page number 25, the court has issued a notice, my lord, does not given injunction.
Yes.
Property, kindly see page annexure C, not page 35. 2004. File.
Yes.
Page 35, my lord. Impugned order, yeah, impugned order is 25, yes, impugned order is 25. The court just issued emergent notice and refused to grant interim injunction. 35, this is my husband's property, my lord.
No, where is the impugned order?
Impugned order is at page 25.
We'll ask them to decide the matter.
Please, my lord.
We'll ask the court to decide the matter within 1 week, notwithstanding the fact that summons are served or not.
That is quite a lot.
Petition is before this court, agreed with the order.
But one
passed on-
difficulty is that these defendants they are nobody, my lord. They don't have any interest in the land.
No, that's why suit, now you filed an IA.
Yes.
Seeking interim injunction.
Yes.
Court has to pass some order or the other.
Yes,
Without
yes,
that,
yes.
it is issued suit summons.
Yes.
Now, what I'll tell the court is, you first hear this IA on the merits of it. Whether summons are served or not is immaterial.
Yes. Yes.
The petition is before this court, agreed with the order passed on. I number 1, where instead of passing an order of any order, instead of passing order on the merits, had issued suit summons to the defendants and senior counsel appearing for the petitioner submits that a coordinate bench of this court in so and so extract that order in the light of the same.
Lord, can I request status quo till then, Lord, because
No.
my
the
possession,
light.
they are trying to interfere.
Not at all. That is not the practice which you should stop now. Now granting the status quo, asking them to come here, keeping the matter 1 year pending, then sending it back, that's not in the interest of.
FIR is also registered against them. They
No,
try
that's
to
why what I
trespass.
say is, I will issue order copy tomorrow itself.
All right.
Within 1 week, I'll ask them to decide it.
Decide the
Then it's
IA.
done.
Yes.
The.
Irrespective of service, and I may be permitted to advance.
Yes. All, this is a standard order in this court.
Yes.
Accordingly, this court is passing the following order. The order dated so and so is set aside. The trial court shall decide IA number 1 on the merits of it, notwithstanding the fact that whether the notice is served on the sue summons or served on the defendant or not, and shall pass orders in accordance with law within a period of 1 week from the date of receipt of the copy of the order. Number 2, the petitioner is at liberty, so she can seek advancement of the case. Accordingly disposed of.
31.
Upload this order tomorrow. Yes, next.
For the petitioner, my lords. Lords, and the defendant before the trial court, Lord, what happens? They file a summary suit saying
This
they
is
have a
last
prima
password.
facie case.
Yes.
But the
All
plain-
this another remaining passwords tomorrow. Yes.
My lord, the plaintiff files a
This
suit.
matter also I'll take it up tomorrow.
My lord, can it be kindly listed in list 1, my lord? It's in
List 1.
list 1, my lord.
My lords,
Oh, bless
there
you.
is a Dharwad bench matter as well, my lords.
Tomorrow.
My lords, 34, my lords.
I'm not hearing anything. Please tell
My
the
lords,
court
see,
officer.
34 was passed over, my lords. I'm just handing over
Come
judgments. my lords.
tomorrow, that will come tomorrow in the first list. Pass over matters too.
79. My lords, there is one Dharwad bench matter as well, my lords.
That's what, that will also come tomorrow morning.
72,
Grateful, grateful.
tomorrow. Some difficulty, my lord.
One second.
72, there is some
had
difficulty.
moved.
Can it be called on Monday, my lords?
List number 223, last two times it's.
Anita madam.
Court officer list 2 matters ನಾಳೆ ಬರುತ್ತಾ?
Two matters, date will be assigned, ma'am.
Okay,
ಮೇಡಮ್
thank you.
ಧಾರವಾಡ ಬೆಂಚ್ ಯಾವಾಗ ಕರೀತಾರೆ?
Court officers IO extend ಆಗತ್ತಲ್ವಾ?
Hello.
So is extended.
Thank you.
ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟ್ರ್ ಯಾವಾಗ
List number
ಕರೀತಾರೆ?
2, serial number 1.
List one, all the matters, whatever there, they will be repeated in list number 1, along with the passovers. And list number 2, I will assigning the dates according to the board.
List one, no.
ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟ್ರ್
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಲ್ಲ?
List one ಅಲ್ಲಿ ಇರೋದು list 1 ಗೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ನಾಳೆಗೆ all matters.
ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚ್ ಅಲ್ಲಿ ಇರೋದು.
ಮೇಡಮ್ ಲಿಸ್ಟ್
ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚ್ ಅಲ್ಲಿ ಇರೋದು ಏನಾಗುತ್ತೆ?
ನಾಳೆದು
Madam, list number 2 ದಲ್ಲಿ interim order extend ಮಾಡಿ first matter ಗೆ please.
Madam, wherever the interim orders are still existing till today, in such matters, interim orders is extended.
Okay,
And
madam.
we will assign the dates according to the board.
ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟ್ರ್.
Dharwad bench matter you are submitted, sir. Tomorrow I will be repeating.
ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್ ಯು.
ಎಂಟನೇ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಮೇಡಮ್ ದಯವಿಟ್ಟು ಸುಮ್ಮನೆ ಇರಿ. Court officer.
Court officer? ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಸರ್ ಸ್ವಲ್ಪ VC ನಲ್ಲಿರೋರು ವೇಟ್ ಮಾಡಿ, ನಾನು ಇಲ್ಲಿರೋರ್ದೆಲ್ಲ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ನಿಮ್ಮನ್ನ ಕೇಳ್ತೀನಿ, ವೇಟ್.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ.
ಕಮರ್ಷಿಯಲ್ ಈ ತರ ಕಮರ್ಷಿಯಲ್ ಅದಕ್ಕೆ ಹಂಗೆಲ್ಲ ಮಿಸ್ಯೂಸ್ ಆಗ್ತದೆ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೌದು ಹೇಳ್ತಾರಲ್ಲ ಕಮರ್ಷಿಯಲ್ ಇದರಲ್ಲಿ
Sir, anybody in VC, sir?
Court officer,
List number 2.
list to serial number 7.
ಇದು ID
Two
number
serial number 7 is on 6/7 Monday, sir.
Monday na?
Serial number 11, list number 2, madam.
List number 2, serial number 11 is on 28/11.
ಮೇಡಮ್
28/7.
8-9 ಮೇಡಮ್ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದೆ, ಅದು ಇದು ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ನ ವೈಲೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಯಾವುದು serial number 11 ಆ?
ಅರುಣ್ ಗೋವಿಂದರಾಜ್ ಮೇ ಬಿ ಆಯ್ತು 8 ಮೇಡಮ್ 8ನೇ ತಾರೀಕು.
8ನೇ ತಾರೀಕಿಗೆ ಅಂತೆ ಕೊಡಪ್ಪ. ಆಯ್ತು.
Please.
serial number 11 ಒಂದು ಚೇಂಜ್ ಮಾಡ್ಕೊ. 8/11 ಏನೋ ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ವೈಲೇಷನ್ ಆಗಿದೆ ಅಂತ. serial number 11 8/7 ಗೆ. 8/7
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.